Yes, Your Honor, and I believe we should start with.
Do you have a transcript of that particular hearing?
We do.
May I?
At the carpet.
May I have it? Can I use it?
You can use it.
I'll give it back. I mean, I don't want it for
No, we'll get
for any other purpose.
Yes, Your Honor. We'll get you a copy of it.
Okay. All right.
Your Honor, I believe that it's probably best we start with the redaction that Mr. Shard has, given he wants these things redacted and those items are in dispute. And those would be the 10 timestamps that you received this morning via email from Mr. Shard.
Are there any sections that, since it's your video, basically, or you're seeking to admit the video, do you have any sections that you all have decided you're going to not play or not in contention? Have you vetted any of those with the defendants?
We have not. The defendants, and I don't know if Mr. Shard was getting ready to do that, based on what we submitted to them, we do not know if there's any parts that they agree with or not. We know that everything that Mr. Shard has sent us, in dispute with us.
All right. Okay.
And so,
all right. So I'll just take by the numbers, and then we'll move on to any other persons that wish to be heard about. So what are you marking that February 21st interview as?
This is going to be 378 Yankee Delta.
Okay.
If you give me a course indulgence, at least until we get the hard copy, I'll forward you a copy.
All right. Has that already been sent to all defense counsel as well?
Yes, Your Honor.
Okay. All right.
Yes, sir.
Are you going to play you have it queued up?
Yes.
Okay, awesome.
No, sure, you're fine. You're fine.
What's your intention? To go through mine first, or?
Yeah, but I want them to at least cue it up. So why? Okay, we'll take the first one. I believe that's at 3:59:50 to 4:00:20, and it apparently.
The first three, Your Honor, are all statements made by investigators. I believe they're all by investigator Gaither.
All right, let me just kind of flesh out as well, just for purpose of record in our discussion. Number 2 is 4:08:40 to 4:09:40, and number 3 is 4:10:55 to 4:11:05.
Right.
And the first one, you've indicated that Gaither gives a speech about the need for people to step up and cooperate. Number 2, Gaither gives a speech about the work they have done. And number 3, Gaither gives a speech about doing this to protect Casey's baby girl.
Right. And obviously speech is my commentary, but it's essentially the narratives given by detectives throughout the interview, which are basically giving argument and kind of parroting the state's argument throughout this case, which I think is improper and unnecessary and fails 403 because there's no probative value to investigator Gaither pontificating about the need to protect the community and the need for witnesses to come forward and her quest to protect Mr. Copeland's child and things of that nature. So, I mean, they speak for themselves. So, Your Honor will hear, and then I guess we can argue about it.
Okay, all right.
And Your Honor, the emails are sent to you, and I'll queue them up. for reference on the transcript, this would be page 13, line 19 through page 14, line 3. And we'll start a little before context. We'll start at 3:59:35.
Probably have another one. This shit, man. All this because I ain't did. I haven't done nothing. I haven't did none of these niggas, man. But what you not understanding is frustrated, man. I did nothing. What you not understanding is you have it in your mind. We can't do nothing about that if you're not speaking on it. We don't know what's in your mind and what you know. And that's what's making it even more fucked up because you holding on. And everybody else just running rampant. I'm going to jail for, I'm taking the blame for everything. I'm going to jail for probation, parole, whatever you want. That's what you in jail for. If there was some other charges on you, they'd be there. And you would see it. They got me in jail for probation until they find out if I shot one boy.
And we ended at 4:25. We ended that play at 4:25.
Okay. All right. Why does the state believe that that's admissible?
Yes, Your Honor. Mr. Copeland testified that Detective Gaither, during the course of any of these interviews, were forcing him to name a suspect. What she's doing here, for context, this interview is the day after Mr. Copeland, his child, and his child's mother has been shot at. And if you can recall, in the February 20th interview when he was with Detective Curry, which has been played before the jury, Detective Curry attempted to get Mr. Copeland to tell him who did it. He did not. If you can recall, he would not say who did it. Detective Curry went into a conversation with him saying, I know you know, I could tell by your body language that you know. Then when he was by himself with Deshawn, his girlfriend, he told his girlfriend, I know who killed me. I know, I'm not killed me. I know who shot at me. This is the next day in which they knew that he had a relationship with Gaither. If you can recall, in that February 20th interview, they kept telling him, you need to talk to Gaither. You need to call Gaither. And now Gaither is trying to get him to come forward with whomever he saw in the day that he was shot at. And so what Gaither is doing during this portion is telling him, I can't stop them from shooting at you. I can't stop them from doing anything if you don't tell me what happened. And majority of this interview is her trying to encourage him to tell what he knows. And that is, again, in contradiction to what Mr. Copeland has said on the stand, that one, that they were forcing him. They were not. And you can see throughout the conversations here, they're never forcing him to do anything. Two, Mr. Copeland eventually says that I wasn't, that Tay never killed me. I think he said, I swear on my child's grave or my mom's grave that Tay never did it. And this whole entire interview is them talking to him about what has been happening, the shootings, the retaliatory shootings, and encouraging him to tell them who he knew shot at him, his child, and his child's mother. So I think this is relevant, one, to contradict Mr. Copeland's in-court testimony that they were forcing him to do anything. Two, to show how the police were attempting to get him to give information, which was in a calm fashion, which was in a fashion to get him comfortable enough to be ready and prepared to make an identification. And so we believe it's relevant to show the jury they weren't forcing him to do anything.
Mr. Short?
Well, I think if you look at that exchange in isolation, it is a narrative by the detective. It's not prior inconsistent statements by Mr. Copeland, but you might say it's not that egregious, or, you know, what's the big deal? I think as we go on and we discuss the next two excerpts, it kind of builds upon itself in forming this narrative of people are not coming forward. Our job is so difficult. We got to do this to protect the community. We got to do this to protect children. And that's my concern, is pushing that narrative through Gaither's words during these interviews are admitted for the express purpose of Mr. Copeland's prior inconsistent statements.
Let me make a suggestion. Why don't I just listen to the three together, and then we can have another discussion, okay?
Great.
All right. Let's play 40840 to 409, or actually 40840 through 41105.
Sorry, 40836.
And even if I did see something on Twitter, I can use what Twitter says. You the victim here. That's what you're so used to being in fucked up situations, you don't realize you a true damn victim. When the police came to my house, I wasn't no jet. I was a suspect. I can't vouch for what nobody else did. That's my case. That's my case. If you was a suspect, you would have got locked up that night. That night. You admitted to shooting back, you would have got locked up that night. Am I correct? Okay, so I'm asking you, who the fuck shot at you? Either you gonna tell me or you not, or you just gonna stay in this predicament that you in. But you're not helping yourself. If you going to the streets trying to kill you. I ain't even going to the street. If you want, you would have been told the first time. The first time you would have told me. It ain't just about you and your life, because your baby was out. It was just the first time. You think I was joking with you? What you tell me the first time? What I tell you? You don't even forgot what I told you the first time? The first time that I talked to you a few weeks ago about the incident on the highway, you didn't tell me when it was time to tell me. You didn't tell me. Us talking off the record, it's like it never happened. It's like it never happened, and I can't work like that. You expect me to help people? Look at what happened to me. I'm expecting you to help you. I'm getting shot at and locked up. It's like I'm talking to a brick wall, Louis. First, I try my best not to cry. It's all right to cry. I cried the same night they came. I did. I let it out. But I express every day. You know what? I just shot my car. You know what I was doing? Well, I was still out. I ran 4-wheelers everywhere. I know. I heard. I wasn't riding all right. You know what I'm saying? Because I know everybody wasn't out to get me. I'm not saying everybody out to get you, but the folks that are out to get you, obviously they coming for you. And me as a police officer, if you don't give two shits about your life, I care about your baby life. I care about her life. She can't get my life and my girl's life. Exactly. So help me do this shit. They unprotected now. They out there by themselves. But you not telling me nothing, cause I'm in jail. You right here right now. They out there by themselves, and the folks that shot at y'all.
It ended a little bit later at 41117.
All right.
Hey, Ron, I have a physical copy of it.
Thank you.
It will be 378 Yankee Bravo 2.
Thank you. right, sir. Sure.
So, Your Honor, my objection to what the playing of what Investigator Gaither says is that Investigator Gaither, again, not the intended declarant of these statements, these out-of-court statements, is essentially making an argument that the jury will hear that it's a future dangerousness argument. It's an argument that, you're either on the side of the quote-unquote gangsters or you're on the side of the people that are trying to protect children. It presents a false dichotomy, and also it invites the jurors to consider subjects and consider things that are not supposed to be in their purview as the finder of fact. Well, future dangerousness, protecting the community.
Okay, tell me where in this particular, from 359.50 to 411.05 that you want me to invite me to look at for future dangerousness.
I believe it is around 410.55 where essentially Investigator Gaither is saying to Mr. Copeland,
okay,
you're not cooperating.
Hold on one
if
second.
you don't,
you said 410.55?
I believe it's
Hey, can you give me the page references for that, please?
I don't believe that he's saying that. I don't know what he's saying.
And essentially,
No, around 410. I need to know the
What page 410?
Yes, ma'am.
That will be around page 28.
All right.
and I don't have the transcript in front of me, the state's transcript, but what the part that I'm referring to is where she says, Woody, you're not talking, you're not cooperating, you might not care about your little girl, but I do. I'm going to protect your little girl. And I think that's improper. It puts it improperly presents this dichotomy where the police are the good guys and the protectors of children away from, the bad guys who are out warring in the streets. And I just believe that that's an improper statement. A, it's not true, but B, it's an improper statement that invites the jurors to consider things other than the evidence in this case.
Okay, you saying that, okay, I'm looking at page 28, line 10 or thereabouts, Detective Gaither. I'm not saying everybody out to get you, but the folks that are out to get you, obviously they're coming for you. And me as a police officer, I don't give two shits about your life, but I care about your baby's life.
Right.
Copeland, I care about her life. Detective Gaither, she can't get Copeland and my life and my girl life, Gaither, exactly. So help me do this shit. And then Copeland, they out now. They out there by self. But they self. But then you're not telling me nothing. That's Gaither.
Right.
And he says, because I'm in jail. And then she goes on to say, you hear right now, and this is page 29, starting page 29, they out there by themselves, and the folks that shot at y'all are probably still out there as well,
In my most strenuous objection is just about the comments about protecting his daughter. I don't think that's appropriate.
All right, any other portions that you want to point? Are you saying that the entirety of it, or are you just saying that particular section?
Right, that particular section about the child, and I think that fails under 403. Not probative. Again, it's the investigator talking, so she doesn't have any personal knowledge of the facts of this case. It's not really the witness presenting evidence, and again, I think it's confuses the issue, and it's likely to inflame the passions of the jurors, and it's prejudicial to our clients.
Well, if there was some testimony that Mr. Copeland was in a vehicle with his significant other and his baby,
Outside of his house.
and they were shot at.
Yes, this is
They were shot at.
Exactly.
So I'm sorry.
This interview, just for context, is 2 days after that
Yes.
event.
So, I mean, it's not. I mean, she's got some basis to ask him those particular ask him or appeal to him in terms of what he, what's going on in his life and her investigation. Like, don't you want to get at the folks that, or at least tell who it is that shot at you?
Well, let me.
Because she's investigating.
I'm not
correct?
criticizing her questioning of Mr. Copeland. Of course, yeah, she has the right in the interrogation room to appeal to whatever she wants. I'm just saying not every, even if it's quite honestly, even if it's decent interrogation techniques, doesn't necessarily mean the words of the officer are exposed to the jury. And that's my issue. I'm not saying that she broke any rules in the interrogation. I'm just saying that those appeals are not necessarily appropriate to expose to the jury.
Can I respond?
Okay, tell me again how it's future dangerousness.
Well, it's an improper appeal to protect the community. It's creating the impression in the juror's mind that the police are out here protecting children, and that these gentlemen, in this back and forth between Mr. Copeland and other individuals, and the state would say individuals seated back here, and this other group are putting these children at risk. And what I'm saying is, if Investigator Gaither was on the stand and said, you know what really bothers me about these things that I've been investigating all these years, it's that these bullets come out of these guns and they're coming at children's heads. We would all jump up and say, objection, objection, that's improper. What is she saying on the stand? So I don't know why it's allowed in just because it's on a tape as an out-of-court statement. It's still making the same appeal.
I don't think she's making a general. I don't think she being Gaither. I don't think she's making an individual appeal for protection of the community. I think she's making an individual appeal to him because he's the victim of a crime, a purported crime at that point in time. So, but I've heard your argument. I haven't made a decision as of yet. State?
Yes, Your Honor. So I want to address a few things. First, this future dangerousness argument is not a proper argument for what occurred in the interview room. Future dangerousness solely talks about an open and closing argument referencing to the jury that if you don't find these defendants guilty, then this will occur in the future. That is what future dangerousness references. It has no bearing on an investigator who's trying to investigate a crime appealing to the victim as to why he should come forward with who harmed him. That is what Detective Gaither was trying to do. Secondly, Your Honor, the defense early in our trial made a number of cross-examination efforts to talk about police officers and the fact that they only target a community, that they only arrest certain types of individuals. And what this video shows, most importantly, is that she was trying to get Mr. Copeland to identify who did this. But secondly, that the police aren't just trying to arrest people. They are not just trying to get individuals charged with crimes, but yet they are trying to investigate crimes, hold individuals accountable, and make sure that those who are victims are no longer victims. And so what Detective Gaither is doing in this portion is trying her best to appeal to Mr. Copeland, who has some concern about giving up an individual, who is concerned about snitching. And that's what you're going to see later on in this interview. And she's trying to get him to identify who did this to her, who did this to him and his child's mother, Your Honor. And so given one, Copeland himself on the stand says, in all these interviews, they were just out to get me. They were out to get Thug. They were out to get me. This is a complete contradiction to that, because Gaither isn't trying to get him. Gaither isn't trying to just get Thug in this interview. Literally, she's trying to identify who shot him. So one, it's impeachment by contradiction to show Gaither's, how Gaither was interacting with him. Two, she was trying to get Mr. Copeland to identify who the person was that he saw shoot at him. She can use certain investigative tools and tactics. Mr. Steele said yesterday, all day long, I want to show that this is how they investigated cases. Well, this is a part of that. This line of questioning is how they investigated cases. And when Mr. Steele says, well, I want to show these bad portions of it, then this is in contradiction to that. This is her using her investigative tools in order to get a victim to come forward. So for that reason, it should come in. And then this future dangerousness argument is not relevant for what occurred in this courtroom. So for those reasons, Your Honor, we would ask to play these portions of the recording.
All right. Anybody else other than Mr. Sharp wish to be heard on this, on the first three redactions? 35950, 40020, or 40840 to 40940, or 41055 to 41105. Anyone else? Mr. Weinstein? Mr. Matthews? Ms. D. Williams? Mr. Harvey? And a 105 instruction. Okay. Denied. But I've noted it, sir. I'll give you a continuing objection on that issue, okay? All right, Mr. Steele?
No, I'll adopt what was said.
All right, sir. Okay. For the reasons articulated by the state in terms of identification or impeachment by contradiction, I don't believe that future dangerousness applies for this particular portion of the transcript. I'm going to authorize or allow the state to play those particular portions over objection. I'll give you all continuing objection as to that. All right, can we move on to 41130 to 41235?
Yes, Your Honor, I'll just keep on playing from where it stops.
All right.
And Your Honor, for reference, that's page
Yes.
29, line 9, through page 48, line 11.
What will that take us through?
That's going to take us through 41235.
Oh, okay. That's the fourth area of contention. 41130 through 41235.
Yes.
Okay. All right. You can go ahead and play it, please.
Still out there as well. Probably still out there as well. Still. Oh shit, man. I try my best, man. Cause if I help you, if I tell you anything, guess what? They make it even worse. What make it worse? Everybody, oh now snitch, now this and that and that. Bro, how you a snitch for somebody trying to kill you, the girl, and your baby? How is that snitching? I just want to get out of jail and go to my next job. Just stay out the way, man. But do you honestly think somebody else that quote unquote the good guy gonna want to help you? If you ain't telling us like you talk about snitching and all this, it ain't about that. But as long as you out there being a part of the problem, we're gonna let you be a part of the problem. I haven't been a part of the problem. Actually, you are. You're not trying to resolve the problem at hand. And I told you the only way for you to start resolving, to get this shit started and resolving it, is you gotta talk to us straight up. That's it. You gotta talk to us straight up. Because if you're not, it's just gonna continue and continue and continue. And I hate to see you or anybody else come up dead behind some foolishness because everybody want to be loyal to the streets and everything. Trump said, care.
In that warrants law 36.
Okay. Mr. Sharp?
So, my issue with this, and again, it's going to be under 403. My issue is this: the state is clearly making the argument and trying to appeal to the jurors through their questioning, and I'm sure they're going to make arguments in closing. They made arguments in opening that witnesses are reluctant, that Mr. Copeland's reluctant. They're pointing out that Mr. Copeland says certain things when Jeffrey Williams is in the room versus not in the room. And the reality is, despite insinuations at times by the state outside the presence of the jury, that were unfortunate accusations, I think, there's been no evidence that Mr. Copeland fears anyone seated here. There's been no evidence of any threats made by anyone seated in this courtroom towards Mr. Copeland, or at least on the defense side. So here, Mr. Copeland is clearly expressing fear of being a snitch, being labeled a snitch, the ramifications of telling. But what's important here, and I'm afraid of what might get lost, is Mr. Copeland is expressing fear of an entirely different group of people than the accused here today. He's expressing fear of the group of people that are shooting at him actively at the time of this interview, which I think the state has alleged are IF gang members. I believe that certain individuals that are not associated with any of the defendants here today were arrested and charged with that crime. So it's misleading the jury, it's confusing the issues, because I think Mr. Copeland is expressing a reluctance to cooperate out of fear being labeled a snitch, but it's not. It invites the jury to conclude that he's afraid of these gentlemen, and that's not what he's saying. And yes, I understand that we have the ability to cross-examine and those issues, but Your Honor, I just ask for you to consider the logistics of this case. The fact that the state is talking about playing, like, I don't know if we add them up, 17 hours of videos or however long of Mr. Copeland. There's it's not a typical trial where we get to just follow up with cross and clear up issues. There might be a week between when this is played and when we have the opportunity to cross-examine him about these issues and clarify some things and clear them up. And it's kind of like it's just not a smooth process. And I think that we need to do our best to eliminate any of the misleading or confusing issues from this tape, including this segment right here, which under 403, I believe that it should be excluded.
Okay. State?
Thank you, Your Honor. I think Mr. Shard is trying to compartmentalize issues, and we have to look at this case in the totality of all of the circumstances. So first things first, specifically, when I asked Mr. Copeland on the stand about Tay and about whether or not he saw Tay shooting, he said, again on the stand, he didn't do it. I swear to God, he didn't do it, or whatever his frame. I'm not quoting that as a direct quote. But also, he talked about not being afraid of snitching. He talked about the fact that whatever he said in these interviews, he was just saying it just to say it. I asked him, was he concerned about snitching, being labeled a snitch? And he said, I was not. So this is impeachment by contradiction and prior inconsistent statements, both. Because I, on direct examination, asked him, was he concerned about snitching? He said, no, I wasn't concerned about snitching. They were forcing me to point out Tay. They were forcing me to do it. Gaither forced me to point out Tay. This is in complete contradiction. He literally talks about why he cannot identify Tay because he's going to be labeled a snitch. I believe this is the interview. Later on, he talks about the fact that his cousin was labeled a snitch and what happened to his cousin. So this is one in direct contradiction to that specific line of questioning. But also, Your Honor, snitching is relevant in this trial in the totality of the circumstances. Mr. Copeland literally last week or 2 weeks ago decided initially that he was going to plead the fifth in order not to testify in trial. To testify into trial is snitching. He has now, as a course of his conduct in the last few weeks when he has testified, is now completely contradicting everything he told police when these individuals were not in the interview room. Again, that is snitching. And here is a reason he is explaining in 2015 why snitching is a problem. So when you look at it for both the specific impeachment of my line of questioning about this interview, but then the larger conspiracy, in this case, people do not want to come in here and testify. Mr. Copeland is not the first witness. We've had Ms. Archillian Bennett, who testified that what she never talked to the police or what she told the police was a lie. But then when you come into court and have to face the individuals that you were accusing, have a different story. Same thing with Adrian Bean. Adrian Bean had a whole interview with Detective Quinn, identify Mr. Williams, identify other individuals who participated in a crime with him. But when he came into court, did not testify. So therefore, snitching is an issue in this trial. Mr. Copeland is talking about his reasons for not wanting to snitch, which is very relevant in the totality of this case. So for multiple reasons, we believe that this portion should be allowed to be played.
All right. Any other counsels wish to be heard on this particular issue from 4:11:30 to 4:12:35? Mr. Weinstein?
No, Your Honor.
Mr. Matthews?
No, Your Honor.
Ms. D. Williams? Mr. Harvey?
Judge, it can't be impeachment because it was made at a time when the witness had a motivation to lie. It was even after this particular event occurred. So it can't be admitted for that purpose.
All right, okay. All right, sir. Mr. Steele?
Just as the court goes through your ruling, the state's information for what they just said about people come in and then face Mr. Williams et al. And then are reluctant is not what I understand. I understand Ms. Bennett was upset because the district attorney's coworker was inappropriately communicating with her. I understand that Mr. Bean told another detective at the hospital when he was first arrested that he did not have information. He was told if you include Mr. Williams, then you can get out. It'll be better for you. With Mr. Copeland, who's testifying, he has stated that he's been pressured by the prosecution. So this whole creation of pressure is a theory of the district attorney without zero proof. So I don't believe that should weigh into your analysis at all. I also agree with Mr. Harvey that once the reason for the fabrication or the improper influence is birthed, then under Tome, which is T-O-M-E, United States Supreme Court case, and in Georgia, Adams, A-D-A-M-S. It's also in the statute, which is OCGA section 24-6-613, because the motivation of Mr. Copeland is clear. He's in custody. He wants to get out of custody, and he's making statements. These are not prior consistent statements at all. The state is saying it's prior inconsistent statements. Sometimes they are, but sometimes they're really prior consistent statements that they wish to get in, because Mr. Copeland really is not inconsistent. He said, yes, I probably said these things, but I said them because I was motivated to get out of jail. So the state is relying on inconsistency. I believe that they're really relying on consistency, and I join Mr. Harvey about it's not proper for a prior consistent statement.
All right, sir. Okay. In considering 411:30 or thereabouts to 412:35, the court is in agreement. At least it's a impeachment by contradiction for the reasons that the state's proffered. Whether or not the issue of snitching is relevant before the jury, and whether or not that is an issue that several witnesses have testified to, would be relevant. So, but the court's primary ruling is based upon impeachment by contradiction. So that will be authorized to be inquired into. All right. Let's turn now to 425 to 425:33. Casey talking about Shannon beefing with IG people. You can flesh it out, sir.
So just a little context, Your Honor. This is after. Obviously, you know, this is after the episode of Mr. Copeland being shot at outside his house. It's also after a January 28th episode where we've heard testimony of Mr. Copeland, Demekion Garlington, and Mr. Stillwell were all in a car together, and that car was shot at, and the car stopped working, if you recall that testimony, Your Honor. So there's two different shooting situations involving Mr. Copeland, one where Mr. Stillwell was also apparently or allegedly in the car, and Mr. Copeland is, I believe, making reference to Mr. Stillwell having issues with some of Mr. Copeland's enemies on Instagram. My objection to this is that this is based, Mr. Copeland's in jail, and it's unclear how he's aware of this, but apparently he's been told about Mr. Stillwell having back and forth with these individuals. From my recollection, you know, I've been through all the discovery numerous times. I don't recall in discovery seeing any of this alleged back and forth during this time frame involving my client on Instagram. So I haven't seen any documentary proof of any of this, but so I don't know exactly what Mr. Copeland is referring to, but from my understanding of the context of the statement, Mr. Copeland is merely passing on hearsay information about what Shannon is doing on Instagram.
Okay.
Mr. Copeland does not have access to Instagram, obviously, as he's making these statements.
All right, can I hear it? And what transcript page is this from?
It's going to be page 47, but page 47, line 9 through page 48, line 15. But I do think for context, we need to start at 424, which is going to be page 45, line 25. Page 45, line 25.
Page 45, line 25?
Yes, sir.
Okay. All right, go ahead and play it, please.
I didn't see no face. It just when I see him jump out the car. gave it to somebody. Who? The boy that was shooting at my house. Who? Who? Who you know to be driving that silver Bonneville? I could never picture that. That's something I could never get. So who do you favor? Say. Your friend Tay? Which Tay? Well, you are my partner at the moment. Where you from? Simpson. You from Simpson? How can I find Tay? He on his Twitter arguing with Shannon. He did what? He's on Twitter arguing with Shannon. He on Twitter arguing with Shannon. This recent? Yeah. When? Right before y'all came and got me, I was just on the phone with my baby mom. She just told. So him and Shannon on Twitter arguing? They been arguing. About what? Me. Saying it. You still alive because we miss you. You still alive because we miss you? Like they miss maybe shooting at you? When did you see this person, like before the incident the other day with your baby? Before the incident with you and your baby, you said the dude was shooting at my house. Which incident are you talking about? Huh? You said the same boy that was shooting at my house. Okay, which?
And you're right, in that 425, 49.
Okay. Yes.
So it said, I heard it, and I'm assuming Your Honor heard it. He says Tay, and they're trying to figure out who Tay is.
Which Tay?
The Tay, I don't know which Tay at this point.
Okay.
So there's a Tay that allegedly shot at Mr. Copeland, or that's the state's theory, and Mr. Copeland is saying Tay, but he's not identifying Tay, and he says something about that Tay is having an argument with Shannon on Instagram, and then he was like, when is this happening, is what Investigator Gaither asked. And Mr. Copeland says, essentially now, or when I got locked up, and he said, that's what my baby mama told me. So it's clear his source of information is someone else who's telling him about this alleged internet argument, and he doesn't have any personal knowledge of it.
All right, sir.
It adds absolutely nothing to the context of this statement, other than it brings in hearsay evidence about my client, which I object to.
All right.
You're right, the section about Twitter, we won't play, we'll just pick that up when Detective Gator's trying to clarify, like an issue, when was he shooting at you? Just to try to clarify that portion. We will take out, I think it's probably about 425.
425.31 to what?
No, 425 to 425.
Okay, 420. 425.20.
No, 425.00
Yes, ma'am.
to 425. I think it's about 31 or 30.
31, 32. That's what you said you're going to take out? Because that talks about the Twitter conversation. All right. Mr. Shart, anything else from that particular time block that you wish to be omitted?
No.
All right. Any other counsel wish to be heard about anything from 425.00 to 425.33? Mr. Weinstein?
No, Your Honor.
All right. Mr. Matthews?
No, Your Honor.
Ms. T. Williams? Mr. Harvey? All right. Mr. Steele?
No, nothing further.
Okay. All right. So the state will be directed to omit that particular portion. The rest of it can be played. All right. Let's move on to 6, and that would be.
This next is
Hold on. Let me just frame it right quick, sir. 438.35 to 3840, and you've indicated that Casey saying that he has not hung out with Shannon Lodi since they shot the car. Confusing under 403 is a pronoun they is meant to refer to people shooting at Casey, Shannon Lodi, but could be misconstrued.
Right.
Okay.
So
Right.
essentially, they are asking about when's the last time he hung out with Shannon and Lil D, who's Demekion Garlington. And he says, not since they shot at the car. I think any reasonable interpretation of that, based on someone who's spent hundreds, probably thousands of hours reviewing the discovery in this case, which I have and the defense counsel has, any reasonable interpretation would mean he's referring to is the people that shot at him, Shannon, and Lil D in the car on January 27th, I believe it was, the day before the statement on the 28th. However, the jurors have not gone through all the discovery 10 times over as the defense has. So they have limited knowledge of everything. And when you listen to the statement in a vacuum, the reasonable interpretation is he hasn't hung out with Shannon and Lil D since they shot at the car, which makes it seem like Shannon and Little D were shooting at a car. It's confusion of the issues. It's likely to mislead the jury. And again, Your Honor, this is another one of those things I said earlier. This is not a normal trial. Yes, theoretically, first of all, there's no need to bring this confusion into this trial. So there's no prosecutorial need for this little excerpt to be played. But sure, theoretically, we could clear this up during cross-examination under normal trial circumstances. But when this is played, there's going to be several days in between that time where the jurors are likely to have in their head, if they're scrutinizing every line, oh, wait, Shannon and Lil D were shooting at a car? You know, and that's going to affect the way they look at my client. And when, in fact, we can just clear that up at the time of him saying it by deleting it, as opposed to me having to come back days later and try to clarify and draw everyone's attention back to this incident and this statement. So I just think under 403, to avoid confusion of the issues, we could easily just redact this little segment and clear up any potential confusion.
And Your Honor, before I even play it, the state understands what Mr. Copeland is talking about when he says when they shot at the car. The state has no intentions of alluding that the they is Mr. Garlington and Mr. Stillwell trying to shoot at Mr. Copeland. And when I read this portion, I'm going to play for the court the entirety of that section, because I think in order to understand this section in context, you have to start at 438:14, because there's already evidence, or will be before this video is played, that there was a shooting on the highway in which Mr. Copeland was involved in. And the state in no way, shape, or form intends to infer that Mr. Demekion Garlington or Mr. Stillwell was trying to shoot at Mr. Copeland. That's not even something we've thought of. So we'll play the whole section so you can hear it in context.
It's fine. Can I get the page references?
Yes, Your Honor. We're going to start at, it's going to be roughly page 64. And I'm starting at 438:14, so it should be around line 2 on on page 64, line 2. And it will go through page 65, line 1.
All right, madam. All right, let me hear it, please.
In that fucking river with them, period. This is what is going on. These two people I be with, they're going to be Shannon and Lil D. When I'm in with Shannon, me and Lil D together all the time. That's all. Exactly. No, this Shannon Steele and Mickey Garland. Yeah. They me and him together all the time. Them only two I've been with. Since they shot their car, I've been in the house with my baby mama. If I ain't in the house, though, we don't got to argue. And I don't call Quake. Quake don't can't pick that up, and we just rolled around here.
So we stopped it at 4:38:46. So in context, he's talking about the last time since they were shot at in the car. Well, before we played this interview, we would have played the January 28th interview where he's going to talk about the fact that they were shot at in the car in January 28th. And so when you read those two in conjunction with each other, I believe the jury will understand that he's saying since they got shot at the car, I've been in the house, given the full context. And again, the state will not infer that the they is Demekion, Mr. Garlington, Mr. Stillwell shooting at Mr. Copeland.
Okay.
When I said the defense attorney's been spending a lot of time with this case, also the state has. I mean, they have a background understanding. Both sides have a background understanding that's through discovery that's deeper than what the jury has at this moment. And that this line adds nothing to the understanding of the case. But, you know, I just listened to it again. I was thinking maybe I missed something. He says there's no discussion of other people shooting at the car. They say, when's the last time you hung out with Shannon and Lil D? Not since they shot at the car. It sounds like my client shot at a car.
Well, it has to be taken in context because the jury's already heard about some purportedly shooting. Okay.
Yeah, but
I understand your concern under 403. I respectfully disagree at this point, but
okay.
Because I don't think it would confuse them. But anyways, anybody else wish to be heard on this issue? Mr. Weinstein? No, Your Honor. All right, Mr. Matthews? No, Your Honor. Ms. D. Williams? Mr. Harvey? Mr. Steele? Nothing further. Okay, all right. I'm going to admit it are allowed to be played over objection. I still give you a continuing objection, okay? All right. Let's turn to number 7. And number 7 is 60325 to 60605. And you...
By the way, it's page 155, line 1 through 156, line 2. 155, line 1 through 156, line 24.
Okay, Mr. Shard. All right, let me frame the period. It's 60325 to 60605. It alleges Casey talking about Kel shooting and at some dice
At a gambling spot, which I believe under the state's theory is kind of one of the incidents that's the genesis of everything, of the disagreements between the groups. And my objection is that Kenneth Copeland is basically telling the police that Kel shot up the gambling spot, but even in his own statement, his identification of Kel. Now, let me be clear. He does say he was there, so it's not that he wasn't there, but from my understanding of his statement, he didn't know, no one knew who shot up the gambling spot. No one identified Kel, who's Kelvin Watts at the time, but afterwards, apparently, according to Mr. Copeland, Kelvin Watts told his girlfriend, or a girl that he knew at the time, whose name's Trivia, about what had happened, and apparently made some confession, according to Mr. Copeland, and then Trivia tells Kenneth Copeland. So it's double hearsay, and certainly even if Kelvin Watts to Trivia would fall under a hearsay exception, Trivia to Kenneth Copeland would not fall under a hearsay exception. So it's hearsay, and he doesn't have a basis of knowledge, and we would object to its admission.
All right, State.
Your Honor, the information about the gambling spot has already come in based on the January 11th interview in which Kel discusses, if not January 11th, February 20th, but the two interviews that have already been played before the jury. Mr. Copeland has already said in both of those interviews that there was this incident at the gambling house in Lakewood, and that it was Kel who did it. And more importantly, when he met with Kel at the Cascade skating ring, maybe the next day after this gambling incident, that he talked to Kel about the shooting at the gambling house, and that it was during that meeting at the Cascade skating ring that Kel got on the phone with Mr. Williams, and Mr. Williams asked for Kel to pay for the window that was shot up at the gambling house. So one, the evidence is already before the jury about the gambling house. How we get to who told him is irrelevant, because it was the effect on the listener, meaning Mr. Copeland, that once he gathered this information, he's using this to try to squash the issues between Copeland and Kel. And so when he's relaying to Detective Gaither the beginning of the conflict between him and Copeland, he's just now reiterating how he got the information that Kel did it and what effect that had on the issues between the two of them. So who told Mr. Copeland that it was Kel is irrelevant to the sole fact that he thought it was Kel. That was kind of the beginning of their issues with each other. And as a result of knowing that it was Kel who did the shooting, Copeland in turn confronts Kel about this shooting. And during the course of his confrontation of Kel, also had a conversation between Kel and Mr. Williams about the shooting that occurred. So this portion as to how he found out it was Kel is not, while hearsay is really effect on the listener, but this is already information that's before the jury. But it's important, Your Honor, because let me say this, that defense counsel is arguing that Copeland consistently lies. What this shows is that Copeland's giving the same series of events to multiple different investigators at multiple different interviews. And so that shows that at least back in 2015, when he's recounting his history with him and Kel, he's telling different investigators these same series of events that occur leading up to the murder of Donovan Thomas. But I'll play the section for you if you want to.
All right, sir. Yes, ma'am. Go ahead.
And I'm going to start at 6:03:22.
But that's what it was about. Then they got mad. So D got jumped in the club by MBC. They tell her, D, we ain't help you because you be with them. They asked her, D, why they ain't help you?
You got too much shit going on. And don't nobody know why.
It was, no, but the whole time come back on care them. Because here's the gambling house we go hang it and gamble. We go down and gamble. We come out the league. Kel, I'm in the bush. Kel, Stewart, and they never mentioned the third person name. In the bush, they started showing me them. They shot so many times. Shit, I was glad they left. Huh?
Who gave them out?
In Lakewood. They shot so many times. They shot down in everybody's car. But they missed everybody. They graded one person probably bad. But when police came here, left. Co-people left. But they don't care. But that's the same like NBC jumped on the deep. So they did it and they seemed like NBC did. But I go over and boy, I'm home. I stayed out about 2 or 3 years. So I was telling them like, damn, bro, y'all ain't gonna come out there. Y'all trying to kill me. What's up, bro? And they like, hell nah, bro, you tripping. Like, bro, we ain't shoot that shot there with one of the NBC niggas. Like, bro, we ain't got no problem with that, bro. You feel me? Y'all jumped on the deep. Let D be with me, bro. I'm on the stage. I'm like, nah, bro, y'all tripping, bro. In my palm, bro, nah. They keep trying to get in each other's face. Well, nah, the next thing you know, Big Boo came up there, and one of them, swarm. He grabbed the D out stage, started jumping on the D. I ain't know it was a D. I'm thinking they wanted them jumping on them. So I walk out the club, see the D, them got shot in the hand, and he blamed me shit. Oh, what happened to you, bro? And he couldn't talk. He like, and I was seeing the hammer, but damn, they shot you too. So he went down hammer now. He went to the hospital. So I had to tell him I'm with him. And Pinky went down there with him. Goddamn, the next night we at the gambling house. They ain't not putting no pictures. We in that gambling. They take pictures and shit. Then he came up and shot at it. We found out it was killed. He had got into a Gucci Red. And she was talking to them. She came back and told her, like, man, they were killed and shot at y'all mixing like they did. Because they shot at it and they went and shot at Monday spot. Monday we got into it with the NBC name. They bumped, boom. They how they fight started. They went and shot at their house on Metro Pines. Shot house on Tuzlo. So that.
And it ends at 6:06:07.
So to put a little context to what you just heard, this gambling spot was shot up, according to Mr. Copeland. It was assumed that it was people from a group called NBC, because according to Mr. Copeland, Mr. Kendrick had gotten into some sort of dispute with someone from NBC around that time, is what Mr. Copeland's saying. I don't know if that's true or
Mr.
not.
Kendrick or Mr. Garlington?
Mr. Kendrick. I think he says Monte. I'm assuming Mr. Kendrick. Might not, maybe someone else named Monte. And I don't know if any dispute occurred. But what he's saying is it was assumed it was NBC. And then through hearsay, it came out that it was Kel. Through hearsay, through trivia. And so our stance is that's hearsay. Effect on the listener is much narrower an exception to hearsay than the state's been putting forward in this case. Throughout this case, they've been relying on effect on the listener quite a bit. I don't believe that it's quite as easy to get around the hearsay rules under just saying effect on listener. And his knowledge, he's giving a historical narrative of this event, and his knowledge of who committed the event or committed the act is based entirely on hearsay. So
what about the issue that we've heard testimony already about the gambling
then
house?
it's cumulative.
Then the shooting of the gambling house.
Well, if we've allowed that in the past, then that's on the defense counsel for not flagging that. But at this point, it's cumulative if it's come in already.
I believe it's already been testified to. In fact, I think Mr. Copeland earlier in his direct he's testified about that on the stand, about the shooting of the gambling house and this kind of historical perspective.
At this point, then it's cumulative, and if collectively we have missed it in the past, we're flagging it now.
Okay, all right. Any further argument, Mr. Weinstein?
No, Your Honor.
Mr. Matthews?
No, Your Honor, just adopt.
Ms. T. Williams? Mr. Harvey? Sir? Turn your mic on, sir, please.
I want to adopt what Mr. Shard said with regard to the effect on the listener. Effect on the listener is usually most often used to as evidence of motive. It has not been used in that sense, and therefore it has been abused and continues to be abused as the basis for the admission of these clearly hearsay statements. So, for example, in Gates versus the state at 298 Georgia 324.
One more time, Gates.
Gates 298 Georgia.
All right.
324.
Yes, sir.
There were text messages admitted that were sent to the defendant's girlfriend, not for their truth, but for the effect on the defendant in establishing motive for a murder. That's the usual basis upon which hearsay statements are admitted for the effect on the hearer. That is not the case here. This is not the defendant. It doesn't establish motive. So I would adopt and expand Mr. Shart's reasoning.
All right, sir. Mr. Steele.
Nothing to add.
All right, sir. Excuse me. All right, folks, we're gonna take a comfort break. Let's take 5 minutes. Come back. I'll make a ruling at that point in time on 7. Okay.
And Your Honor, before the state did want to respond to what Mr. Harvey said, and so I didn't know if we could get an opportunity to do that prior to the court's ruling.
Okay. All right, we're in recess.
Turn it to 7.
you said you had a response to Mr. Harvey's comment.
Yes, Your Honor, very briefly. In looking at Gates, Your Honor, specifically the portion which they talk about the effect on the listener, yes, this was a murder case, but what it says, and this is in Division
2?
2.
I have it up.
Yes. And when you read the fullness of it, it says, for a statement of constitute hearsay, it must be offered in evidence to prove the truth of the matter asserted. And it cites the statute. Here, the declaring statement at issue was, you're ever lonely, you can call me. The text message sent along with the naked pictures was not offered to prove that Gates' girlfriend could in fact call or had permission to call Wilson if she were lonely. Rather, the text messages were offered to show its effect on Gates and in this case, his motive for committing the murder. An utterance may be admitted to show the effect on its hearer. See also Miller v. State, 275 Georgia 32. For such a purpose, the statement would not be hearsay as it was not offered for the truth of the matter asserted, but for the effect or lack thereof on the hearer. As such, Gates claims that this evidence was inadmissible because it was hearsay without merit. Here, again, Your Honor, learning about the fact that Kell shot at the gambling house, what Copeland took with that information is he confronted Kell about it. They had a discussion about not just the gambling house, but all their other issues that they had with each other. And then furthermore, during this interaction, which was, I believe, the next day after the gambling house or some time later, Mr. Williams then speaks to Kell about that shooting that happened at the gambling house and specifically about paying for the window. So again, Your Honor, it's not about what, and I believe it's Gucci Red. I think Mr. Shar said that it was Trivia who said it, but I believe he said Gucci Red told us it was Kell. That information is what he used to confront Kell about what happened at the gambling house. So that's what the state wanted to add.
What's your response to the defense's assertion as well as cumulative? Because it's been testified to.
Because, Your Honor, defense counsel assertion is that Mr. Copeland lies about everything. And so what his reiteration of this incident shows is that not just in the February interview, not just in the January interview, January 11th, he talks about it, I think, briefly in January 28th and February 20th, that he's reiterating these events to different investigators to talk about the history of what has occurred between them. And if he's such a liar as they want to purport him to be, then he would not be able to recount this historical perspective to the detectives that he is meeting with. So while he is repeating the story, he's repeating it to different detectives at different times to show that he is at least consistent with the historical events that lead up to Donovan Thomas's murder.
All right. Okay. All right, counsels, I've had an opportunity to consider your arguments as well as take a look at Gates 298 Georgia 324, as well as Garner versus the state at 342 Georgia Appeals 824. Both of them stand for the same proposition about effect on listeners. So I'm going to permit the inquiry area of 60325 to 60. Hold on. Get back. Hold on. (60325) through 60605. All right. I'll give you a continuing objection, defense counsels, as respect to that. Let's move on to 8. I believe 8 is 6/19/20 through 6/20/20. And I believe that is Casey being reluctant to cooperate in the shooting investigation where he's a victim. He says he's concerned they will put the discovery on IGS or Instagram.
Yes.
Okay. Can you give me the page references, Mal?
Yes, Your Honor. So page 173 line 7 through page 174.
Okay, all right. Mr. Sharp?
So, Your Honor, here is another example of Mr. Copeland stressing the social ramifications of cooperating in this investigation. Again, when I say this investigation, I'm referring to an investigation against people that shot at him allegedly outside of his house while holding his child. So we get into this, it's almost bolstering. It is bolstering, where he's showing a fear of testifying, but again, it has nothing to do with these gentlemen. It has nothing to do with the investigation of these gentlemen seated in court today, but it has to do with an entirely different group of individuals from that are allegedly associated with an entirely different group. So it has no relevance to this case. It creates the impression that Mr. Copeland is universally opposed to cooperating, universally fearful, universally has been threatened and feels threatened. But the reality is he's expressing fear, reluctance, and all the rest regarding an investigation of an entirely different group of individuals. And it's likely to confuse the issues. It's unfair prejudice towards our clients where there's absolutely no evidence that he's been fearful, that he's been threatened by any of these gentlemen or anyone associated with these gentlemen. So we would argue that it should be excluded under 403, 401 and 403.
All right, madam, can you play it, please?
And Your Honor, I'll start at 6/1940.
You know my name?
In that car that's gonna put them there. Like you worried about the wrong thing. Like, I'm worried about when you get locked up and you get a skirt back to see I circle each picture and put my name on them. And you're gonna send it out to the screen and be like, I done told on him. And they're gonna put it out on Instagram and Twitter and they're gonna tell everybody. And then guess what? They're gonna start like, then I'm gonna be just like what then? Nobody won't be around. So you worried about your reputation as opposed to your life and being a free man? It's up to you. I don't want to go back and forth. Either you gonna do it, Woody, or you not.
And Your Honor, that's the conclusion at 6/1944. And Miss, we started at 6/1906. And Your Honor, may I respond?
Yes, ma'am. What's the state's response to Mr. Shard and the defense attorney saying that violates 401 and 403?
So again, Your Honor, one, this is a impeachment by contradiction. Again, in court, Mr. Copeland has said repeatedly that they forced him to pick out Tay, and that he was not afraid of snitching or telling the police who did it, but that Tay did not do it. So one, this is a contradiction to both of those assertions that he made in court. Here, again, for the totality of the case, Mr. Copeland, back in 2015, and we believe even now, does not want to come to court to testify against whether it was Tay or these individuals. So this shows, one, he contradicted his testimony as to what he did back in 2015 as it relates to Tay. And then two, it shows not that he's fearful that anyone's going to harm him, because the state has never asserted that any of the defendants were going to harm him. What the state has asserted is that he does not want to come and testify against them. And this is a prime example of that. So for those two reasons, we believe that this portion should come in. Additionally, Your Honor, when Mr. Shar says this had nothing to do with this case, that is not true. What Mr. Copeland is talking about in this interview is a retaliatory shooting that occurred as a result of Donovan Thomas being murdered. So again, putting this all in context, Mr. Thomas was shot and killed on January 10th. Over the course of about 6 to 8 weeks, there are multiple shootings. We went over that yesterday, Your Honor. And one of the final shootings was on February 19th when these group of individuals that were associated with IF gang shot at him, his child, and his baby. And they're trying to get him to identify who one of those individuals were. So it does have something to do with this case. It has something to do with the overall retaliatory shootings that occurred as a result of Mr. Thomas being murdered. And again, in this section, he talks specific about having to come to court. Like, that was his concern here. Like, I have to come to court and I'm going to have to testify about this. He was concerned about doing that. And Your Honor, we believe that that is also why he's changing his testimony in court today. Court during this trial.
Any further argument, Mr. Weinstein?
No, Your Honor.
Mr. Matthews?
No, Your Honor.
Ms. D. Williams? Mr. Harvey? Mr. Steele?
Nothing.
Okay, all right. All right, in considering both sides' arguments in regards to defense 401 being relevance, 403 being unduly prejudicial, or in the state's assertion that is impeachment by contradiction, the court does find it is relevant that even using 403 as a balancing test, it is more probative than prejudicial and shows impeachment by contradiction. So I'm going to allow it over defense objection, and I'll give you a continuing objection in regards to that. All defense counsel. All right, let's cover number 9. Number 9 is 626:30 through 627:05, and as you framed it, Gaither gives speech about the need to put an end to the shootings. All right, sir, go ahead.
I was gonna.
You want to play it?
Yeah, can we just play it and then?
Yes. And Your Honor, it's page 181, lines 8 through 12. I'm going to start a little earlier at 626:22.
I can't deal with this shit, man. And I understand that, but you gotta help you right now. We trying to get a stop to all this back and forth shooting. You trying to back and forth shooting? Gee, they only shooting at you. Shit. We trying to get a stop to this. And we pulling every resource in the city that we can, but we can't be everywhere. So if I gotta pick these motherfuckers off one by one, waiting on evidence to come back, then I'm gonna do what I gotta do. But you gotta fuck it. I'm doing what I gotta do, man. Help me out. I'm doing it. Damn, man. Why did I go through this, man? I don't know. I don't know, but I'm ready to do it. Bruh, I'm ready to get started on the aftermath. I'm ready to get started on that. I can't work towards homicide. I'm picking up the pieces of the aftermath for the homicide. Here.
Your Honor, we stopped at 627:30.
So, Your Honor,
All right, sir.
my objection, again, these statements are allegedly prior statements. I mean, the reason we're playing for the jury over our objection, the defense objection, is because there are prior statements by Mr. Copeland. We have the non-declarant, Investigator Gaither, just talking about the need to end the shootings and how she's going to end the shootings, and the city's putting every resource into ending the shootings. And it really, you know, we're all citizens here. We're all city of Atlanta. We're all Atlantans. It's not the city versus these gentlemen. It's not supposed to be the police force in the city versus these gentlemen. And it's supposed to be a neutral. And that's the impression that the jury is given when they're exposed to, again, this speech. I call it a speech, but whatever you want to call it, by Investigator Gaither, where she presents this as, look, it's, you know, the city and all the authorities and the police department, we're all working to try to put an end to these shootings, and it's you guys and Mr. Copeland, it's your information that will put an end to it, and it's your group that's involved in all this. I believe it's inappropriate. I believe that it invites the jurors to consider it invites them to take into consideration factors that should not be considered in that jury room. And it's essentially an improper argument. If it was made during closing, we would argue that it's an improper argument. It's, you know, just because it's not a closing argument doesn't make it not improper. It's improper for the jurors to hear that type of talk by Investigator Gaither, especially considering the whole reason that this tape is being played over our objection is not for Investigator Gaither's words, but for Mr. Copeland's.
All right. Ms. Hilton.
And again, you have to look at this in totality, Your Honor. This starts off with Mr. Copeland saying, why do I have to go through this, man? And Gaither is then going into, I need you to do this. I need you to identify who it is so that I can get started on my investigation. So I can continue my investigation. I can continue my work. So while Mr. Sharp calls it a speech, she's responding to Mr. Copeland saying, why do I have to go through this? And if you look at his body language, he was struggling to move forward and just make the identification. And so she's trying to encourage him to go ahead and make the identification so that she can move forward with her investigation, Your Honor. So again, as the state said earlier, that's in contradiction to what he said here in court. What he said in court, they were forcing him. No, they were talking to him about it. He's responding back to her. I believe in court he may have said they made him say Tay. That's not true. That's what this shows as well. And so given his in-court testimony, this is contradicting what he said here in court.
All right. Any further argument? Mr. Weinstein?
No, Your Honor.
All right. Mr. Matthews?
Nothing to add.
Ms. D. Williams? Mr. Harvey? Mr. Steele?
Your Honor, I don't see why this adds anything. I join everyone else, Mr. Sharp's argument. The detectives said we're going to pick them off one by one. Every officer is going to be working. The state is saying that Detective Gaither is encouraging Mr. Copeland. That's not needed. That's not the purpose. We don't just play recordings of me speaking with a witness to say I was encouraging the witness. This is just an out-of-court statement offered to bolster the detective, and that's really not appropriate in my opinion, and it's irrelevant under 4012, and then 3 would be a waste of time. A lot of this, the state wants to play, these are, I believe, 18 hours of recordings. I mean, at some point, they don't get to just play all these recordings, so I would object.
And I can respond to Mr. Steele specifically, if the court may.
Yeah, I'm in trying to kind of see why the detective gave it before it starts. We're trying to stop this. We're pulling every resource in the city. We can't be everywhere. So if I gotta pick these motherfuckers off one by one, waiting on evidence to come back, then I'm gonna do what I gotta do. But you gotta I'm doing what I gotta do. I'm doing it. I'd be inclined to take that out, but the other stuff would be admissible under impeachment by contradiction or relevant.
So which line, Your Honor?
Line 8 on page 181, line 8 through line 12.
That's fine, Your Honor.
It does. I agree with Mr. Steele. It doesn't really add anything to it, and it's for the reasons he mentioned. Okay.
Okay. So line 8 to 12. We can
Yes. Anybody else have any other comment or any other argument in regards to number 9, 62630 or thereabouts is 62730? All right. I'm gonna. Other than that particular omission, or exclusion from, that'd be page 181, using the state's transcript, lines 8 through 12. The rest is can be played.
Thank you.
Okay.
Yes.
All right. And I'll again admit an over objection and give a continuing objection. Does the defendant still maintain that none of this is proper and they should not be played? So, okay. All right. Number 10. Number 10 is 63030 through 63150. And you are saying that that's 404A evidence about Mr. Stillwell and inappropriate comments about character.
Yeah, 404A and B.
404A and B. Okay. All right, sir. Oh,
I'm sorry, Ms. Hill.
you want to play it first?
Yes, please.
Okay. All right. Let's play it. What transcript page is now?
Another portion will be page 185, line 17, through page 186, line 19. And we'll start 630.
630 what?
I guess she wasn't looking at it serious like how it is. I really wasn't. I really thought he wasn't. I didn't think they would do it. I didn't think they knew to try to shoot me. I'm pretty sure I thought really would try to do a kill. They showed me wrong. Well, I know him for shit. He been on Twitter going back and forth with Shannon. Yeah. What the hell? I'm telling Shannon, why the hell you ugly? You can go to it. What Shannon been up to? Because I know he ain't just gonna sit and let it ride like you getting shot at and all that. I know that. And you know what I told Shannon? Man, let Polly deal with him. No man, he'll play himself. You know what Shannon told me that night? The night they shot me in bed. You let him play. I was crying. And you let him play. Man, bro, hell nah, bro. We take anything you can. I'm like, bro, fuck this shit, bro. Let them have it, bro. Let them have it, bro. They kill me, bro. You know what's going on, bro. Just let start with Lieutenant Shannon. Police involved with it. Just start with it, bro. We ain't going to jail, so we ain't do, bro. You're not going to tell you one of these folks think we did this shit, bro. And that's what I told him. He like, she looked at it. She like, bro, I'm telling you, bro, if they kill you or they hurt you or they, bro, they gotta kill him too. Just like him, bro. They don't get your shell out of it, bro. We already in the battle phase. We with people we never thought we'd be with, bro. Fuck this shit, bro. Let them have it. That's why I really ain't getting in there. If I didn't, like, I feel like.
And stop at 631. So sorry, stop at 631:51.
All right, Mr. Sharp.
So this testimony or this out-of-court statement by Mr. Copeland about my client has absolutely no relation to any charged conduct in this case. It's propensity evidence. There's no evidence of something that happened that I know of. There's no evidence of something that happened after this date that was supposedly done on behalf of Mr. Copeland as payback for either the January 28th shooting of Mr. Copeland in the car, or shooting at Mr. Copeland in the car, or the February, I guess it would be 19th, shooting of Mr. Copeland, or shooting at Mr. Copeland outside of his house, other than, of course, Mr. Copeland shooting back at those individuals and hitting them in their car. My point being, Mr. Copeland is essentially saying that Shannon has encouraged him to, and said, we need to get payback for them shooting at you. And Mr. Copeland saying, no, I said, let it be, let it be, let it be. This is not testimony about any act that's charged. This is mere propensity evidence that Mr. Stillwell is someone that when something's done to him or one of his friends, he's going to seek retribution from the other side. And again, if the state had overact, and I'm making this up, that happened on March 3rd of 2015, where they allegedly saw the car that was shooting at them on January 28th, then I would say, okay, maybe that has some relevance to this specific act. But there's no act that's charged. And what the state wants, essentially the logical conclusion based on hearing that, is Mr. Stillwell is, a hothead that seeks revenge. That's propensity evidence. That's exactly what's not supposed to come in under 404B. And so I would object. It's improper character evidence. It's improper propensity evidence.
All right, sir.
Yeah, we won't play it.
Okay. I'm going to use Mr. Adams' favorite saying, easiest decision I'll make today. All right. Anybody else have any other comment about subpart 10, 630, 30 through 631, 50? It's going to be omitted. Anyone? All right. Okay, we've gotten through the flaggings of Mr. Sharp. Does anybody else have any other time periods they wish for me to discuss with the court? Mr. All right, thank you, Mr. Steele. Mr. Harvey? Ms. D. Williams? Mr. Matthews?
No, Your Honor.
Mr. Weinstein?
No, Your Honor.
Okay.
When I say no, it's with reference to my continued objection for severance and instructions with regard to all of this evidence. I don't want that to be deemed to be a waiver on the record.
Okay, Mr. Harvey, in no way, I'll note it again for you that you have moved for severance and for 105 instruction, which the court is going to give you continuing objection on, but I'm going to deny that at this time again, okay? All right, sir. Okay. All right, councils, let's talk a little bit about way ahead in scheduling. I believe that you all have, as well as it pertains to Mr. Copeland, June the 10th interview, which is the longest one, is 9 hours. Is that correct? All right. Have you all been working on, or I'm going to ask the state first and then defense counsels in terms of what you've identified as to what you're going to play and what you wish to omit?
Your Honor, we sent to Defense Counsel, I believe on Monday, the areas in which the state, I'm sorry, let me stand up. The areas in which the state intends to redact. Yesterday evening, Mr. Shard, I think, sent me a portion of the areas that they would like redacted. We haven't had the opportunity to look at those. And then I believe Mr. Adams is supposed to send me the secondary portion of that. And so we'll be looking through that over the course of today and this weekend to determine what, if any, areas we can agree to. Once we finish talking about June, Your Honor, I will briefly just want to get some clarity on February 21st, but after we finish the June discussion.
What do you mean you want clarity on the
So we submitted
21st?
some redactions for February 21st. And I don't know if, kind of along the same lines of the conversation yesterday, if there are areas that the defendants wanted in that the state intended to redact. And if there are those same line of area, we understand the court's ruling from yesterday, but we just wanted clarity because we don't know. And that could be an offline conversation I can have with Mr. Shard to see what their position is.
I think I can answer this. After speaking with other attorneys involved in the defense of other individuals, I believe that there is an objection to the redactions of the timestamps identified by the state. We understand that the state, in their presentation of the case, they may choose not to present some of these excerpts when they play the tape.
Which tape were we referring to?
February 21st, 2015.
All right.
But I believe that the defense is going to seek to admit portions that the state is not going to seek to admit.
And certainly we can have a similar discussion that we had yesterday, or I can authorize, unless there's been a specific objection, I'm going to say you can play it during cross-examination. Like similar to what I did yesterday.
Yes.
Okay. And that's fine, Your Honor. We'll object at the appropriate time.
Yeah, if appropriate, I'll rule upon it. But I'm most of the things that, unless there's clear argument to the contrary, will be fair game on cross. Okay.
Thank you, Your Honor.
Okay, so let's talk about the June 10th interview. So is it possible for you all to, like, consistent with, this has been very helpful for you all to identify the time periods and for us to work down through them and have discussion one way or another? Are you all in a position to potentially put something together by Monday, and so we can kind of go through the June 10th interview?
The good news is we're all operating off the same transcript for June 10th, and there is a transcript. I believe the transcript's about 550 pages. I made it through 380, and I've identified the specific spots that I object to, and I believe that other attorneys involved in this case adopt my arguments for those first 380. Mr. Adams is diligently working. He's identified the rest, and he is going to send that information over to the state at some point. I don't want to speak for him, but I know he's been working on it. So I think that the state has given us their proposed redactions, correct? Correct,
Your Honor, but I think we're going to be in the same position. So we really need their redactions, because I think the state is, we're going to redact what we're going to redact, and if they choose to want to play certain portions, we can object at the appropriate time. So I think we really need to know what their redactions are in order for us to have a meaningful hearing, hopefully on Monday.
So right now they have about 2/3,
Okay.
just by the transcript length, about 2/3 of the redactions, and then Mr. Adams is going to get them the rest.
Mr. Adams, will you be finished by Monday?
Oh, absolutely. They'll have them by, I can give it to them by Saturday.
Okay. All right. Okay.
That works.
All right. So we'll work on Now, as it pertains to, since we'll probably take the most of the day with that, I'm inclined not to call in our juries for Monday.
And Your Honor, I'm going to remind the court that we also have the jail phone calls.
Yes, and there's 11 of those at 2.5 hours. All right, and then, counsel, as you all recall, Tuesday the 25th, we'll probably just work from about 9:30 to about probably shortly thereafter lunch. So my inclination as well, I don't think we're going to probably finish with our, it's possible that even if we, that we'll spend or exhaust most of Monday the 24th and Tuesday the 25th getting through the 10th and or 10th of June, as well as the jail calls, and we may not even be finished with those. So I'm inclined to just tell our jurors have a nice week, unless somebody has something to the contrary.
Nothing from the state, Sean.
Anybody? Okay. I mean, I just don't think we'll be in a position for them to hear anything at that point. All right. Which leads me to July 1, 2, and 3. More than likely, we'll probably use, if we don't finish up our business with the jail calls, we'll probably take that up on Monday the 1st of July. Tuesday, we'll probably do the in-camera review of Mr. Copeland's ex parte matter. And I will give you all more pinpoint instructions on that particular time and date. But it more than likely will be the 2nd or the 3rd of July. So that's our kind of work schedule at this point in time to clear those issues before we call back our jurors.
So at this time, we're thinking no jury for the week of the going to the 4th.
Probably not, is what I'm thinking. And I may tell them that so they can adjust they can govern themselves accordingly. But we have a fair amount of stuff to take care of. So, all right. Anything else, councils, at this point in time? If not, I'll see you all on Monday the 24th, 8:30 for an anticipated 9 o'clock start time, and we'll queue up the 10th, the June 10th, 2015 interview, and see where that leads us. Okay. All right. Anybody else? Okay. All right. We're in recess until Monday the 24th at 8:30.
Watch your step for me.
You solemnly swear the evidence you give the court and during the case now and here and the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Thank you. You may take the seat.
All right, whenever you're ready, Mr. Jackson.
Thank you, Your Honor. Dr. Russell, could you please, in a loud, clear voice, state your name and spell your last name for us?
Hi, Dr. Marie Russell, Russell.
Doctor, what do you do for a living?
I'm an emergency room forensic pathologist, just recently retired.
And prior to retirement, what was your position?
The immediate position before retirement was chief medical executive at for the state of California at the Corcoran State Prison.
And
So, Dr. Russell, I'm going to ask you to keep your voice up, okay?
Yes, I'll try.
Thank you.
Thank you.
there's a couple of air conditioners in here. Just keep your voice as loud as possible. What is, in fact, an emergency physician?
An emergency physician is a medical specialist who has completed a residency, internship residency in the field of emergency medicine, which is a field which involves taking care of patients that are sick or injured and go to the emergency room.
Can you tell us what your education, starting with your education, training, and background is that qualifies you as an emergency physician, starting with your education all the way back to college?
Okay. Well, I've completed at least 16 years of formal education beyond high school, which includes college, and then 4 years of medical school, then 4 years of emergency medicine residency and internship, and then 4 years of pathology residency, which includes 2 years of anatomic and 2 years of forensic pathology. And then I treated, I've taken a bunch of other courses and attended seminars.
Let's start with your college. Where'd you go to college? Where'd you start?
Okay. MIT. I did my first year at MIT where I took my pre-med courses.
And then what happened after that? By the way, about what year was that?
Oh, that was in 1972 to 73.
Where did you go after MIT?
So what happened? I was interested in becoming a doctor, and so I took the pre-med courses, and then subsequent to that first year, I learned that my mother had metastatic breast cancer, and so I decided to go home to New York to be with her. After that, she subsequently passed away, and I returned to Massachusetts and decided to take advantage of the time off from school to investigate my interest in law enforcement. And I subsequently became a police officer here in Massachusetts.
So following MIT, did you go to a police academy?
I did.
Which police academy did you go to?
I went to the Boston Police Academy.
And did you end up becoming a sworn officer?
Yes.
For how long?
I did it for 7 years full time.
And what department did you work for?
I worked for the City of Malden Police Department.
What years was that, if you could give me a range?
From 1977 to 1984.
During the time that you were a Malden police officer, did you also go to school and continue your formal education?
I did.
Describe that for us, please.
Well, I took I took specialized courses through the Massachusetts Criminal Justice Training Council.
Objection, move to strike.
All right, so I'm going to strike that. Jurors, disregard that.
Let me ask you this way. I don't want to get into the specifics.
Okay.
While you were a police officer, did you also take formal education to further your medical training or your college?
Yes, I did.
That's what I'm interested in.
Okay.
Tell us about that.
Oh, yeah. So I attended Northeastern University part-time and received a Bachelor of Science degree in psychology.
After you got your degree in psychology from Northeastern, did you go on to continue your education in medicine?
I did. I attended medical school at the University of Massachusetts Medical School from 1983 to 1987.
Also known as UMass?
Yes,
Did you ultimately end up with a medical degree?
did. Doctor,
After you became a doctor, did you engage in a residency?
yes.
What years were the residency, that first residency?
So the first residency was from 1987 to 1991, and that was in Los Angeles at the Los Angeles County University of Southern California Medical Center.
Is that also known as LAUSC?
It was at the time, yes.
And that's associated with the University of Southern California Medical Center, is that right?
Yes.
After your first residency, by the way, what was your first residency in? What was the subspecialty?
So it was in emergency medicine, and USC is a very large trauma center.
How would you describe the size and volume of the USC Trauma Center?
Well, it's one of the busiest in the United States.
After your first residency in emergency medicine, did you do a second residency?
Yes.
What was the subspecialty in that second residency?
So I did a 2 years in anatomic pathology and 2 years as a fellow in forensic pathology at the Los Angeles County Coroner's Office.
So you did 2 full residencies after you became a doctor, is that right?
That is correct.
What's the difference? I don't want to go into great detail, but what's the difference between an emergency physician and, for instance, the residency that you did in pathology, both anatomic pathology and forensic pathology? What are the differences?
Well, generally, the emergency physician treats live patients, and the spectrum of injuries can be wide, or illnesses can be wide, and the forensic pathologist treats or deals with deceased patients generally.
Did you become a fellow at the LA Coroner's Office following your second residency?
No, that was part of the second residency.
Understood. Describe that fellowship.
So that was 2 years of full-time work at the LA Coroner's Office under the supervision of very experienced medical examiners. And what I did was I did autopsies, every day, 1 or 2 autopsies every day, attended conferences, and read journal articles, etc. It was a very formalized education.
Did you also become, at some point, a professor or an assistant professor at LAUSC, the medical center side, the university side?
Yes. So while I was doing the forensic pathology and anatomic pathology residencies during the daytime, I worked as a full-time ER doc supervisor in the capacity of an assistant professor in the evenings.
Did you also become an adjunct professor at Cal State Los Angeles, California State Los Angeles?
Yes.
Is that a separate university?
Yes.
And you had separate responsibilities as a professor in that role?
Yes.
Were you also teaching legal medicine and forensic medicine in that capacity?
That is correct. It was a master's level program.
How long were you an ER physician in total and an attending physician for Los Angeles County USC Medical Center?
29 years in total. 4 of those were in training and the rest were as a supervisor. And
Of your 29 years, 25 of your 29 years, you were supervising others,
correct.
meaning other doctors,
Other doctors, yes.
teaching other doctors,
Yes.
and teaching medical students.
Yes, and seeing their cases, once they examined the patient, they would present their case or tell me about the case, and then I would go in and see those patients in addition to my patients.
That was my next question, doctor. In addition to teaching, were you also specifically assessing, diagnosing, and treating patients of your own?
Yes, not all the time. Some shifts I didn't have to do that, but much of the time, yes.
For the bulk of the 29 years that you were an ER doc, an emergency physician, in other words, were you also attending to patients as well?
Yes.
Once you left that fellowship with the LA Coroner's Office, did you remain active in any way or connected to the Los Angeles Coroner's Office?
Yes, so I would attend their weekly conferences when I could, when I was available and to do so, and I also consulted on some cases with them. So if they had something that was interesting and beyond their clinical expertise, they would sometimes consult me.
During your tenure at LAUSC, did you become the director of any of their sub-programs?
Yes.
Can you describe that for the jurors, please?
Yes, I was a director of the USC Center for Life Support Training, and that involved teaching other doctors life support courses such as advanced cardiac life support, or we teach the surgeons advanced trauma life support.
I'm sorry?
Oh, go ahead.
Were you also a director for their quality improvement in the early 2000s?
Yes, for the emergency medicine department.
What was the reason for the quality improvement program, if you will, for LAUSC?
Well, for any program, it's ideal to have a quality improvement component, because what you want to do is look at cases that were treated and see if there were any errors, and if so, correct the errors, teach the doctors that involved, what went wrong, and try to make systemic improvements or teaching improvements to prevent those errors from occurring in the future.
Were you teaching basically best practices for emergency room physicians as well as trauma physicians and surgeons?
Yes, we tried.
And you were the director of that program, correct?
Yes.
Did you also become the director of LAUSC Jail Medical Services?
Yes.
What is the connection or the tether between the jail system in Los Angeles and LAUSC Medical Center?
Well, LAC Jail Ward was established about 70 years ago, and it was a place that the officers from various agencies, such as LA Sheriffs, LAPD, California Highway Patrol, or any of the municipalities around, could bring people that they arrested who were in need of medical care.
So the jail system, very large jail system, I'm guessing, in Los Angeles, correct?
Correct, yes.
There have to be medical attendants to that jail system, correct?
Yes.
And you became the director of the jail medical services for the entirety of that system?
For the hospital component of it.
Understood. In California, you're obviously licensed in California.
Yes.
There is a state medical board in California, correct?
Yes.
And did you ever do any work with that state medical board?
Yes, I worked with them for about 7 years part-time as a regular employee embedded in their enforcement unit. And what that involved was examining cases that were referred to the medical board because of substandard care or illegal activities of the providers. It was for physicians and physician assistants that we regulated.
What was your title with the state medical board for those purposes?
The title was medical consultant. That was the official title.
Okay. And then before your retirement, by the way, what years were you the medical consultant for, or a medical consultant for the state board in California?
I think from 2009 to 2016. I think those were the years. I'm not positive. I did that. That was a job I was doing. One, I was doing the LA County USC Medical Center job too. It was an extra job.
So you didn't stop working as a physician, an ER, an emergency physician at LAUSC to take that position?
No.
You just consulted with them?
I did it once a week, 1 day a week.
Got it. And then with regard to the one of your last positions that you held, did you become the chief medical executive for the California State Prison, Corcoran?
Yes.
Tell me about that position and the years that you held that position.
So that was from 2018 to 2023. And as the chief medical executive, I was the supervisor of all the doctors and nurse practitioners that provided care to the inmates.
And obviously the California prison system is a very large prison system.
Very.
Doctor, are you board certified in emergency medicine?
Yes.
Are you a member of the National Association of Medical Examiners?
Yes, I'm actually fellow status, which is higher than member.
Are you a member of the American Academy of Forensic Science?
Yes, again, I'm a fellow there.
Which also is an advancement above just being a member?
Correct.
Have you ever published in the area, and now I'm going to get very specific, have you ever published peer-reviewed articles and done research in the area of animal bites and scratches?
Yes.
Did you author or co-author a peer-reviewed article named Managing Law Enforcement Dog Bites in the ER?
Yes.
About what year was that?
It was in the 1990s.
Late 1990s, 1996, does that
Yes.
sound right? Did you also author or co-author an article called Law Enforcement Canine Dog Bites, Injuries, Complications, and Trends?
Yes.
So given those articles, did you study specifically dog bites, dog wounds on the human body?
Yes, I have a very strong interest in wounds in general, and I have a strong interest in dog bites in particular.
During the course of your career, your professional experience, how many patients would you say you've seen or treated with animal injuries, including bites and scratches?
It's very hard to estimate, but between my own practice and the residents that I supervised, it was, I'm sure, well over 500, and could possibly be double that.
Could be up as many as 1,000.
It could be, yes.
Have you qualified as an expert in emergency medicine in the past?
Yes.
You qualified as an expert in the area of forensic pathology and wounds in the past?
Yes.
Is that both in federal and state courts?
Yes.
Doctor, were you asked to review certain materials related to this case in furtherance of coming to some opinions and conclusions about injuries suffered by John O'Keefe specific to his right arm?
Yes.
What did you review in coming to your opinions and conclusions?
Well, I reviewed hospital records and pictures taken of him in the hospital, when he was in the hospital. I reviewed autopsy records, the autopsy report, and photographs taken during and before the autopsy. I reviewed, reviewed the grand jury testimony of the autopsy pathologist. I reviewed affidavit of Dr. Sheridan. I reviewed the town of Canton dog bite reports about regarding incidents.
Action, may we approach?
Yes.
Hey there, Karen Reed, Trial Watchers. This is another law and crime legal alert. Have you experienced severe gastroparesis or other side effects after taking Ozempic or another GLP-1 weight loss medication? The Ozempic lawsuits allege that the drug can lead to severe intestinal blockage and persistent vomiting, and that manufacturers allegedly failed to provide adequate warnings about these risks. Well, True Law, one of our legal sponsors, is helping those injured file a claim through an experienced attorney who helps ensure your claim is thoroughly presented. Just visit www.glp1case.com/LCLive to answer less than 10 questions and check your eligibility to file a claim.
Good after this, I'll report back to session. Please be seated.
So the Commonwealth's objection is overruled. You can continue.
Doctor, you've listed several items that you've reviewed in coming to your opinions and conclusions. Did you also review a toxicological report?
Yes.
And a neurology report, neuropathology report?
Yes.
As well, from the Commonwealth?
Yes.
Based on your review of all of those materials, I don't want to know what your opinion or conclusion is yet, but were you able to come to an opinion or conclusion concerning the injuries specifically to John O'Keefe's arm?
Yes.
Or his right arm? Were there any documents in furtherance of your review from UC Davis?
Yes.
Did you review those as well?
Objection.
Sustained.
With the court's permission, may we display Exhibit 19, please?
Okay.
Doctor, I want to show you a photograph and ask you very quickly, have you seen this before?
Yes.
Is this one of a number of photographs that you reviewed in furtherance of your evaluation of this case?
Yes, it is.
I'd like to just focus your attention on this for just a quick second and ask you, does this accurately reflect the wounds or injuries that you saw on John O'Keefe's right arm in coming to your opinions and conclusions?
Yes, it reflects the injuries that I saw in photographs.
All right. Now, based on your review of all of the data that you've talked about, all of the information that you were given and reviewed, what is your opinion or conclusion about how these injuries were sustained?
I believe that these injuries were sustained by an animal, possibly a large dog, because of the pattern of the injuries.
Could you describe for the jurors, please, on what you base that opinion?
Yes. Well, may I use the?
Sure.
Okay, thank you. There's a number of patterns here. There, on the upper part of the arm, there's parallel lines, and those were inflicted by either teeth or claw marks. So there's a number of patterns that could be teeth or claw mark. And so this is one set right here. This is the one further down, closer to the elbow, is another set of parallel marks. Again, probably most likely from teeth marks. And the reason I say that is, in addition to the parallel marks up here, down here, there's also little punctate, incomplete puncture marks here, little round marks right there that were inflicted by the actual point of the tooth.
Okay, that was my question. What relevance does that have to your determination that this was likely caused by an animal?
Yes, and I can explain in a moment the various kinds of wounds that animals can inflict. But going on with the picture first. So then down right at the elbow, there's another different series of marks that again have linear abrasions up where the pointer is, and then down below some punctate, superficial, round, small abrasions, again representing upper and lower teeth, in my opinion. And then there are some irregular wounds down just below the elbow. And these are all, by the way, on the exterior surface, or what we call what doctors would call the posterior surface of the arm, which is the part of the arm that would sustain defensive type wounds. So if someone were to protect themselves.
Objection.
So sustain. Next question.
Sure. Doctor, if I can ask another question. Just to clear up what you said a little earlier about something wounds close to the elbow, is it your opinion that both the top teeth and bottom teeth could have created some or all of the injuries on that elbow area?
Yes.
Okay, so in other words, instead of the mouth going all the way around the arm, it could have, the top and bottom jaw could have situated itself on this portion that we're seeing, the posterior part of the arm?
Yes, and in this case, the animal did not get a good enough contact.
Objection. Move to strike.
So I'm going to strike that, ask a different question.
Have you seen contact wounds where the animal, a dog for instance, gets a very solid purchase on the leg, arm, part of the body?
Yes.
Okay, is that this or is this something else?
Something else.
Describe that.
Well, when an animal inflicts injuries, the type of injury depends on, in part, on the actual type of contact and how much force is applied by that animal, in addition to any relative movement between the animal and the victim in this case. So, for instance, in the law enforcement dog bites, many of...
Objection.
Right. So the nature, is it notice? Is it, what's one word?
May we approach?
Okay.
You are unmuted.
May I, Your Honor?
Yes.
Thank you. Without getting into any specifics about police canines,
Okay.
does the pattern of injuries that you see appear consistent with an animal or a large dog?
Yes.
Does the number of injuries that you see here relegated to just the right arm, is that also consistent with an animal or large dog?
Yes, it can be.
Is the direction of the injuries, or the consistency of the direction of the injuries, or the parallel injuries, is that also consistent with an animal or large dog attack?
Yes.
Based on everything that we've discussed today, Doctor, is it your opinion, based on a reasonable degree of medical certainty, that these injuries were from an animal attack, possibly a large dog?
Yes.
Have a moment, Your Honor?
Yes.
That's all I have at this time, Your Honor.
Okay.
May we approach?
Okay.
You are unmuted.
Hey, John.
Sure.
Good afternoon, ma'am.
Good afternoon, sir.
Now, testified that you're certified in emergency medicine, is that correct?
That is correct.
And you're not, nor were you ever certified in forensic medicine, is that correct?
That is correct.
Pathology.
Correct.
And when was the last time that you worked at a coroner's office?
1995 in terms of doing autopsies. Yes.
Now, when was it that you first spoke to anyone from defense counsel in regard to your coming in here and testifying today?
May 17th.
Doctor, I am going to ask you to keep your voice up.
Oh, sorry.
Thank you.
May 17th, 2024.
May 17th of this year, is that right?
2024.
So about 6 weeks after this trial began?
I don't know when the trial began.
Now, as far as who reached out to who?
I reached out to a district attorney that I worked with with the LA coroner's office.
And then somehow that person put you in touch with Mr. Jackson, is that right?
Yes.
And was that also on May 17th?
17th and 18th, yes.
So I'm sorry, 17th or the 18th? Which one was it that you spoke with Mr. Jackson?
I didn't speak to him.
You did not speak to him?
Not speaking, not verbal. There was some email communication or text communication.
You communicated with him? Was
Yes.
that the 17th or the 18th?
Yes, both, I think.
Both, okay. And when did you render this opinion as far as what you've testified to here today?
Shortly after he sent me the files.
Now, in regard to those files, you testified in this court a couple days ago, correct?
I did.
And you were under oath at that point, is that correct?
Excuse me?
You were under oath at that point, is that correct?
Yes.
Okay. And when you were asked specifically what materials that you had reviewed, you included a number of items, but you did not include anything about a Dr. Sheridan affidavit, anything about a UC Davis report, or anything about any sort of bite history for a canine that lived or resided at 34 Fairview Road, correct?
That's correct, because I hadn't reviewed them then.
And so since then, 2 days ago, now you've reviewed them, correct?
Yes, I became aware that those files existed, yes.
You became aware of those files? Were they not sent to you previously?
No, I think there were technical difficulties regarding me and the computer and downloading from Dropbox. And so, yeah, so they were, I think they were sent to me, but I think I didn't open them.
Now, with reference to these technical difficulties, did you ever express any of those technical difficulties, or, hey, I can't see the whole file, or there's other things in here that are listed that I can't look at?
No, I wasn't aware.
And so with regard to, as far as your reaching out or contact in regard to this case, how did that come about?
Okay. I saw an article, I believe it was in the Boston Globe, regarding this case. And I didn't, initially I didn't think anything of it. Then I saw an article that indicated that there was some...
I don't asking you anything about anything any article indicated. You saw an article in the Boston Globe about this case, is that right?
Yes.
And how did you come upon it? You have a subscription to the Boston Globe?
I did at the time, yes.
You did at the time. What time was this?
In May.
May of 2024?
Yes.
And how long had you had a subscription to the Boston Globe at the time that you saw this?
It was either a 6-month subscription or a year. I don't remember.
And that was the first time that you had seen anything about that?
First time I paid attention to anything like that, yes.
Now, again, you had testified here just a couple of days ago when I asked you questions about this. Is that right?
Yes.
It wasn't in your testimony just a couple of days ago that the subscription was actually for a year or 18 months.
No.
Remember, not 6 months a year.
So only one person can talk at a time. So was that your testimony, doctor?
No, I don't believe so. I believe that I said it was a 6-month subscription or a 12-month subscription.
In any event, you saw something. That's the first time that you recall seeing anything in the media about this case was in May of 2024?
It was the first time that I recall reading anything about it. Correct.
Now, did you write a report in regard to your opinions that you've testified here today?
No.
And I asked you that a couple days ago as well.
Yes.
Okay, so in the last couple days, you've had time to review a UC Davis report, Dr. Sheridan's affidavit, and any sort of dog bite history, but you haven't had a chance to write a report?
Objection.
Sustained to that form.
You haven't written a report, correct?
That's correct.
Why not?
I haven't been asked to write a report, sir.
Now, did you ever look at anything related to Mr. O'Keefe's head injury?
I looked at.
Objection.
Sustained.
You want to make the approach briefly?
Yes.
You are unmuted.
May I have a moment, John?
Yes.
Now, Doctor, you testified that you had some familiarity with areas of forensic science. You're on some boards, things of that nature. Is that correct?
Yes.
And as a result of that, or any other work experience, are you familiar with a NAS report from 2008?
Not with that limited information, no.
You're not aware of a report issued by the National Association of Forensic Science in 2008 which specifically has a section dealing with.
So I'm going to see you both at sidebar again.
You are unmuted.
So, ma'am, you're not familiar with that report, specifically as it applies to forensic odontology?
So could you say that again, Mr. Lally? What's the report?
The National Academy of Sciences 2008 report in relation to the section referring to forensic odontology.
I'm not familiar with that specific report, no.
So then you equally unfamiliar with the representation that that is not from the NAS report, that is not a reliable science as far as bite marks are concerned.
There are certain aspects of bite marks that have been deemed not reliable. And that I believe has to do with saying that this particular person or animal inflicted this particular bite. But that's very specific, and that's what I'm aware of, that recommendation.
You're not aware of any findings in the NAS report that has led to questioning the value and scientific objectivity of such evidence?
For specifically identifying a bite mark to an individual that might have inflicted the bite mark, I think that's what that applies to.
Okay, I'm not asking, again, this is a report, are you familiar with it or are you not familiar?
I'm familiar with a summary or a abstract of a report that indicates that forensic odontology is not is deemed not reliable when it comes to that particular narrow aspect of forensic odontology.
And so you're not familiar with it also, talking about sample data and collection, analyses of these, interpretation and reporting of results. You're not familiar with those areas of the NAS report as well?
But what specifically, do you have a specific question about that, or?
First question was whether or not you're familiar with the report. You indicated that you weren't.
I did not read the report.
Mr. Lally, let the witness answer one question at a time, one speaker at a time. Doctor, can you answer that question?
Sure. I did not read that report.
Okay. Now, you had written some articles that you were asked about in reference to dog bites or canine dog bites in the emergency department. Is that correct?
Yes, co-authored.
Something that you published or authored or co-authored sometime in the late 1990s. Is that right?
Correct.
And in that instance, you talk about law enforcement dogs and a bite and a hold technique, correct?
Yes.
Now, part of the reason in writing that article had to do with sort of the applied forces and the unique spectrum of injuries from those kind of dog bites. Is that correct?
Yes.
And that spectrum of injuries would include deep puncture wounds. Is that right?
They can, yes.
Severe crush injuries. Is that right?
Correct.
Large tissue avulsions and lacerations. Is that right?
Yes.
Wounds necessitating surgical debridement. Is that right?
Yes.
Bony injuries ranging from cortical violations to displaced fractures. Is that right?
Yes.
Neurovascular damage. Is that right?
Yes.
And other wounds at high risk for infection, correct?
Correct. But we also put a disclaimer in that article.
I'm not asking you about any disclaimer.
Okay.
I'm asking you about what the type of injuries that you were looking at. Is that correct?
Yes, but we saw a skewed population.
You skewed population in a study. Is that correct?
What we saw the worst of the worst.
Or no?
Yes.
Skewed population in the study.
I'm sorry, I don't understand the question.
The population.
We skewed the. Did we skew? No, we reported on all the ones that presented to the emergency room for care. However, a lot of dog bites don't present to the emergency room.
And so from the different cases that you report on within that article, are there any of those cases in which there is injuries to just one aspect of one part of the human body for the victims of dog attacks or dog bites in those cases?
There may have been. That's a summary of the 700 cases, more than 700 cases.
Is it normal in any kind of animal attack for injuries to occur on just one side of one arm of the person that's being attacked, clawed, or bitten?
There are many people who are bitten or scratched.
I'm asking if it's normal, ma'am. That's all I'm
Okay,
asking.
so hold on, Mr. Jackson. Mr. Lally, ask a question, wait for the answer, and then start a next question. Do not interrupt the witness.
I apologize. I don't mean to interrupt, but I'm asking for an answer responsive to the question.
So ask a question and ask it in a manner that you get a responsive answer.
Dr. Russell, is it your testimony that it's normal in an animal attack for injuries to occur on just one side of one arm and nothing else, anywhere else on that person's body?
It can be, yes.
I'm not asking if it can be. I'm asking, is that normal?
I can't say.
It's sustained. You have to ask the question differently.
So from your observations, you looked at various photographs of Mr. O'Keefe, is that right?
I did.
Did you observe any injuries on any other part of his body that you would attribute to an animal attack, whether they be claw marks or bite marks or anything else?
No.
So nothing on his left arm, correct?
Nothing that identified as a dog bite or scratch.
On his legs, is that correct?
That's correct.
Nothing on his torso, is that correct?
That's correct.
Now, you say an animal attack, possibly a large dog, correct?
Yes.
Can you say what type of animal left these marks that you attribute to an animal attack?
Not with 100% certainty, no.
Can you say where physically Mr. O'Keefe was located when the animal attack supposedly occurred?
Objection.
Can you say that?
No.
Okay.
Can you say when Mr. O'Keefe purportedly sustained these injuries from an animal attack?
Well, to a certain degree, yes. Before, it was before death, but not long enough to have a big inflammatory reaction. So yes. So minutes to hours before death.
Minutes to hours before death, but at some point before death, correct?
Yes.
Can you say anything about the breed of dog?
No.
Can you say anything about whether it occurred inside the house, outside of the house, anything like that?
No.
As far as you mentioned some of the different things that you reviewed over the course of your testimony, over the preparation of your testimony, both prior to Tuesday and between Tuesday and today, any of those things contain any forensic reports or phone examinations or anything else related to this case?
Could you repeat that? What kind of examination? Phone?
Any of the materials that you reviewed, whether it be prior, sometime between May 17th and Tuesday, or anything that you reviewed between Tuesday and today, did any of those materials that you reviewed contain any sort of forensic reports or anything beyond the UC Davis?
Yes, I saw a photograph.
So you saw photographs. And to that point, you never actually saw Mr. O'Keefe's body, correct? You just saw photographs?
That's true.
And with respect to the UC Davis report, as far as canine DNA, are you aware that the results of that were that there was no canine DNA on Mr. O'Keefe, on swabbings that were sent to the UC Davis lab?
I'm going to allow it.
Yes, but there was clothing in between.
Okay, but the swabbings came from the clothing with tears in the clothing in the same area as the injuries, correct?
Okay.
Do you know that or no?
I couldn't tell if they came from the wound or the clothing. I thought that they came from the clothing, but...
You couldn't tell by reviewing the report whether or not the swabbings came from clothing or from Mr. O'Keefe's body?
I know the clothing was sent to the laboratory.
You know the clothing was sent to what laboratory?
To the DNA laboratory.
To UC Davis?
Oh, I don't know that. No, I'm sorry.
You are aware that that came back as far as negative for any canine DNA, correct?
That's correct.
Now, as far as the injuries that you observed, your testimony is that both the top teeth of whatever animal this is and the bottom teeth of whatever animal this is both made contact with only the top of Mr. O'Keefe's arm or the posterior of his arm?
Both sets of teeth made contact with certain of those wounds, yes, but not all of them.
But neither the top nor the bottom teeth made any contact that you observed, assuming your issue as far as an animal attack. There's no evidence of any animal attack on the bottom of Mr. O'Keefe's right arm, correct?
I'm not sure what you mean by bottom.
Anterior?
Anterior? That's correct.
And nothing on the posterior or the anterior of his left arm?
That is correct.
And nothing on his legs?
That's correct.
Nothing on his torso?
Correct.
Nothing on his head, is that correct?
Correct.
Now, as far as the marks that you did observe that you do attribute to an animal attack, can you even say with certainty whether or not those marks you feel are bite marks versus scratch marks? Do you have any idea which are which?
There may be a combination.
So is that a no?
Well, no, I think that the ones that had the linear abrasions above the small round punctate abrasions, I believe that those are bite marks from upper and lower teeth.
Now, you indicated that part of what you had reviewed was a dog bite history for a dog from 34 Fairview Road named Chloe, is that right?
Yes.
And there were a couple different instances of that dog essentially getting in a fight with other dogs, correct?
Yes.
And at any point in time, did you see anything in there as far as a dog going after a human in which there was no other dog present?
No.
And there were actually photographs contained within that material of dog bites from that dog, from Chloe, correct?
Yes.
Did any of those dog bites that you saw in those photographs look anything like what you observed in the photos that you saw of Mr. O'Keefe's arm?
No, but. Okay.
That's all, man.
Objection, Your Honor.
No, so the answer is no. You can get back up, Mr. Jackson, but the answer to that question is no. Next question.
So, is it your testimony that from reviewing what you reviewed, that what you observe on Mr. O'Keefe's arm is consistent with an animal attack to the exclusion of any other possibilities?
To a degree of reasonable medical certainty, yes.
So as far as any other sort of blunt impact injuries or other manifestations of how those scratches got there, you're saying, nope, had to be an animal attack.
I've seen thousands of wounded.
What I'm asking is.
All right, so Mr. Lally, I'm going to let the witness answer.
Right now.
I've seen thousands of people with injuries to their skin, and from blunt, from sharp, from all different mechanisms. Those injuries did not look like blunt force injuries.
So it's your testimony that the injuries to his arm don't look anything like blunt force injuries that you've seen before. You wouldn't characterize them as that?
That's correct.
And that's based on some photographs and some other materials that you began reviewing sometime May 17th, 2024.
Yes, I'm an ER doctor. I need to make a diagnosis quickly when I see something, and I'm trained to do that. That's my specialty.
Are you being asked as an ER doctor to come to a quick conclusion in this case?
No.
But you did anyway.
It's how I'm trained.
Nothing further. Very briefly, Your Honor, please report.
Go ahead.
Concerning the forensic odontology report, the NAS report that Mr. Lally asked you about, what is your understanding about the report as it pertains to identifying individuals who left a bite mark? Explain that to the jury, please.
I believe the report says that that is not reliable as it once was thought to be.
Like a fingerprint identifying a human being, DNA identifying a person, or a bite mark identifying a person. The NAS said, not the bite mark. Doesn't work that way.
That's correct.
Has nothing to do with the pattern of injuries that you've seen 1,000 times from animals, correct?
Correct.
You were asked several questions about the injuries that you saw and studied attendant to highly trained canines, police dogs, correct?
Yes.
Very different than just a domestic dog that somebody might have as a pet, correct?
Correct.
And the bite injuries are very, very different as well, aren't they?
That is correct.
You were asked whether or not you were aware, based on UC Davis's report, that there was no canine DNA found on the swabs that were sent to them, correct?
Yes.
Are you also aware that there was pig DNA?
I'm aware of that.
Did that have any impact in did you analyze that at all, one way or the other?
Not to any degree of scientific certainty, no.
But you do know that dogs chew on pig ears sometimes, correct?
Objection.
Sustained.
You've reviewed at least a report, if not a series of reports, that indicate that a particular dog has an attack history, correct?
Yes.
You were asked specifically by Mr. Lally whether or not the wounds in a dog attack on another dog attack where a human stuck a hand in the middle look anything like these, correct? Remember that question?
I remember a question like
And
that.
you said no, but, and then you were cut off. Remember that?
Yes.
Can you finish that answer for us?
Yes. So animals and dogs in particular can inflict a wide variety of injuries on the skin, from just individual puncture wounds to abrasions where there's a scratching of the skin, to where there's actually a pulling away pulling away of the skin from the underlying tissues, a ripping effect. And so there's a variety of wounds that or patterns that one can see from an animal attack. It depends a lot on the thickness of the skin, the movement of between the victim and the animal, and also the power of the animal and the training of the animal. Yes.
So, in other words, not all wounds inflicted by a particular animal are going to look exactly the same.
Correct.
Very dynamic situation, isn't it?
Objection.
Sustained.
Doctor, having seen up to 1,000 bite and claw marks on the human body, and based on your review of the entirety of the case file that you reviewed, including the nature and the pattern and the consistency of the injuries that you saw on Mr. O'Keefe's right arm, what is your opinion to a reasonable degree of scientific certainty about the nature of those injuries?
Objection.
Sustained.
What is your ultimate conclusion and opinion about the injuries that you saw and that you reviewed and that we saw today?
Objection.
Sustained.
Can you tell the jurors at the end of the day what is your opinion and conclusion about those injuries?
Objection.
Sustained.
Can we approach? No more questions.
You are
And
unmuted.
Mr. Lally, you had no more questions?
No, yeah.
Okay. All right, doctor, you are all set.
Okay, thank you.
All right, jurors, we will take our luncheon break.
Court, all rise to the jury. You may be seated.
I just want to know who you have this afternoon.
Just Richard, please, Your Honor.
All right, thank you.
You are muted.
Hey there, Karen Reed trial watchers. This is another law and crime legal alert. Have you experienced severe gastroparesis or other side effects after taking Ozempic or another GLP-1 weight loss medication? The Ozempic lawsuits allege that the drug can lead to severe intestinal blockage and persistent vomiting, and that manufacturers allegedly failed to provide adequate warnings about these risks. Well, True Law, one of our legal sponsors, is helping those injured file a claim through an experienced attorney who helps ensure your claim is thoroughly presented. Just visit www.glp1case.com/LC Live to answer less than 10 questions and check your eligibility to file a claim.
Good afternoon, this court is back in session. Please be seated.
Thank you. All right, Ms. Giannetti.
Thank you very much, Your Honor. Defense calls Richard Green.
Okay.
You raise your right hand. You solemnly swear the evidence you give the court and jury in the case now and hearing should be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Thank you. You'll take the stand.
Good afternoon.
May I proceed, Your Honor?
Yes.
Sir, if you pull that microphone as close to your face as you can so your voice will be kept up, and I'd ask you to state your name and spell your last name.
Sure. Richard Green, that's Green.
And where do you live, sir?
I now reside in Coldwater, Michigan.
What do you do?
I own and operate a company called United States Forensics.
And what is United States Forensics?
Sure. We're a digital investigation firm. We have, we're licensed in Florida and Michigan, but we do cases across the country.
All right. And again, I'd ask you to keep your voice up only because we have an air conditioner there and we have jurors behind me that.
Okay. I'll do my best here.
Yeah, as best you can. Now, you are president of that company, sir?
I am.
In addition to managing the company, what do you do on a day-to-day basis?
Well, I perform the majority of the investigations. I specialize in computer, cell phone, cloud, auto video, metadata media, surveillance systems, things of that nature.
Do you work in conjunction with others?
Certainly.
Describe that, please.
Certainly. Well, we do take cases from individuals. Prefer to take cases from attorneys. We've also worked with numerous public defenders. We've worked with federal public defender. We've worked with law enforcement. So quite a variety of clientele.
Civil cases?
Yeah, civil and criminal. I would put it at about 60% criminals, 40% civil.
Okay. And on the criminal side, you've done both law enforcement and defense, correct?
Yeah, most of the law enforcement ones, though, have been more geared towards civil. It's when they had perhaps they were party to a suit and it was just improper for them to use their own experts. So that's where we've provided assistance.
All right. Now, how long have you been involved in the field of data forensics?
Sure. Well, my first case and testimony was 28 years ago. I'm not even sure we called it data forensics back then, but that was 28 years ago. And then about 16 years ago, started the company United States Forensics and been full-time in the industry since that point.
All right. Now, you'd mentioned that you'd actually testified for the first time 28 years ago. That would have been 1996, if my math is correct?
That's correct.
You were qualified as an expert witness at that time?
Yes, sir.
In order to have been qualified as an expert witness, you must have had experience before that?
Yeah, it was specifically in computers. We didn't do much with cell phones back then. By about a decade or so in computer IT, networking. We actually built a line of computers, a lot of repairs. So I was pretty deep into the computer IT world at that point.
Okay. And you say you formed your company in 2006?
Correct.
And do you work full-time, part-time? What's your schedule?
It's been full-time ever since.
Would you describe for the jury, please, your educational background, your training, certifications, etc.?
Why don't we break it down into smaller segments?
Sure.
Okay.
First, with regard to the training that you've received.
Sure. So that would have to do with Associates of Digital Forensics.
Well, that would more be your education, right? You received an associate's degree in digital forensics?
Correct.
Okay, so why don't we start with education, since you did?
Okay, well, that was part of the work and more or less the formal training to get that degree. the certifications, which again, this all kind of goes hand in hand, but the certification training would be the CCE, which is certified computer examiner from the International Association of Criminal Investigation Specialists. I also have a certification as a computer crime related investigator, cybersecurity, as well as computer first responder. The training aspects over the last 18 years on really a daily basis, when I've worked, I've participated in listservs, done research into the newest developments in the computer forensics, and really on usually a weekly basis, we'll target some training seminar. I found in this business, even if you took us like 6 months off, you would start to get behind in this business. It changes that rapidly, and you really need to do continual training.
Okay, and again, your voice trailed off a little bit at the end, so.
I'm sorry.
I'm sorry to keep reminding you, but I just want to make sure everybody hears. With regard to the amount, your caseload at USA Forensics, can you give the jury some idea of how many cases you handle on a yearly basis or have handled historically?
Yeah, we average, I'd say between 100 and 120 cases a year. We probably get inquiries to about 3 times that amount.
Okay. And have you testified as an expert witness in the area of computer forensics since that 1996 first appearance?
Yeah, we testified about 24 times in various state and federal courts.
Okay. And when you say various states and courts, is that state court, federal court, both?
Both.
Now, directing your attention to September of 2022, were you contacted by somebody to become involved in this matter?
Yes, sir.
Remember who that was?
I believe it was Miss Little.
What were you asked to do?
Well, there was 3 cell phones related to this case, and to provide relevance with the data on those phones as related to the incident on January 29th, 2022.
Okay, and were you aware of the owners of those 3 phones?
Certainly. It was Karen Reed, John O'Keefe, and Jennifer McCabe.
Now, I'd like to ask you first, if I can, about John O'Keefe's phone. How did you receive the data from that phone, if you remember?
Yeah, we received what's called an image file, and that's a forensic term that we use. Essentially, it's a copy of the data that's encapsulated into a single file. In this case, it was a zip file.
Did you examine that data?
I did.
What were your goals during your examination of John O'Keefe's phone? What were you looking for?
Well, initially what was reported was the location data. We wanted to get an idea of when he had arrived and anything else that we could tell from that as far as location.
And when you say when he arrived, do you remember the location that you were asked to learn when he arrived?
34 Fairview.
In Canton?
Yes, sir.
All right. Were you able to determine, as a result of your examination, approximately when his phone arrived at 34 Fairview Road according to the location data?
Yes, sir.
And how did you do it?
Sure. Well, I say we, so that's proverbial we. I extracted the location cache data, which is stored in the on your phone, and it's in the certain location. We exported that out, and then we use a tool called CellHawk, and we import it in there, so it can take literally, thousands of data points and automate that process to specific GPS locations, and just as importantly, the range of accuracy that location is reporting.
Okay. So according to the process that you underwent, what time did the location data indicate that John O'Keefe's phone arrived at 34 Fairview on January 29th of 2022?
So the first one right to the driveway was at 12:24 and 28 seconds.
12:24 and 28 seconds.
Correct.
Now, if I asked you to filter John O'Keefe's location data within an accuracy of 3 feet using Cellhawk. Could you try to do that?
Yes, sir.
In fact, did you try to do it?
I did.
When?
Last night.
Who asked you to do that?
You did, sir.
I may approach, Your Honor?
Yes.
So I placed that document before you. Could you familiarize yourself with that and look up at me when you're done?
All right.
Recognize that?
I do.
What is it?
So this is a screenshot from the Cellhawk program. It has a kind of a central box here that says database settings, and this is where we apply a certain filter.
And what filter did you apply?
This was for the accuracy of less than or equal to 3 feet.
With regard to what?
Oh, John O'Keefe's location data.
Is that an exact? Is the data on that document exactly what you received when you used the Cellhawk program to filter the data?
Yes, sir.
I would offer that, Your Honor.
No objection.
No objection, sir.
Oh, I'm sorry. I thought you said objection.
So you need to give it to Madam Court Reporter?
I'm all flustered. Sorry.
6:52.
And if the witness could have that again.
Thank you.
With permission, I'd like to publish that, Your Honor.
Okay.
Okay, so, Mr. Green, what are we looking at?
Okay, so that is the screenshot from the Cellhawk.
And what can you tell us about what you learned from that exhibit?
Well, yeah, I'll just use the pointer here, might help. You can see up in this part here, where this is where we apply the filter for 3 feet or less. That'd be the accuracy. And then it actually returns 0 results, meaning all of the data within there had an accuracy rating higher than that 3 foot. It could be 5 meters or 10 meters, but none of it was granular enough at a 3 foot or less accuracy level.
Oh, and if you had inputted accuracy of within, say, 500 feet, what would you find?
Yeah, you would see then a large number of circles, each circle representing the meters that the accuracy would be related to. What's really important to understand, though, is you don't want to look at just the middle of the circle. That accuracy indicates it could be anywhere in the circle. So if you saw one and it encompassed 2 or 3 houses, you could only draw that inference of somewhere in that circle. So it's kind of like how the hurricane, they say don't just look at the cone, right? Because it could be different than that. Also, the accuracy, this is Apple's best guess of what the accuracy is. So it could actually be different than that. It's Apple is using a number of services, and they're giving back the best estimation that they can for the accuracy.
Okay, so we've talked about the location cache data and where it put John O'Keefe's phone in terms of arriving at 34 Fairview, but was there also Apple Health data on John O'Keefe's phone during that time?
Certainly, yes.
Is Apple Health data generally accepted within the forensic science community as being reliable?
Well, the Apple Health data comes from something called Health Kit, but it's integral to the iOS system. So anyone that has an iPhone probably seen Apple Health data, and it's known to have extremely valuable data that the forensic tools work with and present to us. The degree of accuracy, it depends on the type of data that's being pulled out on the artifacts. For example, steps are known to have an accuracy of around 98%. on the actual steps occurring.
So if the Apple Health data returns, for instance, steps, 20 steps within a certain time period, 98% of the time Apple's going to be right?
That's what studies have shown.
All right. May I approach the witness, Your Honor?
Yes.
Do you want this back? Okay.
Mr. Green, I've placed another document before you. Do you recognize what that is?
Yes, I do. This is this lists out Apple Health data for that was from John O'Keefe's phone on January 29th, 2022.
All right. That came from the data that you received, the image file of John O'Keefe's phone, correct?
That is correct.
I would offer that, Your Honor.
Mr. Lally?
No objection.
Give back to me. And with the court's permission, may I publish that, Your Honor?
Okay.
Specifically, I'd like to start with page 2, record 2. Okay, Mr. Green, are you wearing the right glasses to be able to see the scene?
Yeah, I probably need bifocals here. I keep switching glasses, but
are you able to read what is on the screen? And if it's easier, you can look on your document in front of you. It's page 2, record 2.
yeah, I think I'm going to have to do that. I can probably still see good enough to do the laser one. I'm sorry, which record is this you're looking at?
Page 2, record number 2.
Okay, yes, I have that in front of me.
Okay. What does record number 2 show on page 2 of John's Apple Health data?
Sure. So this is the number of meters. It's listed as 87.74, and the time is listed between 12:21 and 10 seconds. And there's milliseconds after that, but I'll just round it off to the second if you don't mind. So 12:21 and 10 seconds to 12:24 and 22 seconds.
Okay. And you said that it showed 87 meters traveled during that time period?
Correct.
And with regard to that same time period, 12:21 and 10 seconds and 12:24 and 22 seconds, please turn to page 5. And Mr. Bates, if you would zoom in on record number 2.
I have that.
Okay. What does record number 2 reflect?
Again, it's the same time period, and the steps taken is recorded as 80 steps.
Okay, and you said the same time period, so again, 12:21:10 to 12:24:22, correct?
Correct.
All right, now I'd like to direct your attention to page 4, record number 1. And if Mr. Bates, you could post that. And when you're ready, Mr. Green, if you could tell the jury what that reflects.
Sure. So this indicates 3 sets of floors. That represents elevation change. So it doesn't indicate to us up or down, but 3 steps. And the time period for that is 12:22:14 to 12:24:37.
Okay, did you say 12:21:14 to 12:24:37?
Yeah, 12:22:14 to 12:47:37.
I see. And with regard to all of this data, the 80 steps and the 3 flights of stairs that you mentioned, is it possible to pinpoint where within the time frame that's given those steps or flights of stairs were ascended or descended?
No, the most granular we can get is the time period, and it doesn't signify as any more likely at the beginning of the time period than at the end of the time period than at some time in the middle. And if you think logically, like distance traveled, that doesn't happen at a split moment. It happens over a period of time. So it's time is a factor in that equation, and this is how the Apple records that data. You got to look at the time overall.
Okay, so you don't know if the steps are bunched up toward the beginning or toward the end or more evenly spread out?
No, I would not be able to tell you that.
Now, Now, we've discussed the Apple Health data. I want to go back for a second to talk about the location data on the iPhone. Does that data that you've already talked about in terms of the arrival time that it gave for John O'Keefe's phone at 34 Fairview, does that arrival time fall within or outside the range of 12:21 and 10 seconds, or 12:21 and 10 seconds and 12:24 and 37 seconds?
Well, there is that certainly indicates an overlap, but the health data is ending after the arrival, and we can.
Now, I'd like to discuss with you the concept of clocks used by apps on an iPhone.
Sure.
Are you aware of the 3 different clocks that are used by iPhone apps?
I am.
What are they?
We have you have 3 separate internal clocks. You have a monotonic clock, a baseband clock, and a wall clock.
Okay, and is the wall clock also called the display clock?
Yeah, that would be also a common name for that.
And what is the significance of the existence of 3 clocks regarding, different times that may show up within these records?
Sure. Well, app developers can access Apple program library, and they can call upon any of the clocks to use within their apps.
Okay. Now, in your investigation and examination of this case, did you find examples on this phone of different clocks being used?
So in this particular case, I had reprocessed the data with the newest version of the Axiom forensic program. It's similar to Cellbrite. There are competitors to Cellbrite, and we use both programs. And this newest version had a feature in there where you can filter for the Waze application. And again, just following up and seeing how this functioned, we filtered for the Waze application. And for the first time, we saw this monotonic timestamp being related to the Waze application.
Okay. I want to show you Exhibit 640, if I may approach, Your Honor. Sure. I've placed Exhibit 640 before you, sir. Do you recognize what that is?
Yes, sir.
What is it?
So this is a screenshot from the Magnet Action program I was referring to. It's the 8.1, actually it looks like 4287, but.
Keep your voice up, sir.
I'm sorry, yeah, so it's the newest version of the program, and we have it filtered for the Waze app, and it's giving us the timestamps associated with it.
Okay. With the court's permission, may I publish that?
Okay.
There you go.
And first of all, are you, no, that writing is probably too small. I can't read it.
Okay, thank you. I'll go off of this one.
There we go. With regard to what we are looking at there on that part of the screen, what are we looking at, Mr. Green?
Okay, so this is listing details of this particular artifact, and you can see that this is bundled. The com.waze.iPhone, that's a standard bundle type name where it always starts with com dot and then the application reference.
And what does that mean? When it says, it's highlighted on the screen, com.waze.iPhone. What does that mean that we're in right now?
Yeah, well, this is an artifact specifically related to the Waze program.
Waze app.
Yes, sir.
All right, go on.
Okay, and we can see here our entry for the monotonic time, the baseband time, and the display time.
And what did you notice about the relationship of the 3 of those?
Certainly. Well, most noticeable about this, the monotonic is running a little over 3 minutes ahead of the display. So that, I think it's 3 minutes and 1 second, give or take a little. So, in a lot of cases, 3 minutes may not seem like much. But in this case, this struck me as important to. Objection. Move to strike.
Sustained. I'm willing to strike that. Next question.
Okay. I apologize.
That's okay.
You can hand that back to Madam Court Reporter.
Certainly. Thank you.
And I'd like to go back to the Apple Health data, Mr. Bing, if you can put that back up. And this would be page 2, record number 3. And you don't still have that in front of you, do you?
Actually, I do.
You do?
I do.
Page 2, record number 3, sir.
Yes, sir.
What does that show?
All right. Okay, so this is another entry from John O'Keefe's cell phone data, and this records 25.46 meters occurring between 12:31:56 and 12:32:16.
Okay. And directing your attention to page 5, record number 3, if you could tell the jury what that shows, and if we could have that displayed as well, Mr. Vince.
Certainly. So this is directly related to the distance, and this is recording 36 steps, and it's the same time period, 12:31:56 to 12:32:16.
Okay. So we have 36 steps being taken according to Apple Health data on John O'Keefe's phone for a time period that ends at 12:32:16.
Objection.
Sustained. Ask it differently, Mr. Manning.
With regard to those 36 steps, do we know where within that time frame they were taken?
Sure. Let me reread that here. We January 29th, 2022, 12:31:56 a.m. It's actually 12:31:56.109 a.m. and 12:32:16.507 a.m.
Okay. All right. So now I'd like to switch, if we can, to Jennifer McCabe's phone and your analysis of that. During the course of your examination, when you reviewed data from her phone, did you find a particular artifact of interest?
Yes, I did.
What did you find?
We found a Google search that happened. First of all, the search was how long to die in cold, and it happened at or before 2:27 a.m.
All right. Where was that search found?
Sure. So the artifact on that was called a Safari Suspended Tabs artifact, and there's a database associated with that called the Browser DB database, and in a company file, which is by the same name but ends in WAL, which stands for Write Ahead Log. And the write ahead log is where the data first gets written to, and then at certain points, that data then gets committed and written to the main database.
All right. So that, if I'm correct, that browserstate.db/wall file, that's a temporary file, right?
It's temporary by nature, but it's not. It's integral. It's part of the way the SQLite functions. So it's not like a throwaway file. It's part of the way the whole system works.
And is it helpful to you when evaluating artifacts?
Certainly, yeah. Just by nature of it, we'll find a lot of the newest artifacts in that WAL file.
Now, how do you determine the timing in terms of the timestamp on the browserstate.db WAL file?
Sure. So the WAL file has different rows and columns. You can kind of think of it as an Excel spreadsheet. And in this one particular column, it was a time column. That'd be the nature of the data going into it. And this the heading on this particular one was last viewed time.
Okay. Regarding that Google search for HOS long, and I say HOS, HOS long to die in cold, found in the browser state DB WAL file, what was the date and time for that artifact?
Sure. So that's recorded in what's called an Apicocoa time, and it's actually the number of seconds since January 1st, 2001. So you end up with this large number, and that gets converted to present to us something that's human readable, and then you have to apply the offset for the local. So once you do all those calculations, that's where we get the January 29th, 2022 at 2:27 in the morning.
The specific, do you remember the number of seconds after?
I believe it's 40 seconds.
2:27, 40 seconds.
Yeah.
Okay. And in what state did you find that artifact?
Yeah, so the specific artifact, or it comes from a record, and the record number on this is 4028, I believe, and it was in a deleted state.
Okay. Now, what what would you normally expect to find along with the artifacts, sir?
So you'd have the date and time, the URL, which the way the URL presents itself, we know that it's a Google search, but you also see a history of other places that tab has been.
And with this particular artifact, did you learn the full internet history of websites related to that record?
No, that wasn't possible. We were only able to get the one website. I would say.
And I'm sorry.
I'm sorry. Go ahead.
I interrupted you. Sorry.
Well, no. So we definitely got the one artifact, the Google search, and we have the time related to it, but we do not know everywhere else that tab had been.
What significance was there to you about the fact that the full internet history related to that record could not be recovered?
Well, I wanted to do a little deeper dive into that, and so I used some various other database specific tools. One was called Belkasoft X, which has an excellent database viewer in it. Sanderson Forensics, which is known to specialize in this type of work, and
ArtX?
I'm sorry?
ArtX?
You saved me. Yes, ArtX, which is a program known in the community for research.
And how did you sort of cross-reference the three of those together? How did you use them?
Yeah, so all three of those tools, along with Axiom and Cellbrite, which I did, they do have a low-level SQL viewer as well. So I looked at the data with all 5 of those tools, and I found it to be consistent amongst all the tools.
And in addition to using those tools, what else did you do?
So I wanted to get a little more context. One thing with this artifact, it is deleted. And one thing about deleted data, sometimes you get it all back, sometimes you don't, sometimes you get a fragment. Deleted data makes it very difficult to give you the whole picture of what's happening. So in this particular case, I wanted to see what other artifacts were around this time as it related to web history, and particularly this browser database file.
And so what do you compare the 2:27 a.m. search to in order to gain more information?
Exactly.
I'm sorry.
What the information was. So what we found is that when we looked at a particular URL, a particular website that was visited, and then searched using that URL, the browser state database entry is the last entry in all of that. So we could see searches, videos playing. There's an artifact called knowledge C that records the user's activity, but the browser state is the very last entry on the items that we observed.
And did you find other examples of that you can speak to before this jury?
Yes, I believe we have one printed out there.
Okay. May I approach, Your Honor?
Yes.
Okay.
I placed the document before you, sir. If you could familiarize yourself with that and look up at me when you're done.
I have it.
What is it?
Okay, so this is another screenshot from the Axiom program. And it is showing a search that we conducted for raining men. And then it takes that search, and we have a couple different items on there. We set the date to begin in 1970 and ending in 2100. In other words, we only wanted to see artifacts that had dates associated with them. And then we listed them from the newest date to the oldest date. And this particular one, again, it ends up with the Safari suspended tabs artifact being the very last in the series of dates and times.
All right, I'd like to go through that, but first I'd offer it into evidence, Your Honor.
Okay. Any objection?
No, Your Honor. There you go.
It's 6:54.
And with the court's permission, may it be published, Your
You
Honor?
want this?
Yes.
Okay.
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 So we have a number of columns here. Could you explain to the jury what's going on with that exhibit?
Certainly. So I'm gonna switch glasses back here. Forgive me.
Do you need the light on, sir, or are you okay?
No, I'm fine, Your Honor.
Okay.
Thank you much. I can certainly do this. So we are looking at here web-related history, and also I have the filter turned on for application usage because there's some log files, sort files that the iPhone keeps track of to record user interactions, and that can give us a idea of the history as well. And then, as I mentioned, we have it filtered so that it's only showing dates, that dates existed, and we took the earliest possible date to a date way in the future. And then it's listed, and next to the date and time, you'll see a little arrow, and it's skinny at the top and big at the bottom. That tells you it's going from smallest, earliest time to latest time. And this particular view is showing us the last of that series, because what's relevant and really important here is that the Safari suspended state tabs ends up being the last of the entries related to that, not one of the beginning of the entries related to that.
And what is the significance of the Safari state tab being the last entry? What does that tell you?
Yeah, well, so it tells us the internet history happened before that, and the purpose of this tab on at least this particular iPhone with this very specific iOS version is to record the state of that tab when the user left that. And the whole purpose of that is if you're on Safari, you're on a website and say you have to take a phone call or answer a text message and you navigate away from the Safari app, when you come back, it remembers where you were and allows you to pick off from there. It also allows you to hit the tab button and see what other tabs you might have open and navigate to one of those tabs.
All right, so as I see the last tab, am I correct that the time is 1:29:22, same day, like 2:27 and 38 seconds? Is that what it says on your?
I'm sorry. I'm definitely getting a pair of bifocals. I apologize here. I feel a little silly. Yes, on this particular one. So that is just moments before the Google search artifact.
The one that you previously talked about, the How Long to Die.
How long to die in the code, yes.
But all the other history of this particular artifact was before that time, correct?
Correct.
So with regard to what that tells you about when the It's Raining Men was either searched or accessed, was that at, after, or before 2:27 and 38 seconds?
I'm sorry, can you?
Sustained.
Okay, if you say it one more time.
All right, let me try and put it a different way. Given the timestamp of 2:27 and 38 seconds on January 29th for that Safari suspended state tab with the It's Raining Men, what did that tell you about the timing of when It's Raining Men was accessed by the user?
Yeah, well, so the indications would be that that tab was brought up and then went away from to do another tab. So it can happen less than a second. It doesn't take long to open up a tab and start a new tab. Can be done very quickly.
I'm not really phrasing this the right way to get what I want. What I want is the timing of the interaction with It's Raining Men by the actual iPhone user. When did that happen?
Well, certainly, all the activity that we have is all prior to the recording of that timestamp in the browser state.
All right. Now, with regard to this particular example where the browser state DB is the last entry, so the activity happened before, was that unique on this phone, or were there many examples of this?
No, I found many examples of this exact behavior.
All right. Now, given your findings in researching these issues and how this user used this iPhone with this iOS, do you have an opinion to a reasonable degree of scientific certainty as to the timing of that search for Haslong to die in cold?
Objection.
Sustained.
Do you have an opinion to a reasonable degree of scientific certainty as to when Haslong to die in cold was searched?
Objection.
Sustained. I can see you at sidebar.
Thank you.
You are unmuted.
Do you have an opinion as to the timing of that first search for Haslong to die in cold?
Yes, I do.
What is that opinion?
That would have happened at or before January 29, 2022 at 2:27:40 a.m. in the morning.
And what is the basis for your opinion?
Again, by how this particular phone operates with that exact operating system and comparing it to other data on that phone and the way it presented it out itself is all consistent with that search happening at or before that time.
And what opinions or conclusions did you reach regarding how, if any, how the 2:27 a.m. search was deleted?
Well, we know that that's in a deleted state. And importantly on that phone is when I say, I keep using the proverbial we, I found a lot of other that would have been used or deleted artifacts between the midnight and the early mornings on January 29, 2022.
Okay. Are you aware of any internal mechanisms that could have caused that deletion?
No, not in this particular case. I know of no mechanism that would have done that.
All right. And you mentioned other deletions on the phone. I want to show you what has been marked, if I may approach. Sure. MMM for identification.
Okay.
Do you recognize what I've placed before you, sir?
Yes, sir.
What is it?
Okay, this is from Cellbrite. It's a program, again, like the Axiom that processes data. And this is this lists out a, 623, this lists out a deleted call record.
Okay. Are you able to see from that record to whom the call was placed?
Yeah, well, we have the number, and I won't necessarily read it out loud here, but through searching, and this is from the phone of Jennifer McCabe,
Yeah.
But through searching for that the number, I was able to see that it went to, you want me to say the name?
Sure.
Yeah, Uncle Brian A.
Oh. I would offer that into evidence, Your Honor.
Same objection as before, Your Honor. As when this was, may we approach?
Okay. So, folks, we're trying to streamline the exhibit numbers. It looks like this may already be in evidence. It's one of 4 different numbers, so I sort of wanted to keep it with that. We are so far removed from where it was that this will just come in as the next exhibit. So you will technically have it in evidence twice.
Okay.
Exhibit 655. Thank you. May I approach again, Your Honor?
Yes.
There's one final document before you. If you can identify that for the jury, please.
Yes, this is another report generated out of Cellbrite. It's based on Ms. McCabe's cell phone data, and this lists out the call log with a number of deleted items and a number of live items.
I would offer that, Your Honor.
If I get to see.
Sure.
It's fine, Your Honor. I think it's already in evidence as well, but.
So
actually, it's, I confirmed it's not. It's not yet in evidence. We looked at the exhibits that were specified, so.
They're
656. Thank you. If you could hand that to the witnesses, if I could have the first page of that exhibit displayed. This is, okay, with regard to that exhibit, Mr. Green, what did you find that was unusual, if anything?
Objection.
sustained. Ask it differently, Mr. Yannetti.
Yes. What did you find of note?
Certainly. What was the time frame of the deleted records? Now, I'll just talk about this particular report here. It starts at 5:33:47 in the morning, and on the second page, we see it ends at 8:50 and 15 seconds, again, a.m. And then the normal recalls, what we call live data, then begins at 8:59 and 34 seconds and goes on throughout the day with no additional deletions.
And am I right that those are all, that's the call log, those are all phone calls?
Correct, yeah, this is the call log.
And what was the difference between the calls that were at 8:59 and after on January 29th, 2022, and the calls that were at or before 8:50 a.m. on January 29th, 2022?
Yeah, well, it's the state they were found in, deleted versus live data.
I'm sorry?
Deleted data at the earlier time and live data after the 8:59:34.
What percentage of phone calls were found deleted on Jennifer McCabe's phone prior to 8:50 a.m. on January 29th?
So all right, I have to see you. Take this down for a minute, please. I have to see counsel.
You are unmuted.
So, Mr. Green, I'm not sure if that question was clear or if you understood it. If it's not, please let me know. But I had asked you from the first recorded call there that was listed as deleted until 8:50 a.m. or so, what percentage of calls were deleted on Jen McCabe's phone within that time period?
Yeah, so we found no live data, so 100% of them would have been deleted.
Now, are you aware of the term spontaneous deletion?
No, sir. I know what the individual words mean, but in relation to digital forensics, I'm not familiar with that term.
And do you have an opinion as to how those calls would have been deleted from that phone?
Those would have been user deleted.
I may have a moment?
Sure.
No further questions. Thank you, sir.
Good afternoon, sir.
Good afternoon, sir.
Do you know who Miss Jessica Hyde is?
I do.
Are you aware that she wrote a report in relation to this case?
Yes.
Specifically in regard to the Google searches for Ms. McCabe's phone that you were just talking about?
Yes, sir. It was very specific about that search.
And have you had a chance to review that report?
I have.
You also know who Ian Whiffen is?
Certainly, yes.
And are you aware that he wrote several reports or submitted several items in relation to, again, the exact topic that you're testifying about in relation to the Google searches on Ms. McCabe's phone?
Yes, sir. I understand that.
And have you had a chance to review those materials as well?
Yes, sir.
You understand that they both disagree with what your opinion is in relation to those searches?
I absolutely understand that, sir.
Now, just as far as your qualifications and certifications go, I'm just having a difficult time. From the certifications that you have, at what point were you, or what, if any, certifications do you have with reference to Cellbrite as a tool, as far as your use and interpretation of data from Cellbrite?
Certainly. So my certifications are much more broad. They have to do with a lot of the fundamentals and how we conduct the investigations and what tools we should know and when we need to know we need to do more work and such like that. Cellbrite, I do not have any specific Cellbrite certifications. They offer many of them. However, I have participated in, God, I can't even count, hundreds of their training events that they offer, both Cellbrite, Axiom, Belkasoff. They all provide the community with fantastic support as far as that. And although certainly a class can be very good, but you really need to stay up to speed, you've got to participate in the most recent understanding being put out there. Even in the changes of their tools will change from one version to another.
And so, to the point, as far as you have no certifications in regard to Cellbrite as a tool and how to use it, those kind of things?
That's correct, sir.
And in this specific instance, at any point, did you reach out to Cellbrite to go over sort of your findings or your opinions in relation to this search?
I did.
And who, if anyone, did you speak with from Cellbrite?
Yeah, as close as I can remember, I know it was Leo, and I believe it was Santos.
And do you know what part of Cellbrite they work in or what they do?
Well, he was in the technical support, and contacted him. He had informed me that they had elevated this up to some higher level technical support when they came back. His comments to me, if you want to hear them, was that this. Okay.
Capture his comments, but at some point,
I understand.
You talked to technical support, is that correct?
Absolutely.
And they indicated that they would refer you to actually Mr. Whiffen's team?
No, sir, they did not.
So you weren't told that you were referred to Mr. Whiffen's team, and you weren't contacted by anyone from Mr. Whiffen's team?
No, and I forget the exact date, a couple weeks ago, maybe a month ago, out of the blue, I got an email from Ms. Whiffen saying, and I can't, I don't want to misquote them, but certainly I got an email from
I'm not asking
him.
you about any specific conversation
Okay.
you had. What I'm asking, and I'm asking about a time period more back in 2022.
I'm sorry, I couldn't quite hear you.
Back in 2022, did you reach out to Cellbrite in relation to this search and your opinions related to it?
Yes, sir.
And at that point, was that the point that you spoke to someone from technical support?
Yes, sir.
And at that point, did someone from technical support actually refer you or tell you that they were referring you to Mr. Whiffen's team?
No, sir, I had absolutely no idea about that.
So no one from Mr. Whiffen's team reached out to you, and then you just never called them back? That didn't happen?
Not that I'm aware.
Now, you were asked to look at a couple different phones, and I'm assuming by counsel for the defendant, correct?
Can you say that once again? I'm sorry.
You were asked to look at 3 different phones is what your testimony was, and I'm assuming that was by some counsel for the defendant, correct? No one else asked you to look at these phones, correct?
Oh, correct. Yes, it was from the defense asked me to, yes.
And so the phones that you were asked to look at were Mr. O'Keefe's phone, the defendant's phone, and Ms. McKay's phone, correct?
Correct.
Now, as far as Kerry Roberts' phone, were you ever asked to look at that?
No.
And with respect to the defendant's phone, was there any GPS location information or data that you observed in her phone?
So we had an indication that location had been using, there was something called Apple Map tiles, and those probably when you use the Apple Map app, that it in order for it to work, it will create these little tiles or little pieces of pictures, and they get stitched together to give you the view that you see on your phone. Now, for that had to be working, we know location data had to be working. This particular location data, the location data cache, is known to only be present on the phone for a couple weeks. Now, what I don't know, and Mr. Lally, if I'm going too far, just please stop me. What I don't know are what measures were taken to preserve that data, whether it was put in airplane mode, whether the location services were turned off, whether it was put in a Faraday bag. And quite frankly, Mr. Lally, I don't know if they did all the location data would have remained or not. I've never tested that, but all indications, it would have had location data on the day that it was seized, because we received the Apple Map tile. But when I got the full extraction, there was no location data there. Now, I did observe. So
there was no GPS location data on the defendant's phone, correct? From what you observed.
And again, if I'm, I did find deleted location data from April of 2022.
Okay. Now, with respect to the defendant's phone, did you also find deleted web history data from the afternoon of January 29th, 2022?
No, I'm sorry, I didn't observe that.
Didn't observe it, or didn't look for
it? You know, I really don't have a recollection if I specifically looked for deleted data. I don't believe I did. I don't know if I would have had to have a cause to.
Now, with reference to, you were asked some question about location accuracy within 3 feet. You did some sort of thing last night on CellHawk using that tool. Is that correct?
Certainly.
And you were asked to do that after Trooper Guarino testified yesterday. Is that correct?
I understand he testified yesterday.
And so with relation to you creating sort of that document, and that's now been marked as an exhibit, was that something that Mr. Yannetti asked you to do in relation to Trooper Guarino's testimony yesterday?
Well, in all fairness, you need to ask Mr. Yannetti. I could make an assumption here. I mean, if
I'm not.
I don't know quite.
I'm
not trying not to answer you. You know, but I was asked by Mr. Yannetti to perform that search.
So, Mr. Lally, please be cautious of that.
Yes, sir. So, Mr. Green, with respect to that 3 feet of accuracy, are you aware that what Trooper Guarino was testifying to in regard to that had absolutely nothing to do with phone applications or anything to do with data from a phone or a CellHawk or a tool or anything like that?
No, I don't know the full extent of what Mr. Guarino would have been testifying to.
And so you're not aware that his testimony was actually in regard to reviewing cruiser camera video from the Canton Police Department and photographs of where Mr. O'Keefe's body was, and then mapping that using GPS latitude and longitude. Objection. Based on that within a 3 feet accuracy.
The objection's sustained. Ask it differently.
Are you aware of any of what Trooper Guarino testified to yesterday?
What you're mentioning, I may vaguely be remembering, and again, I'm not trying to not answer your question exactly. My conversation with Mr. Giannetti is 3 foot when it comes to GPS data. Can you tell 3 feet from GPS data? And no, it's not known to be that reliable, and particularly Apple location services. How that applies to the trooper's testimony, I can't say with specificity. I'm happy to opine on location data, though.
There's no question.
Okay.
Sir, but thank you. I may have a moment, Charlie.
Sure.
Now, sir, with reference to Safari and deleted tabs, isn't it true that there is no way for a user to delete a tab, only to close it? Do you agree with that?
Yeah, well, when you close a tab, all right, you're taking it out of the active state, and it's going to an inactive state that some people could call deleted. Now, the Safari history allows you to go in and delete history by certain date ranges, but you can also go into specific websites that you visited and delete those. Now if you want me to continue, the WAL file itself, you can't open up a WAL file and say, oh, I want to delete that record. But functioning the phone through the user interfaces will have an effect of deleting data within that WAL file.
Isn't it also true that Cellebrite uses that red X to annotate that the record is no longer active and has been recovered? It should then make it incumbent upon the examiner, being you in this instance, to determine if it was actually deleted, correct?
Yes, sir. Thank you for asking. It's yes.
That's all I'm asking, sir.
Okay. All right.
Now, you stated in your affidavit, in your testimony, that you used the Sanderson SQLite or SQLite Forensic Explorer to examine the Safari tabs DB associated with the WAL file log. Is that correct?
Yes, sir.
Now, in your analysis using that Sanderson Forensic Explorer, was there an indication that House Long to Die in Cold was found in the WAL file?
Yes, sir.
Now, with regard to that, did you independently verify the cause of that timestamp that you observed there?
Yes, sir.
Now, is it your interpretation that the timestamp means the search appeared at that time solely based on the naming of the field in the database?
No, sir.
Now, can a WAL file contain items that are so new that they're not yet committed to the database?
Yes, sir. That's the purpose of it.
So the WAL file holds the newest information until it's merged to the database, including additions, deletions, changes, all of those items, correct?
That is correct.
Now, according to your affidavit, the device was in active use between 2:23 a.m. and 2:31 a.m. And just to be clear, I'm talking about Ms. McCabe's device, correct?
Correct.
And what other searches did you see at that time, and where were they performed?
I'm sorry, can you repeat that? I couldn't quite hear you.
Searches did you observe in that time frame, and where were they performed?
Well, there were a number of websites, including the Rainy Men exhibit that we did. There was Ozone Basketball, I believe. There, Hockermont, Smith. And I can tell you that those, similarly, the last entry with those there is the browser state DB file. It's not at the beginning, it's not at the end, and I have a couple thoughts on why that may be in regards to Ms. Hyde and Ms. Whippen. I'm happy to share those with you.
I'm not asking you anything about that, sir.
Very
What I'm
good.
asking is it possible for a change request in the wall to a SQLite database pertaining to one particular field, leaving the other fields as what they were previously?
I want to answer your question as well as I can. So can you repeat that one more time?
Sure. Is it possible for a change request in the wall to a SQLite database pertaining to one particular field, leaving the other fields as what they were previously?
So I'm having a little trouble answering this. So if I'm understanding correctly, when the wall file gets written to the database, and could that have made the change ending with this deleted record? Is that the question? I'm sorry. I want to answer you. I'm just a little lost on how you're asking it.
And the question?
Sorry?
Do you not understand the question?
Why don't you move on, Mr. Mayor?
Is it possible that the URL field, which has the website name, was updated to the newest search while the timestamp retained the original search? Is that possible?
No, not the way on this particular phone in this particular iOS, and also with the user interacted with it, that it would have been at the 227 or before. The way this very specific iOS was happening, that is consistent with all the other ones that I observed out there on the phone related to specific web searches and activity.
Is it possible that the search for How Long to Die in the Cold at 6:24 a.m. was the most recent search completed in the tab?
Oh, well, not in that tab, but I certainly agree with you that there was a second search done at around that time.
Now, is it also possible that the search that you assert took place at 2:27 and 40 seconds in the morning is the same as the search that took place at 6:24:51 a.m. for that same search?
Yeah, that's inconsistent with the actual data I'm seeing on this actual phone with this precise iOS version.
Now, as far as the search in Safari with the string as far as the smotot.apple.com included, is it, you recall that search as far as being a suggestion from Apple, from the iOS, as far as the search with how long to digest food?
Okay, I didn't hear your whole question, but I heard the last part about how long to digest food, so I can opine on that. So my feeling on that is when the How's Long to Die and Cold was put in, that was most likely a Apple suggestion. And I've done some testing now. The time period I'm doing my testing, is after the fact that this would have actually occurred. But as I tested that on a live phone and using a Google search, I could see that how long to digest food would come up. I also notice the specific phrase, how long does it take to die from hypothermia? So as you do this Google search, you try to repeat what's being done. Those are two suggestions that actually came up.
And so that was something that was a suggestion and not something that was actually searched, correct?
Yeah, no, and I know that's different from my affidavit from about a year and a half ago, in all fairness, but
that's entirely different.
One person,
David, correct?
Mr. Lally.
I'm sorry.
One person at a time.
Yes.
Okay. So, yeah, in fairness, I want to give you my best knowledge, as I understand it saying here today, including after my review of Mr. Whiffen and Ms. Hyde's report. So I want to do everything I can to shine as much light and clarity on this as possible. So as I repeated, since that time and did the search, I would notice that is one of the things that would come up, and it would have a little picture of like a dinner plate or something like that. And there was actually a similar, if not the same picture found in the artifacts of that phone.
And so just to conclude, that's not what you said in your affidavit that was actually filed under pains and penalties of perjury with this court, correct?
Yes, and on that day, that is what my true and proper belief was. Okay, it's since further testing, I have found that I now believe that was probably an automatic one, and if I've caused you any distress, I apologize.
Doesn't cause me any distress.
Okay.
What I'm asking, sir, is that that's what you filed because that's what you thought at the time, correct?
Yes, sir.
And subsequently, you've done further testing, and that's shown that you were wrong, correct?
That is correct.
Now, according to your affidavit, there was a search for how long to digest food at 6:23:49 a.m. that precedes the search for how long to die, and the misspelling here would be the key CLKD at 6:23:51 a.m. Is that correct?
Yes, sir.
Now, is it possible that the how long to digest food was a predictive suggestion from Apple rather than a search entered by the user? Is that also correct?
Yeah, I don't know. I don't know the answer to that. I believe that it was, if it had picked up a earlier search from 227 of how long to die in the cold, and then you went to retype it in, it may have then tried to give you something similar at the 6:23 and 6:24 timelines. So hopefully that answers your question.
So steps, going to Mr. O'Keefe's health data, steps doesn't necessarily mean that someone is physically taking steps, correct?
Again, the research that's done for this is steps tend to be a very accurate artifact.
So steps could not also be coincided with, say, movement in a car or other sort of movement of the phone as far as the health data is concerned?
Sure. Well, I did, geez, quite some time ago, do some testing with an actual iPhone 11, the same make and model, and took a drive and tried to see if it would register steps. It did not. I sat in a chair and tried to duplicate how I thought I would walk to see if it recorded steps. It did not. I took the phone from the floor to the ceiling to see if it would record a flight of stairs. It did not. The only, with that iPhone 11, same make and model that I got, it was very consistent with me actually doing walking steps, and that was whether I had it in my shirt pocket, my pants pocket, or clipped onto my belt.
That's your testimony?
That is my testimony, yes, sir.
Now, are you familiar with GPS native locations?
Yes, sir.
And GPS native locations takes its data as far as defining latitude and longitude from a number of different sources, correct?
Well, true GPS, okay, is going to take it from the GPS network. What you may be thinking of is assisted GPS, which the iPhone uses, and that assisted GPS will try to, it kind of does a crowdsourcing. So it'll look at cell towers, what's in range as far as like Wi-Fi's and a number of other devices to try to get you an enhanced GPS location and give you the best data possible.
So it takes GPS native locations within an Apple iOS device, takes from 4 different sources. Isn't that correct?
It tries to get from a variety of sources, like I just mentioned. Not all would be available.
Now, with regard, did you look at any GPS native location data with regard to Mr. O'Keefe's phone?
Yes, sir.
And would you agree then that the GPS native locations didn't record any movement of that phone after 12:25 a.m.?
12:25. You know, I would have to look at the exhibit to see what the time of that last entry was. I don't want to misstate something to you, sir.
Now, you were asked about sort of the elevation change in 3 floors, ascending, descending, and saying that you couldn't pinpoint a time period or within that 12:21 to 12:24 time period from the health data. Is that correct?
Correct. It happened somewhere within that time.
Could you pinpoint more specifically if you looked at the GPS native location data?
No, well, we're talking to Apple Health and GPS location. So
But you said you couldn't do it.
I'm sorry, which one are you asking about? Please.
What I'm asking is, you said you couldn't pinpoint it within the GPS health data. What I'm asking is, if you had looked at the GPS native location data, could you give a more specific pinpoint as to where Mr. O'Keefe's phone was?
I'm going to allow that.
Maybe we can see briefly.
Okay.
You are unmuted.
Now, to be clear, sir, you had indicated earlier in your testimony that the elevation change from 1221 to 1224, you could not pinpoint where in that time period, or specifically where in that time period the elevation change occurred, correct?
That's correct. It's a time range, yes, sir.
So what I'm asking is, had you looked at that in the GPS native location data, would you have been able to more accurately or specifically pinpoint when that occurred?
Okay. So the location, are you looking for a yes or no? I'm sorry.
Yes or no?
I try. There was, yes, there was location data within that time period. Right? Okay.
And are you aware that Mr. O'Keefe's phone from the GPS native location data was actually a half-mile away from 34 Fairview Road at the time that it made those recordings in the GPS Apple Health data?
Right, yes, I understand he was using Waze, and it had made that recording. I understand that. That's why the finding that 3 minute and 1 second offset brings into serious doubt if that time was accurate. And when you apply that to the location offset, then the Apple Health data and the GPS all aligns. Now, I have not decoded Waze and found out what functions they were calling and all that. And I don't mean to indicate that I have, but I mean that the latest version of Axiom is bringing that up as an artifact and a timestamp related to Waze. And in the case of here, where minutes are important, I thought it proper that I bring this to the attention of the case as a possible explanation.
As a possible explanation?
As a possible explanation, sir, yes.
Now, the 3 different clocks that you were talking about, are you aware that those are actually associated to power usage and not applications?
Right, that power usage was directly related to the Waze application.
So it's your testimony that those 3 clocks apply to the times in Waze? Is that your testimony?
I'm saying that the timestamps were directly related to Waze. It was reported by Axiom when you applied the filter and say, show me all the artifacts related to Waze. These were artifacts that came up related to the Waze bundle. So I guess you need to give it the weight it deserves. Like I said, I've not decoded Waze. That's not something that has been done, but I think we need to consider the 3 minute offset as it applies to giving significance to the Apple Health data and the Waze GPS.
Now, turning to Ms. McCabe's phone again, as far as the search, what you indicated as last view time, are you aware that that is actually related to a time that it was actually focused on the screen as opposed to your interpretation of it?
I'm aware that from that it appears to be the last time and date it was focused, and when it was no longer was focused, that's when the timestamp was written. That's what's consistent with the other data on this particular phone on this very specific iOS.
Now, with regard to looking at this search, you mentioned that you used something called an ArtX tool. Is that correct?
Yes, sir.
And are you aware that's a tool that was actually created by Mr. Ian Whiffen?
Absolutely.
And with regards to this specific issue, as far as how this data is being interpreted from the browser, state DB versus the knowledge C database and the wall file and all of those, the P list and all of those other kinds of things, as far as the misinterpretation of the data has then caused Mr. Whiffen in further versions of Cellbrite to revise that so that this kind of error can't occur.
Sure, happy to answer that. So Mr. Whiffen's testing was not done with this specific version of the iOS. The iOS has been known to be changing the way this artifact works. To do proper analysis, the researcher that he is, he would need to work with that same iOS. Now, in regards to the Cellbrite question, they have two versions of the Cellbrite Physical Analyzer. One is the standard physical analyzer that's been out for several years now, probably is majority use in the community. It's a tool that takes that raw data and it puts it into human terms that we can look at and understand and write reports like you've been seeing here. So they have the Cellbrite Physical Analyzer that's out there. I believe it's 7.68, but don't quote me on that. And then they have a new version that's come out called Insights, and this operates more on a where you can put multiple cases in and that. It's only the Insight versions that they have bothered updating and no longer reporting on that time. Their current physical analyzer program, and I tested this a few days ago, still reports on that search occurring, and that timestamp. So currently Cellbrite is providing examiners, law enforcement, and people worldwide with two different versions giving two different results. That I can't speak to more than that, other than I've tested that, and I see how those programs are working now.
So my question, sir, yes or no, is are you aware that Cellbrite has had to modify their software based on misinterpretation of data, as you've done in this case?
Yes, with the asterisk, they updated one of two programs.
Nothing further. No further questions.
Okay.
All right, Mr. Green, you are all set.
Thank you, Judge. Thank you.
Sitting a little too long. Please, your votes. Get your seat. Yes, sir.
All right, George, that's it for today.
What is your?
All right, so juries, we are going to send you home for the weekend. Please do not discuss this case with anyone. Don't do any independent research or investigation into this case. If you happen to see, hear, or read anything about this case, please disregard it. We are on track. We will get this case next week for your deliberation. See you on Monday.
Court, all rise for the jury.
All right, why don't I see counsel regarding scheduling? Jimmy, I'll see you in there.
DNA testing.
Was there anything else besides DNA testing with regard to the firearm initially?
And functionality of the firearm.
I'm going to show you what's been marked and admitted by stipulation as State's Exhibit 2. While Ms. Morrissey's pulling up that exhibit, let me ask you, who sent the request to the FBI for assistance?
I believe it was the sheriff that ended up drafting the request for assistance on behalf of the Santa Fe County Sheriff's Office.
Did the sheriff or anyone at the Sheriff's Department initially request that the FBI conduct a test called the accidental discharge test?
No, that was not in our initial request.
Was an initial request made for any destructive testing to be conducted on this firearm?
No.
We have State's Exhibit number 2 up. Do you recognize that?
Yes, I do.
And what is that?
That is the letter that was drafted from the sheriff requesting assistance from the FBI for evidence testing.
Anywhere in this letter, does the sheriff ask for destructive testing to be done on this firearm?
No, he does not.
In fact, at the time that you and the Sheriff's Department requested assistance from the FBI to conduct functionality testing and DNA testing on this firearm, were you aware that they could do an accidental discharge test?
No, I wasn't aware of that test initially.
When did you become aware of the test?
I'm not sure the exact date that we had become aware of it, but it was later on in the investigation.
And who brought that possibility or that option to your attention?
It came from the FBI.
And what were you told about this accidental discharge test?
We were made aware that if we proceeded with this test, that it could result in damage to the firearm.
And did you and your department approve this test?
Yes.
And did you initially, did you request that other testing be done before the final accidental discharge test?
Yes, we had discussed that with the FBI, that all of the other testing would be completed before we moved on to the accidental discharge.
Did you request that the FBI photograph and examine and preserve the condition that the gun was in before they did the accidental discharge test?
I don't think that's something that we specifically requested. I think that, however, they process is how they probably have their own policy and procedures on that.
What was your understanding with regard to what the FBI was going to do before they did the accidental discharge test? as it relates to documenting the condition of the gun before they got to that last test?
So I believe that was part of the functionality test, was that we wanted to ensure that the gun was operating properly prior to them doing that accidental discharge testing.
Do you recall approximately when this testing was done by the FBI?
I don't recall the exact date.
From October 21st, 2021, up until the point that the FBI suggested this accidental discharge test, had you been asked by Mr. Baldwin or his attorneys to conduct independent testing on this revolver?
No, we didn't have any other requests.
Were you notified, or anybody in law enforcement, to your knowledge, notified by either Mr. Baldwin or his attorneys that the gun may have been malfunctioning prior to October 21st, 2021?
No.
What did when you interviewed Mr. Baldwin on October 21st, 2021, did he tell you that he did not pull the trigger?
I don't believe he stated one way or the other in regards to pulling the trigger.
Did he use any terminology when he was describing what happened right before the shooting, or when the shooting occurred?
I'm sorry, can you ask that again?
Did he explain to you how the shooting occurred?
I think the statement that he made was that the gun just went bang, or just went off. I'm sorry, I don't know the exact words, but something to that extent.
Did you interpret Mr. Baldwin's statement that the gun went off to mean that the gun was modified or altered in any way?
No.
Did you interpret that to mean that he did not pull the trigger?
No.
During your investigation, did you have any indication from either Mr. Baldwin, any witnesses, or his counsel that this gun had possibly malfunctioned?
No.
In examining or in looking at the gun when it came into your custody, did you have any indication to believe that there were any mechanical defects with this gun?
No.
Did you have any indication that the gun could have or previously had fired without a pull of the trigger?
No.
Why did you approve the accidental discharge test?
We had decided to proceed with that test due to Mr. Baldwin. He conducted an interview, a public interview, and I forget, I believe it was with, sorry, I don't remember the gentleman's name. But during that interview, he had made a statement that he didn't pull the trigger on that firearm, which is why we proceeded with that test.
What was your goal in requesting that test?
So the goal of the accidental discharge testing was to see if, in fact, the gun would fire or discharge without a pull of the trigger.
Did you approve the accidental discharge test so that the revolver would be damaged?
No.
May I have a moment, Your Honor, to confer with counsel? I think I'm ready to pass the witness. But if I could just have a moment.
Yes.
At this time, Your Honor, I have no further questions. I'll pass the witness.
All right,
Thank you.
cross-exam.
Yes. Good afternoon, Corporal.
Good afternoon.
Can you hear me?
Yes, I can.
Okay, great. When you first described getting to the scene, you referenced Mr. Baldwin, and you said he was either the shooter / handler of the firearm. Do you remember saying that he was the shooter or handler of the firearm?
Yes.
And the truth of the matter is, at the time of the destructive testing that we're here about, you weren't certain that he pulled the trigger of that firearm, true?
That is what I was told that he had pulled. That he was handling the firearm.
No, that's not exactly my question. My question is, at the time
I missed that answer. I missed that answer.
You want to repeat the answer? Sorry, Corporal. It was a little hard to hear it for me too.
Yeah. So my knowledge was that he was handling the firearm.
Right. Simply that he was handling the firearm. You were not certain at the time of the destructive testing that he had pulled the trigger of the firearm, correct?
That is correct.
And in fact, at that time, it was quite possible in your mind that the gun had just gone off and that he hadn't pulled the trigger, true?
That was the theory that we were testing, yes.
Now, you talk about the moment that the gun was recovered, and you sort of traced from that moment of the firearm all the way through the different phases that the firearm went through, the hands it touched, whatnot. You recall that part of your testimony?
Yeah.
Okay, I want to go back to the very beginning when you talked about, observing the gun being recovered. You didn't see the gun being recovered, did you, Corporal?
I wasn't present there, but through lapel video.
Oh, okay.
I missed that answer. Through the what?
Lapel video, Your Honor.
Yeah, I just wanted to clarify that for the court, Corporal, because when you testified before, and it may have been the way the question was posed to you, but you indicated that you saw the recovery, as I understood it, of the firearm. Did you not?
Not physically. I was not physically present there.
Okay. And you didn't inspect the firearm when it was recovered either, right?
That's correct.
Right. So when you're telling the court that you first found this firearm, recovered this firearm, and that you saw no modifications, that whole testimony, you didn't actually do that yourself, did you, Corporal?
No, not myself. It was learned through the investigation.
Okay. And that's sort of the same with everything that you said regarding the tracing of the firearm through its different phases here. You weren't in Italy with Mr. Pieta when he says he manufactured this firearm, correct?
Correct.
Right. And it goes from Mr. Pieta in Italy to EMF in California to Mr. Neal. I don't know if anybody knows where Mr. Neal is. Do you know where Mr. Neal has his shop?
I do not know where he resides.
Yeah. So it's to someplace nobody knows. To Seth Kenny in Arizona, I think, right?
New Mexico.
Was he in Arizona though when he got the firearm?
I'm not sure exactly where he was.
To Sarah Zachary in Albuquerque, right?
Yeah.
Spent the night in Albuquerque, right? The gun?
Yeah.
Sarah Zachary? Yeah. And then it ended up with Hannah Gutierrez Reed on the set of a movie film, right?
Yeah.
And then it was there for any number of days, weeks prior to the incident, right?
Correct.
Right. And you don't have any specific knowledge, frankly, about anything that occurred during any of those various stops with various people in various places around the world, do you?
I wouldn't. I'm not present, but that's, it's part of our investigation is that we learn that.
Well, certain people told you certain things, Corporal. You don't really know what happened with that gun in those various places at those various times, do you?
That's correct.
Had you submitted a firearm for testing in a homicide prior to this case?
Yes, I have.
In the homicide that you were lead detective on, that prior to this case, okay? Was that a homicide that involved a firearm?
I have been involved in a couple homicide investigations involving firearms.
As I understand it, prior to the investigation that brings us here today, there was only one homicide prior to this that you were the lead detective on that led to an arrest. Is that accurate?
That's incorrect.
Okay.
Um,
How many were there? I apologize if I have that wrong.
There was at least two that I was involved in that I can think of off the top of my head where the individual used a firearm.
Yeah, sorry if my question was clear. I'm asking when you were lead detective, when you were in charge of the case file.
At least two.
At least two. And what two were those?
So, I mean, what specifics are you looking for? I don't.
What cases were those? What were the names of those cases?
So one I had up in the Sanai area, and I don't recall the name of the suspect in that case because he is deceased. And then the other one that I had was a case here closer to Santa Fe, and the last name of that case was Grabe.
And the circumstances, just in one sentence, of that case?
It's ongoing.
Pardon?
It's still active.
No, right, but just the circumstances. Were the parties known to each other? Was it a gang shooting? Just a sentence about what that case was. Just
Yeah,
one sentence.
they were all known to each other, yeah.
Was it domestic?
One of them was.
The second one you're talking about where the defendant is not deceased?
I mean, I wouldn't say it was a domestic matter. It was more infidelity matters.
Okay. But the parties were known to each other?
Yes, sir.
It was not an accidental shooting?
Correct.
In this case, why did the gun get submitted to the FBI as opposed to state police, DPSO? Can you just explain that to me?
At the time of this case, we had just explored options with the different labs. Our lab at that time had a pretty extensive backlog in evidence testing, so we were just exploring options to see if we could find somewhere where we could get results a bit faster.
And what was the priority involved in this matter?
Because it was a high-profile case.
At the beginning of a week or so into this, as you're beginning to send things off for testing, and I see that your name is on the testing paper, or the DA's office, the prosecutors were already involved in this matter, right?
That's correct.
And they were involved in deciding what evidence to process and what follow-up interviews to do, correct?
Yes, they were.
You were meeting with the DA, then you'd meet with the FBI, and your technician, Marissa Popple, correct?
Yes.
You met with the FBI virtually and in person, right?
That's correct.
And nobody limited your resources at that time in terms of what you could or could not test, fair?
Yes.
So I want to now fast forward to April 2022 and sort of give the court a snapshot of where the investigation was at that point. I think I heard you say that, Mr. Baldwin never asked to test the gun. Did you say that? Did I hear that correctly?
Correct.
Okay, but Mr. Baldwin did volunteer multiple times to you to come back in and to answer any questions that you had, correct?
Correct.
And in those text messages with Mr. Baldwin, you never told Mr. Baldwin that you were going to submit the gun for destructive testing, correct?
Correct.
And the prosecutors were in touch with Mr. Baldwin's counsel, and they never told Mr. Baldwin's counsel that they were intending to present this gun for destructive testing, did they?
I wouldn't know the conversations between the prosecutors and the defense.
They never told, I apologize. They never told you that they, don't worry about the fact that the gun is destroyed. We told Mr. Baldwin's counsel so they had every opportunity to view it, right? They never told you that, did they?
That was not relayed to me.
Okay. And so in April of 22, at that point, you have not conclusively determined how the live ammunition got on set, correct?
Yes, that's correct.
And you turned back to the gun in April of 2022 to do this further testing, correct?
I don't know the actual date, but if that's what it states, then
And at that point, as we talked about it, as the examination opened, there were sort of two possibilities. One is that Mr. Baldwin pulled the trigger and discharged the weapon, and the other one is the possibility that the gun went off, and you were attempting to use your words, disprove Mr. Baldwin's statement that the gun had just gone off. True?
I think I needed to further elaborate on what I had meant by that.
So we needed to figure out how to disprove that theory or that statement. And that was the way that was proposed to us and what the FBI could do. Fair?
Right. Like I said, I think that what I had said there was probably not a full statement or explanation in what we were trying to do.
Well, that's the statement that you gave.
I understand that that's the statement that I gave. However, I needed, if, I had given time to further elaborate, or if I was able to further elaborate, then what would have been explained was that we were testing the theory due to the statement he made that he did not pull the trigger.
That's fine, Corporal. And I don't, I'm just going to break that down a little bit, though, just so that the court understands, right? That's what you said under oath, true?
Right.
Okay. And Miss Morrissey was the one asking you questions. She didn't cut you off or anything, did she, Corporal?
No.
Okay. And that was the statement you gave under oath at a trial where a person was facing homicide charges and ended up going to prison, true?
Yes.
Okay, this wasn't some casual conversation. You were testifying under oath in front of a jury in the very courtroom you'll be testifying in this manner, correct?
Yes.
Okay. Now, you talk about this statement that Mr. Baldwin made on national television where he denies pulling the trigger. You talked about that, right?
Yes.
Okay. What I've always wanted to understand is if he made that statement in December, of 2021, why did you wait until April of 2022 to order the destructive testing?
I don't know when it was actually ordered or when that conversation came about.
I want you to assume for the sake of this, okay, that the interview, which was broadcast all over national television, in which he adamantly denied ever pulling the trigger, right, happens in December of 2021 and is a matter of record, okay? I want you to assume for a second that the order for destructive testing is April 2022, okay? Can you explain to me why all of a sudden in April of 2022 there was urgency or need to order the destructive testing?
Again, I think there's a lot of factors that go into that, though. Where the FBI was in their testing, when we found out that this test could be performed, I don't think it's as simple as he made the statement in December and then in April it was ordered. There's a lot of factors that go into that. It was an evolving investigation still at that time. And, I can't even recall the day that we were made aware that test was possible.
Okay, well, we're going to pull up that email in a minute, but rather than talking in hypotheticals, can you give this court any information about why the delay actually occurred? Right? You said, well, they could have been backed up on testing, or we could have not known about the testing. When did you, lead agent on this case, begin to explore the possibility of the destructive testing? How long after the very public interview that Mr. Baldwin did?
I would have to know when that option was presented that could be done.
And I think I understand your answer. So what you're telling me is, until somebody gave you the option of a destructive test, you did not seek out that option. Am I understanding you correctly?
I did not know that option existed.
Okay. And as we talked about before, you had supervisors working with you, Sergeant Zook, Lieutenant Martinez, right?
I do believe that they were the supervisors at that time.
Right. And you had the DA's office working with you, right?
Correct.
And you had their investigators working with you?
Yeah.
Right. You weren't the only one that came up with ideas and things that could progress this investigation, Corporal Hancock, right? You guys were making group decisions and talking about possibilities to further this investigation. Isn't that true?
Yeah.
Now, you say at the moment that he denies this, that he ever pulled the trigger, which is this December national broadcast statement. Have you reviewed that statement?
I have, yes.
And you reviewed it when it happened, right?
As he was giving it?
In the days and weeks that followed. You reviewed it contemporaneously, right?
Yeah.
You reviewed it many times, fair?
Several, yes.
And you would agree with me that he adamantly denies pulling the trigger, fair?
Yes, he does.
And you knew, and I'm going to go back to before the accidental discharge. You know, when you were being directed by the prosecutors, some of the information you were providing to the court is stuff that you've learned in the past weeks, right? It wasn't all information that you knew at the time of the destructive testing, fair?
That's fair.
Right. So at the time of the destructive testing, you said, and in sum and substance, that there was no body and no information about a potential gun malfunction that was available to you. Right?
Right.
Okay. But Mr. Baldwin had said that he didn't pull the trigger, right?
In his interview, yes.
He had never told you yourself, Corporal, in sum and substance, that he didn't pull the trigger, that he didn't volitionally fire that gun?
In my interview with him, he didn't state either way. So.
You knew there had been accidental discharges on the set, true?
Yeah.
You knew that those had included accidental discharges with revolvers, correct?
Yeah.
You knew that Seth Kenny provided those weapons and confirmed to you that there were accidental discharges with those weapons, right?
I'm not sure if he's the one that confirmed it, but through interviewing the people that were around at the time, they confirmed it.
And in your mind, as you've already testified, there was a possibility that the gun had just gone off, right?
And that's why we tested the theory.
Right, but in terms of this concept of whether or not there could have been a malfunction, and this is your word, the word malfunction. Mr. Adiago had told you that from his vantage point, the gun had just gone off, right?
I don't know his specific wording.
Duran Curtin had told you the gun had just gone off, right?
I don't recall interviewing either of those two people, so.
Well, when you were talking to the prosecutor, you used information that not only you yourself learned, but that you had learned during the course of the investigation, Corporal. Don't you know that the witnesses the night of the shooting pretty much uniformly said that the gun just went off?
That's potentially, but your statement was that they told me that. They did not tell me that.
So let me withdraw the you that, okay? Again, that's when you were testifying on direct and you were saying how you recovered the weapon, there didn't seem to be an issue, but that's fine. You understand from reviewing police paperwork that the witnesses that were interviewed the night of the 21st, okay, indicated that the gun just went off, true?
If that's what they said, I don't know their exact statement.
Okay. Are you aware as you sit here whether any of the witnesses the night of said verbatim the gun just went off?
I think that's kind of been the
Your Honor, I'm going to
common.
object. It's been asked and answered, and counsel's getting argumentative with the witness.
She appears to be able to answer this. Let her answer, and then we'll move on.
You are aware that witnesses that night indicated to members of law enforcement that the gun just went off, true?
I think that's been a common phrase used. Yes,
It was a common phrase used, correct?
right.
It was what?
A common phrase.
Phrase used.
Oh, common phrase.
And Hannah Gutierrez Reed had told you that if you touch the trigger, it'll just send the hammer down. She told you that, right?
Yes, that's how they would operate.
She had also told you that she had trouble loading a firearm on the day of the incident, right?
Yes, she did state that.
And people had told you or law enforcement, that the firearm had a quote unquote hair trigger, true?
I'm sorry, a what?
Hair trigger.
I don't know if that was the phrase used, but that's what they said.
And that it was a sensitive gun, quote unquote.
I don't recall that phrase either.
You knew that the gun was an important piece of evidence, true?
Yeah.
And in deciding whether or not to go forward with the test, who was involved in making that decision?
I don't have specific names, but again, it was discussed with members from the sheriff's office, our evidence team, the FBI, and the district attorney's office.
And who ultimately made the call?
Again, it was a group or a collective effort in proceeding with it.
Did you do any research into the ramifications of this testing?
I was made aware that the test could damage the firearm.
Did you look into other options?
No.
Did you confer with any experts, you or the prosecutors?
No.
Anything else at this point that you did to answer this question in your mind of whether or not to move forward with this test?
I'm sorry, can you state the question again?
Sure. At this time, when you decide to go forward with this test, is there anything else that we haven't talked about that you did to help answer the question in your mind of whether or not to go forward with this test?
No, because that was presented to us, so that's the option that was discussed.
Did you provide the FBI with any of the actual real-life circumstances of how this incident occurred?
What do you mean by real life circumstances?
Well, you know that the FBI tested the gun by smashing it with a mallet, right?
Yeah.
Okay, I presume you did not tell the FBI that's what occurred in this case, right?
That's correct.
Okay, and you didn't tell them that the gun went off by being dropped either, did you?
Correct.
Okay, but did you describe to them the circumstances of how it actually went off?
I didn't know the circumstances of how it went off. That's why we were testing functionality and then potential for accidental discharge.
You didn't know 6 months into the investigation, any of the surrounding circumstances that might have informed the FBI's testing?
I'm not sure I'm understanding your question.
Okay, well, you had the ability to communicate with the FBI, right?
Correct.
There was nobody put a restriction on your ability to share information, right?
That's correct.
Okay, and they were deciding what test or tests to perform on this firearm. You understood that, right?
Yeah.
Okay, and so I'm asking you at that point, did you explain in any way, shape, or form the circumstances surrounding either the pulling of the firearm and what happened, the motion that Mr. Baldwin did, or any of the circumstances that led to the incident? Did you describe any of those to the FBI?
There was actually very limited information given to them at when we had first started using the FBI for evidence testing. They weren't given all details of the investigation because it was still being learned.
Well, at this point in the investigation, you had a case file, right?
Yeah.
Okay, and in your case file, you had the SFSO reports from the night of 10/21, true?
I don't know exactly when they were done. They took quite a while to produce reports from this.
You don't know whether within 6 months the reports from the night of were done? You don't know that as you're sitting here, Corporal?
I'm sure that some of them were done, but the case was still under investigation at that time.
I agree with you that the case was under investigation at that time, but I'm asking you, the reports from 10/21, the night of, those were already in your case file as of April 2022, 6 months later. Fair?
I would think so, but
okay.
There were a lot of people working there.
If we could pull up what's going to be defense one, which is the exhibit that I want to talk to you about next, which is the email chain, as we're getting it up, between the FBI and Mr. Ziegler, who tested the gun, and of course you and Ms. Popple. And if we could blow up that top page. You see, it's April 21st, 6 months after the incident, right?
Correct.
Okay. And the email indicates from Mr. Cortez, who was your liaison at the FBI, right?
Yeah.
I spoke with Detective Hancock. That's you, right?
Correct.
Okay. And you would like to request the below, and we can go down, right? And it indicates, I think on direct examination that you said that the test could, was the word you used, could result in damage to the firearm, right?
Yeah.
Okay. But if you look down at this third paragraph here, it says, second sentence, we're tracking that this will alter the firearm and it will not longer be in the same physical condition that it was seized in. Do you see that?
Yeah.
And this is an accurate representation, I have no doubt, of what the FBI understood at the time. True?
Objection, Your Honor, calls for speculation.
Sustained.
This is an accurate reflection of what you understood at the time, right?
Well, the statement here is that it will alter the firearm and not be in the same physical condition. It doesn't state in here that it will be damaged.
Okay, but you do agree with me that you understood prior to the testing that it will alter the firearm and it will not longer be in the same physical condition. You did understand that, right?
Right, as it states here.
Okay. And you're copied on this email, of course, right?
Yes.
And it says, enhanced test fire to verify if the firearm functions without pressing the trigger. Is that a fair assessment of what you were trying to accomplish?
Yes.
Okay. And at this point, you end up authorizing, you and the team end up authorizing the destructive testing, true?
Accidental discharge, not destructive.
Okay. The testing that ended up being destructive. You want to call it the accidental discharge test? That's fine. You ordered the accidental discharge test. Okay. Yeah. Okay. You do not ask the FBI to disassemble the firearm and to take pictures of it, do you?
That's, again, I don't know their processes on how they run their testing. So I don't believe it was specifically requested from us.
You did not ask the FBI to videotape the testing, right?
I don't believe that was in the request.
Okay. You didn't tell them we need to notify defense counsel of the target, right?
Correct.
You didn't go to a judge or anything like that, right?
No.
Okay. You didn't tell them to come back to you as the testing progressed and to check back in with you, did you?
No.
You didn't tell them to preserve what they were doing in any way, shape, or form, did you?
No.
And you understood, or you understand as you're sitting here now, that the test did alter the firearm, right?
Yes.
It did make it so that it's no longer in the same physical condition, right?
Yes.
And no one will ever be able to bring it back to the condition that it was in when it was recovered, right?
Objection calls for speculation.
If you know.
I'm not a firearms expert, so I don't think I can testify to that.
How were you informed that the firearm had been destroyed or broken? If you want the word broke, if you don't like the word destroyed, broken.
I believe through their report, through the FBI's report.
That you eventually received.
Yes.
Nobody called you afterwards and said, just so you know, the firearm in this case is destroyed.
I don't recall ever receiving notice.
And you, as the case agent, never made any other request to the FBI for any further testing of this firearm, true?
That's correct.
I have nothing further for this witness at this time.
Redirect.
Yes, Your Honor, briefly. Corporal Hancock, on October 21st, 2021, did you believe that that gun had fired without a pull of the trigger?
I didn't know at the time.
Did you have any indication or any reason to believe that that gun on October 21st had fired without a pull of the trigger?
No.
Did you have any indication that the gun was malfunctioning on October 21st, 2021?
No.
Have you watched Lieutenant Benavidez's lapel camera video or dash camera video as well?
Yes, I have.
Okay. And is it on that video where you watched him taking custody of this particular revolver?
Yes.
Does Lieutenant Benavidez do anything with the gun after he takes custody of the gun, other than put it in his vehicle?
Objection if she knows.
If you know.
I'm sorry, can you state the question again?
Based on your observation, well, let me ask you this way. Based on your observation of the lapel video and the dash camera video from Lieutenant Benavidez, did you see him do anything with this gun other than take it from where he seized it and put it in his vehicle?
That was all that I observed.
Now, Mr. Spiro asked you questions about communication Mr. Baldwin was having with you after October 21st, 2021 via text message. In any of those text messages, did Mr. Baldwin tell you that gun may have been broken or may have been modified or altered in any way because it fired by itself?
No, I don't recall him ever making that kind of statement.
And at the time that this accidental discharge test was authorized, was Mr. Baldwin charged with a crime?
No.
And is it your practice as a law enforcement officer to tell the defense what investigative steps you are taking in an investigation before they're charged with a crime?
No.
Now, you were asked questions about your statement that you made when you testified in Ms. Gutierrez's trial that you were trying to disprove the theory, that theory or that statement, I believe is the words that were used. What did you mean by that?
So essentially what I had meant was that there, was statements that the trigger was not pulled when that gun discharged. And to, check the facts of the validity of that statement, we did need to test that theory.
Now, you were asked questions about the December 1st, 2021 televised interview that Mr. Baldwin gave to one of the networks. And do you recall the date of Mr. Baldwin's interview with the OSHA investigators?
I don't recall the date of it.
Would reviewing the transcript of his OSHA interview refresh your memory as to the date of Mr. Baldwin's OSHA interview?
Yes, ma'am.
If you would please, and let us know when your memory is refreshed.
Okay. Okay, I'm refreshed.
When did Mr. Baldwin give an interview to the OSHA investigators?
He gave the interview on December 8th, 2021.
And was that after the ABC interview or the network interview Mr. Baldwin gave that Mr. Spiro asked you about of December 1st?
That is after.
What exactly, if you could please testify and tell the court, what exactly did Mr. Baldwin, 7 days after his interview, where he disavowed pulling the trigger, what did he tell OSHA investigators about this particular firearm?
He had told the investigator that nothing was wrong with the gun, and that the only thing that was wrong with the gun was that there was a live bullet in it. He said he hadn't had any issues with that weapon.
Are those his words verbatim?
It's not verbatim.
Would reading the transcript at page 42 refresh your memory as to exactly what Mr. Baldwin told OSHA investigators?
Yes.
If you would, please.
Okay.
What exactly did he say when he was asked about if the gun had any mechanical defects?
He said that it didn't. He said the problem didn't have to do with the gun, it had to do with the bullet. And that he said that there was no mechanical defects of the gun.
Now, you were asked by Mr. Spiro about 2 other accidental discharges that had occurred on set. To your knowledge, based on your investigation, were either one of those with the gun Mr. Baldwin used?
To my knowledge, no, they were not.
Did you understand the phrase "went off" to mean Mr. Baldwin did not pull the trigger?
No.
Did you? I'm sorry, go ahead.
I would just interpret that as the gun discharged.
Did you understand the phrase "went off," that the gun malfunctioned?
No.
Were you offered any other options by the FBI after they did their functionality test and other testing? You were offered the accidental discharge test, is that right?
That's correct.
Were you offered any other tests by the FBI?
That is all that I can remember them offering.
Now, was it your understanding you were asked questions about an email from, I believe, Agent Cortez? Did you understand that the accidental discharge test would definitively break that firearm, or that it might just possibly break it?
That it would possibly break the firearm.
Your Honor, at this time, I have no further questions. Thank you, Corporal.
I have very brief follow-up, Your Honor.
Any objection?
Your Honor, they had cross-examination. I would object. We have 2 hours for this hearing that the court has allotted. We have 2 other witnesses waiting to testify.
All right. No. Okay. This witness is excused. All right. We've got another witness waiting to come in. All right. Is this your next witness? Where'd he go? Ziegler. Is this your next witness?
Yes, Your Honor. Mr. Ziegler.
All right. Please raise your right hand. Do you swear affirm under penalty of law that the testimony you'll give in this case will be the truth, the whole truth, and nothing but the truth? You're on mute.
I do, Your Honor.
All right. Thank you. Go ahead, Ms.
Thank
Johnson.
you. Thank you. Mr. Ziegler, would you please introduce yourself to the court?
Yes, my name is Bryce Ziegler. First name spelled B-R-Y-C-E. Last name spelled Z-I-E-G-L-E-R.
And how are you employed, sir?
I am currently employed by the Federal Bureau of Investigation within the Laboratory Division, and specifically I'm a forensic examiner in the Firearms Toolmarks Unit.
How long have you been employed by the FBI lab?
Since 2011.
And what is a forensic examiner in the firearms unit?
So essentially, I am, my main duties are to receive evidence that's relevant to my discipline, perform the requested forensic examinations on those items of evidence, issue my results in a formal laboratory report, and testify to those findings if requested.
And those essentially are your duties as a forensics examiner?
That's correct.
What is your educational background, Mr. Ziegler?
I received a Bachelor of Science in Forensic Science from the Pennsylvania State University.
And did you go work for the FBI after obtaining your degree?
Yes, I did.
Okay. And did you receive any specialized training to become a firearms examiner?
Yes, so I had to complete what's called the Forensic Examiner Training Program. And that training program is for all forensic examiners at the FBI lab, but it's specific to the unit that that person is seeking a qualification in. So I had to complete that program in order to be considered a qualified examiner.
And how long was that program?
It took me a little over 3 years.
And since completing that program, do you continue to obtain educational classes and continuing education?
Sure, there are some continuing education requirements, and there's also proficiency testing that I must continue to do as well.
And after you finished the initial training, did you then receive on-the-job training as well?
I would say that on-the-job training really occurs during the training program. So I'm working with qualified examiners. I had a mentor that I worked with. I actually worked cases while in a training status, but all my work would be reviewed by a qualified examiner. So I'd say that that on-the-job type training occurs prior to the qualification.
Does the FBI lab have protocols and standard procedures as it relates to firearm exams and firearm analysis?
Yes, we do.
And is there a standard protocol for each test that you conduct in the firearms unit?
Yes, there is. Some of the examinations are combined into a single protocol. Others have their own independent protocols.
And do you follow those procedures when you're doing your firearms examinations?
I do.
Approximately, in your career with the FBI, approximately how many firearms have you examined?
I would estimate that number to easily be in the thousands of firearms.
Let's talk about your examination of the evidence revolver in this case, and we'll refer to it as the evidence revolver. Were you asked to examine and conduct tests on the evidence revolver in this case?
I was, yes.
And what were you, who asked you to conduct these exams?
Right, so typically evidence is submitted to the FBI lab from a special agent. So in this case, that person was Jose Cortez. So he submitted evidence to the laboratory, and essentially that evidence comes with a request, a written request on what the contributor would like done.
And what was your understanding about whether or not this was an FBI request or was it a local law enforcement request?
It was my understanding that it was a local case. However, sometimes locals come to the FBI to ask for assistance.
And is that routine?
It does happen. Yeah, I'd say it's fairly frequent.
What were you initially asked to do as it relates to this firearm?
So specifically with the firearm, I was mainly just asked to assess its function. So that includes things like, are the safeties working correctly? Do I notice anything about the firearm that I may determine that I feel it may be unsafe to fire? So things like blockages in the barrel, bulges in the barrel, potential weak points within the firearm. So things along those lines.
And is part of that function test also doing a test firing of the firearm?
Yes, it is.
Okay. And who did you receive this firearm from in your particular unit?
So when evidence at the laboratory is transferred from one unit to another, it gets dropped off in my unit at a secure storage location. So that's a location that it's badge access only. So people have to have the proper, badge access to in order to pick up those items. And then once it's dropped off in our unit, we receive a notification, and either myself or a technician will retrieve those items from that location to begin either taking notes or conduct the actual examination.
Do you recall when you received the evidence revolver?
I do have my notes. I'd have to refer to that.
If you would please refresh your memory with your notes and then let us know when your memory is refreshed.
Yes, so I can tell you that the exams, and when I say the exams, I'm talking about initial documentation. So just things like photographs, annotating the make, model, caliber, things of that nature. They began in April of 2022.
I'm going to show you what's been previously marked and admitted by stipulation as State's Exhibit 3. Do you recognize that, Mr. Ziegler? If you can scroll up a little bit.
Yes, I do.
What is it?
So this is a case notes worksheet. It's a firearms function worksheet. So this is exactly what I was describing to you before. When a firearm comes to my unit, it typically gets photographed, and then some of that kind of background information, make, model, caliber, things of that nature are recorded on this standardized document.
And the photograph that's depicted on Exhibit 3, is that the evidence revolver we've been talking about?
Yes, that's correct.
And does that photograph accurately depict the way that that evidence revolver looked when it was received in your unit?
Yes, yes, it does.
Was there anything about that evidence revolver when you received it in your unit that indicated to you that it may not be working properly or malfunctioning, or that internal components were modified?
No, not in the condition it was received.
And you testified that you did an initial inspection of the gun?
That's correct.
And upon doing that inspection, did you note any defects or alterations on the gun?
No, that initial inspection is basically a safety inspection. And as you pointed out, if I notice anything odd about the firearm or something that may give me cause for concern that it may be unsafe to fire. So I didn't see anything of that nature, so I felt it was safe to fire. So at that point, we did the test firing.
So that was your next step in the process, was the test fire?
That's correct.
Can you describe the test fire for the court, please?
Yes, so I can take this firearm to one of two locations at the FBI laboratory. We have a 25-yard range, and we also have what's called a water tank, which allows me to retrieve fired bullets. So it's a large metal box filled with water. You shoot into the port, it takes away the energy of the bullet, and I can collect the bullet if I need to do so. So I took this particular firearm to the water tank, and I used laboratory ammunition. I loaded it in the way it's designed to be loaded. And while I do this, I'm checking the positions of the hammer. I'm ensuring the safeties are operating correctly. I'm assessing if the internal parts, so things like the trigger, connection with the hammer, if those internal operations appear to be functioning normally. And after all of those things, I would actually physically fire the gun.
Before we get to your test fire, you said that you checked the position of the hammer. Did you do that in this case?
Yes.
And can you explain how many positions that hammer has?
This hammer has a total of 4 positions.
Can you describe what each one is?
Yeah, so in its most uncocked or at rest state, that's when the hammer is fully forward. It's as far forward as it can be, and it's essentially resting up against the frame of the gun. Now, as you start to cock the hammer, there are notches, and you can't see them in this picture, they're on the inside, but there are notches in this hammer that as you cock it, the rear portion of the trigger, which is called the sear, you can hear it click into those positions. So if I have my hammer at rest and I start to cock it, I'm going to hear the first click. That notch is called the quarter cock. Sometimes it's also referred to as the safety notch. If I continue to cock it further, you'll hear a second click. That's the sear dropping into the half cock notch, which is sometimes referred to as the loading notch. And if I pull it fully to the rear, I'll hear a third click, and that's where the sear is sitting in the sear notch. At this point, that is the position where this firearm would be ready to fire if the trigger's pulled.
I'm going to show you what's been marked as State's Exhibit number 4. Do you recognize what's depicted on 4?
Yes, I do.
And what is it?
These are photographs that I took depicting the 4 hammer positions that I just described to you. So you see how far it gets cocked back in each position from the side view, which is the column on the left, and from the top down, which is the column on the right.
Okay. When the hammer was in the full cock position, did you experience at any point that the gun discharged without the pull of the trigger?
No, so when the hammer is in the fully cocked position, as I mentioned before, the sear is sitting in that final notch. So essentially, for this hammer to fall, that sear has to move out of the way. So however that is achieved, that's what has to happen. Now, if this firearm was, as you mentioned, if there was an issue where the hammer was falling just on its own, if you look at the bottom 2 photographs here, this hammer is currently in the full cock position. I'm not holding it with my finger. My hands are nowhere near this firearm. So it's sitting in that full cock position on its own. So it has proper engagement. It's not falling by itself. And again, this is how it was received. I wasn't noticing any of those types of failures in the condition it was received.
Can you explain how this revolver fires as opposed to, for example, a semi-automatic?
Sure. So a semi-automatic does a lot of the work that the shooter has to do for you. So it's automatically going to extract, eject the fired cartridge case, chamber the next available cartridge, and then essentially the shooter just has to pull the trigger a second time. With a firearm like this is called a single action revolver. Single action refers to the shooter must manually cock the hammer each time they intend to fire. So there are other types of revolvers called double action where the shooter does not have to manually cock the hammer. They can pull the trigger and it performs that action of cocking and releasing the hammer. However, in a single action revolver, the shooter has to perform that one action manually.
And what position does the hammer have to be in order for it to fire or the trigger to be pulled and it fires?
Right, so this firearm is designed to fire with the hammer in the fully cocked position. So the bottom images that you see here.
You also testified that you inspected the trigger connection with the hammer.
Yes.
Did you find any defaults or any problems with the trigger connection?
Right, so Just to be clear, I did not disassemble the firearm prior to test firing it, so I don't have any visual type of indicators whether there was an issue there or not. However, if there was an issue, I would have expected to see that during the test firing. So whether the hammer would not stay in the full cock position, whether it would be falling on its own, I would have expected to see something if there was some type of malfunction with that connection.
And do you need to disassemble a firearm to determine whether it functions as it's designed or properly?
No, not necessarily. If I go through essentially all the steps to check the safeties, check to make sure the action appears to be functioning correctly, and I physically test fire it, and I don't see any abnormalities that occur during that test firing, then no, there's no reason for me to then disassemble it if nothing odd has happened during that test firing.
And how many times did you test fire this revolver?
I test fired this particular one 12 times.
And during each one of those 12 times, did you observe any of these issues that you just mentioned that would cause you concern that maybe this gun could malfunction?
No, there was nothing odd or abnormal about this during the initial test firing.
And when you did the test firing, did you check the different hammer cocking positions?
Yes, I did.
Okay. And at any point during each one of those 12 test fires, did the gun discharge by itself without a pull of the trigger?
No.
And you testified that you checked the hammer's quarter-cock hammer position, right? That's
correct.
Did the firearm fire when it was in the quarter-cock hammer position?
So that portion of the testing I did during the later phase of accidental discharge testing. When I say that I checked the quarter and the half cock positions, those positions are designed so that if you're cocking the hammer, and if I cock it past the quarter cock notch, and if my thumb slips off the hammer, that quarter cock is meant to catch the hammer before it falls and makes contact with the cartridge. So when I say that I checked those positions during the function assessment, what I mean is I pulled the hammer past those notches, released it, and ensured that that safety mechanism was actually working correctly. So I did that for both the quarter and the half cock positions.
And were the safety mechanisms working correctly?
Yes, they were.
When you had the hammer in the full cock position, did it hold in that position until you pulled the trigger?
During the initial test firing, yes.
What were you able to determine after you conducted your physical examination of the gun, the examination of the trigger of the hammer, and the 12 test fires? What did you determine?
So the end result in relationship to the function exam is just that it functioned normally. And again, that means I didn't see anything abnormal, odd. There were no apparent either damage or modifications that would have rendered this firearm unsafe.
Would you say it functioned as designed?
Yes, it functioned normally as it's designed.
And what does that mean when one uses the term function as designed?
It's basically what I just described. So while I'm conducting my checks of the firearm and physically test firing it, nothing out of the ordinary happened during that testing. So if I had a discharge without pulling the trigger, or if I noticed that the sear notch was not engaging properly, that's something that is out of the ordinary. So that would not be functioning normally, and that's something that I would have annotated in my notes and the report. So I wasn't seeing any of those things. So that's what function normally means.
And as part of your examination, did you also conduct measurements of the trigger pull?
I did.
And what is that? What is that intended to measure?
So in my laboratory, when I do a trigger pull examination, it is not to determine the exact amount of force that is required to pull the trigger. At my laboratory, it is designed to establish a range. So at the lower end of that range, I'm confident that that is not enough force to pull the trigger. And at the upper end of that range, I'm confident that essentially that amount of force or weight will cause that trigger to pull every time that I'd test it.
And how did you conduct this trigger pull test?
So essentially, if you picture a wire coat hanger, so I have a long wire with a hook on the top, and I would orient the firearm vertically, so the muzzle will be pointing straight up at the ceiling. I would hook this, essentially the coat hanger portion of the hook inside the trigger guard, resting on the trigger, and then I kind of add static weights to the bottom of that wire. And so I can continue to add weights until I reach the point where it's starting to pull the trigger as I pick up on the firearm. So the amount of weight that's added, that's going to be the amount of force that's required to pull the trigger.
And what amount of force was required to pull the trigger for this evidence revolver?
So in my note taking and during my exam, I measured that amount of force to be between 2 and 2.5 pounds.
And what does that mean?
Can you elaborate?
Well, does it mean that it would take 2 to 2.5 pounds of force to pull that trigger?
Somewhere in between those values, yes.
Would that be considered what people call a hair trigger?
I personally would not consider that to be a hair trigger. When I think of a hair trigger, I think of either very high performance hunting rifles, things of that nature, where the amount of force on the trigger, I don't have a specific number for you, but it's extremely light, where you just barely have to touch the trigger to fire the firearm. It's typically, you see them in hunting rifles.
Did this particular revolver fire at any point with less than 2 pounds of pressure on that trigger, based on your exam?
Right, so I can't answer that question because I don't know the exact amount of force that I'm using while I'm doing the actual test firing. I can just tell you that when I did the measurement with the static weight set as I described, it would not pull with less than 2 pounds of pressure.
When you were conducting the trigger pull measurements, was there any indication to you as a forensic examiner that this trigger had been altered?
No, there was no indication. I feel this range is very common for this style of firearm.
When you're doing the trigger pull measurements, do you also engage the hammer?
Right, so in order to test that, the hammer would have to be in the fully cocked position because that's how this firearm is designed to fire.
And so in the fully cocked position, the amount of pressure during your measurements that it took to fire this gun was between 2 to 2.5 pounds?
That is correct.
Did, after you conducted your physical exam of the gun, the trigger, the hammer, and your test fire, was another test conducted on this firearm?
Yeah, so I did do some other exams with the ammunition, but if we're focusing specifically on the firearm, the next test is what's called accidental discharge.
Before we get to the accidental discharge test, were the exams that you just testified about, were those conducted according to FBI procedures and protocols?
Yes, they were.
So what is an accidental discharge test?
So in my laboratory, the accidental discharge test, it seeks to determine if I impart a certain amount of force to this firearm, is it even possible for this firearm to fire without pulling the trigger? And the way it's done in my laboratory is essentially I would take a rawhide mallet and I would strike the firearm on 6 planes. And when I'm referring to those 6 planes, if you pictured a cardboard box sitting in front of you, the 6 planes would be the front of the box, the rear of the box, the left side, right side, top, and bottom of the box. So those are the 6 planes. And essentially when I'm striking this firearm with a rawhide mallet, the goal is to determine is this amount of force, this vibration, this shock, is that enough to cause the inner workings of the firearm to disengage and actually allow the hammer to fall and fire the shot? So this test is really designed to mimic if the firearm's been either banged into something or maybe hit with an object or maybe even dropped or something of that nature. Some type of force has been introduced to this gun.
Now, before we get to your accidental discharge test that you conducted in this case, did you document, photograph the condition of the firearm before the accidental discharge test?
Yes, so all the photos that you've seen so far were prior to that test.
And prior to the accidental discharge test, did you have any indication that this revolver was altered or modified in any way?
There was nothing that jumped out at me, no.
So once you got to the point of accidental discharge test was the next test that you were going to conduct, did you contact the local law enforcement?
I contacted the Special Agent Cortez, the case agent.
And was it your idea or did you suggest that there was this test available?
Yes, I did.
Now, to your knowledge, have other firearms examiners at the FBI lab conducted the accidental discharge test in other casework?
Yes, I've seen them do it while I've been in training.
Now, is there a procedure and protocol that the FBI has in place for conducting the accidental discharge test?
Yes, there is.
Did you receive authorization to go forward with the accidental discharge test?
I did from the case agent, yes.
Now, can you describe for the court how you did the test in this particular case, where you had the firearm and how you went ahead and conducted the test?
Sure. So to actually do this examination, I use what's called a remote firing platform. And essentially, you could think of that as a padded vise designed specifically to hold firearms. So it essentially has a vise, but it kind of has rubber on the inside. And I clamped this firearm into that device, and then I continued with the testing as I previously described, striking with a rawhide mallet on 6 different planes. And I also wanted to test this firearm in all 4 positions of the hammer. So I wanted to kind of exhaust all efforts for any condition that that hammer could have been in.
Now, was the rawhide mallet that you used, was that affixed to another device or were you using that freehand?
No, that was me physically holding it.
Now, can you describe, if you could use your hands and demonstrate to the court how you applied the force with the mallet, the force to the gun with the mallet?
Right, so it would depend on which of the 6 planes that I was working with at that time. So I don't know if I could give you one description that would encompass all 6 of those planes, but I would liken it to similar to hitting a nail with a hammer, something to that effect.
And were all those in a straight line, or could some of those come in at an angle?
Right, so I'm a human being, so there's a good chance that there's going to be some variability in each of those strikes. So sure, it's certainly possible that not all of them were completely perpendicular to the firearm.
And when you're doing the accidental discharge test, did this revolver discharge when the hammer was in the quarter cock position?
So because of the design of this firearm, in the 2 intermediate settings, the quarter and the half cock, I did not have to do the striking with the mallet test.
So was your test then done with the hammer in the full cock?
Yes, I did the striking with the hammer at rest and in the fully cocked position.
At rest, did it discharge?
It did.
And when the hammer was in the fully cocked position, did it discharge?
So I did have one event where it discharged with the hammer in the full cock position. And what occurred is I struck the hammer directly with the rawhide mallet and the hammer fell. And when we do this testing, I use a primed cartridge case. So I remove the bullet from the cartridge, I dump out the powder. So it's just a case with a primer in it. So that's obviously done for safety purposes. So I'm not firing a shot if there is a firing event. And then I can audibly hear if the primer is detonated. So I struck the hammer fell and detonated the primer during this one event. And what was interesting to me is I thought it was odd that the quarter or the half-cock safety notches did not catch the sear as the hammer was falling. So this led me to believe that there was some type of damage that occurred during that event.
But you had to apply a good amount of force for it to discharge. Is that right?
Right. I can't quantify what the force was.
Now, was the discharge with the hammer in the resting position, did you expect that? Was that something that was expected?
Yes, this is a known issue with a revolver of this design. In fact, if you would read the owner's manual for this type of firearm, you would see warnings not to carry this firearm with the hammer at rest on a loaded chamber.
So can you describe what eventually happened as a result of this accidental discharge test?
Sure. So as I mentioned, I had some suspicion that something occurred inside that allowed this hammer to fall that was not normal. So eventually, after this testing, I took the firearm apart and I was able to find 2 locations that had actually fractured during that striking event. So it's my opinion that the firearm would not have fired unless those 2 pieces fractured like they did.
Were you able to fire the firearm after these pieces fractured?
No, it was no longer operable in that condition.
Now, let me go back just briefly to when you offered this test to local law enforcement. What did you tell them about the possibilities of what could happen during this accidental discharge test?
All right, so this is actually written in our standard operating procedures. This test is considered potentially destructive. So in order to do this test, I need to inform the contributor that I may be imparting some damage to this firearm in doing so, and that it potentially may not be operable as a result of that testing. So I had to explain that to the contributor and allow them to make an informed decision.
Now, did you tell them they would definitively break the gun or just that it could potentially break the gun?
No, it's a possibility. There's no way that I could have known for certain that the firearm was going to break.
And when you conducted this accidental discharge test, did you do it according to FBI protocols and procedures?
Yes, I did.
Now, Mr. Ziegler, let me ask you, so even assuming that maybe some internal component of this revolver was modified before you received it in the lab, did the gun fire without a pull of the trigger before you got to that accidental discharge test that broke the gun eventually?
That did not occur during my testing at the lab, no.
At any point before the accidental discharge test, did that gun fire without a pull of the trigger?
Not during my testing.
Was there any indication that the gun did not function as designed before the accidental discharge test?
No, there was nothing odd or noteworthy about this firearm.
As a forensics examiner for the FBI lab, have you had experiences in the past when conducting your scientific testing, evidence you've examined has been either modified in the process of the exam?
Sure, that can happen.
Can you give us an example of that?
Sure. So one example could be if I'm asked to do microscopic comparisons on, say, a fired bullet, and there's also ammunition that's sent in with the case. And initially I would do test fires with laboratory ammunition. However, sometimes it's best, as far as how fired ammunition components are marked, typically the best ammunition that you have is going to be the closest to what was used in the actual shooting event. So there may be times where the ammunition from the laboratory is just not reproducing the same as the ammunition in the case. So I may reach out to the case agent and request their permission to consume some of the evidence ammunition to collect additional test fires. So I need their permission to do that because I'm permanently changing those items of evidence. I'm taking a live cartridge, I'm physically shooting them. So I'm detonating the primer, I'm consuming the powder, and I'm forever changing the bullet and the fired cartridge case. So they've submitted ammunition, but they're going to receive a fired bullet and a fired cartridge case in return. So that's just one example where, you know, I may be permanently changing the evidence to do my examination, and I would need their permission in order to do so.
Did you conduct this accidental discharge test to damage this gun?
That's not the goal of the test, no.
May I have a moment, Your Honor, just to review my notes? Now, just the one last question, Mr. Ziegler. The damage, let me show you what's been previously marked. I believe it's State's Exhibit 5. Do you recognize State's Exhibit 5?
Yes, I do.
And what are they, or what is it?
All right, so this is rotated 90 degrees, but this is a photograph that I took, and this was after the accidental discharge testing, after I disassembled it, and this is depicting the parts in the condition after that test, and it's depicting the two locations that I found where portions of these parts actually fractured off.
Now, prior to the accidental discharge test, did you have any reason to believe that these parts were in this condition as we see them on Exhibit 5?
No, if they were in this condition, I would not have expected to function correctly.
Are these pieces still available? The ones depicted on Exhibit 5? I mean, or when they left your lab?
Right, I returned everything, you know, in the correct packaging and all that. So as far as I'm aware, yes.
I have nothing further. Thank you, Mr. Ziegler. I pass the witness.
Cross-exam.
Thank you, Your Honor. Good afternoon, Mr. Ziegler.
Good afternoon.
When you have this case on your desk, you have your case file and your comms log. Those are the two large packets of documents that you provided. Is that fair to say?
The one is called the 1A. That's essentially the document repository, but that includes the comm log.
Understood. And that includes the request for lab examination. Fair?
That's true.
Okay. And any other information that you get about the case, you traditionally get from the customer, the person requesting the testing. Fair?
That's typically the way it works, yes.
Wait, did they provide you, they meaning the Santa Fe Police Department or the prosecutors, any additional specifics about replicating what had occurred in real life when you performed these tests?
No, sir.
What about from the media? Did you learn anything about what happened ostensibly before you performed these tests?
The only thing that I was aware of was that the defendant was stating that they did not pull the trigger. I don't know any of the specifics surrounding that event.
Exactly right. And the reason that you went forward with the testing that ended up destroying the gun wasn't to test for malfunctions, right? It was to verify whether the firearm would go off without him pressing the trigger. True?
So my exam is specific to the firearm, not necessarily the defendant and their actions. So my exam is just to determine what are the capabilities of this firearm. Is it possible for this firearm to discharge without pulling the trigger?
Right. So what you are testing for, though, just to be clear, because this word malfunction keeps getting thrown around, what you're testing for is whether or not the firearm will function without pressing the trigger. Fair?
Specifically for the accidental discharge, yes, that is the goal.
Right. And the reason you have to do that is because the physical exam that you spent some time describing and the little test where you just shoot it 12 times in the lab into the water or whatnot, that doesn't answer that question, does it?
Which question is that exactly?
The question of whether the gun is able to fire without pressing the trigger.
Right. Again, I can only tell you about the results of my testing. So initially it functioned normally, and then the accidental discharge testing, beyond that.
Sure, but you wouldn't have suggested and ultimately performed a test that led to the destruction of the firearm if the physical exam and the functional 12 shots into the water were sufficient to answer that question, would you have?
That's a question that's up to the case agent. So I can provide them the information. I could tell them we have the capability to do this examination, but they're the ones that need to make that determination.
The risks of malfunction, I take it that this expression, you're talking about manufacturing defects, modifications of the weapon, or any other damage that could have occurred inside the weapon because of an accident or a drop. Is that what you mean when you say malfunction?
Oh, it could be a variety of things. It could be age. It could be the firearm hasn't been taken care of, so it's rusted and corroded. It could have been laying in the bottom of a lake for the past year. So I know nothing about the history of this gun. So while I'm doing those initial inspections and I'm doing that initial test firing, when I speak about malfunctions, that's what I'm speaking of.
And so when you look at the gun from the outside, you can't always identify if the gun has something wrong with it, can you?
Not visually, no.
Right. And neither could a random actor on a movie set, right? They would have no way to know by looking at a gun, right?
Sorry.
That you're aware of?
Objection, speculation.
Yeah.
Can anyone
rephrase it? Okay, thank you.
Is it possible to know just by physically looking at a gun whether or not it's capable of malfunctioning?
I would say no.
And even if you've test fired in your laboratory into the little water bucket a bunch of times in that sort of stabilized environment, just because that works and there's not a catastrophic explosion of the gun or something like that, that doesn't mean that it's impossible that there's a malfunction, does it?
That's correct. I can only tell you that it functioned normally during my testing.
And you didn't at that point, before you went into the accidental testing that led to the destruction of the firearm, you didn't disassemble and look at the inside of the gun, did you?
No, at that point, there was no reason for me to do so.
Well, nobody asked you to.
That's correct, but I also did not see anything that would give me cause to do so.
And not only did you not disassemble it, but you obviously didn't disassemble it and take photographs or video of the inside, true?
Prior to the accidental discharge testing?
Right.
That's correct. I did not do that.
And you have disassembled very similar single action revolvers in your career, have you not?
Yes.
You didn't videotape any of the testing that you have discussed here today, correct?
That's correct. We do not videotape our examinations.
Nor did anybody ask you to videotape your examination, true?
Not in this case.
And I take it the way that you're able to recount what you're telling this court is because you took notes and you have worksheets that wrote down what you did and when you did it. Is that fair?
As well as the standard operating procedures, but yes, you are correct.
Well, but there's different points in this case where you weren't sure whether you did the function test and then sought permission from the state's prosecutors to hit the gun with the mallet, or whether you waited to do all of the testing until you got permission. Isn't that fair that you're not sure about the order of this?
No, I disagree with that.
Okay. You're quite confident that you did the visual and functional test before asking for permission before they asked you to do the accidental discharge test. Is that your testimony?
I see your question. No, I can't tell you exactly when I did the function test, if that was before or after that conversation. However, it was before the accidental discharge test.
Right. So I just want to make sure that you are correct. That's what I was getting at. I just want to make sure, that's clear to the court, that despite your worksheets and the best of your memory, you don't actually know at what point you asked, or rather they asked you to perform the accidental discharge test. True? I
do have messages in my comm log for the dates that I had those conversations.
Right, but as you just testified to about a minute ago, you don't know the order of what occurred when, as you sit here, do you?
You specifically asked me if I knew if I function tested it prior to that conversation. So my answer to that is no, but I do know the order that I conducted the examinations in.
Sure. I know that you conducted the functional test prior to the accidental discharge test, because after the accidental discharge test, the gun wouldn't function. Fair?
True.
Now, and the way you do keep track of this, even though you don't obviously know the exact order compared to the phone call with the prosecutors and the detective or any law enforcement interaction you had, is you take notes as you're doing this. Is that fair?
That's correct.
Okay. And you take in the thousands of exams that you've done. You're a note taker. Fair?
I'm not quite sure how to answer that. We have standardized note sheets that have mandatory fields that I have to populate.
And in all of those examinations, the thousands you've done, the almost decade you've had at the lab, have you ever performed this test on a firearm?
In a actual case?
In an actual case.
This is the first time. First and only.
First and only. And the firearm cannot be tested now in the condition that it came to you in. Fair?
Not in the condition that as a result of my testing. That's true.
And it's not just, you've also said, by the way, that this examination and the report were fairly complex. Is that fair?
I'm not sure where you're getting that from.
Well, I'm asking you. We can refresh your memory, but I'm asking you, was the examination report here fairly complex?
You wouldn't see the word complex anywhere in my report.
Not in your report, but what about in an email transmitting your report? Saying that sorry for the delays with the report, this was fairly complex.
I would have to see that message.
Okay. Do you dispute that the examination and the report were fairly complex?
I'm not sure what you're referring to, because that could be speaking to the entirety of the evidence in the case, which was almost 200 items. So yes, I would agree that is a complex case.
The information we've discussed so far, you mentioned on direct examination that there's a manual that comes with this firearm, right?
That's correct.
And this concept of the firearm going off without pressing the trigger is something that's actually discussed in the manual of the firearm. True?
As far as I'm aware, that circumstance is only in that manual with the hammer in one particular setting.
Sure. Thank you for that clarification. But it is true that the manual discusses that this firearm can go off without pulling the trigger. True?
Specifically with the hammer at rest, you're correct.
And you've said this isn't some phenomenon. This is something that's known about the design of these firearms. True?
With the hammer at rest, you're correct.
And well, in the owner's manual also says that a blow to the hammer resulting from a fall dropping of the gun can also cause the gun to discharge. True?
With the hammer at rest, you're correct.
Okay. Or if the hammer slips from the shooter's thumb, right?
I would have to see that line to see what that is referring to.
The manual also says that the person should not even touch the trigger because of this concern and sensitivity of the hammer falling. True?
I would attribute that to general firearm safety.
But it's in this manual. True?
I don't specifically know that.
Objection calls for speculation. And if he's referring to the manual, I'd ask that he give Mr. Ziegler an opportunity to review the manual.
I'm not required to do that in a cross-examination. He said he reviewed the manual. I'm asking if he knows that.
What was the question that she's saying is speculation?
I guess that I just asked him, does the manual say that don't even touch the trigger because the hammer can slip in this firearm? Does the manual say that? Do you know that?
May I answer?
Yes, but you're assuming that he remembers. So
If he doesn't remember, I understand that he may not remember it. It's in his report and it's in the manual. So I'm just asking.
all right, thank you.
I do not know the answer to that.
If the trigger is held in, okay, while you're cocking it, and the hammer falls, that can set off this firearm. Isn't that true?
Depending on how far the hammer is cocked, because you have to keep in mind as you're cocking the hammer, the cylinder starts to rotate. So again, depending on the position of the cylinder, if the hammer falls and does not make contact with the primer, it won't fire. However, you are correct. If I hold the trigger in and I cock the hammer and I let it go, you may fire a cartridge in that method.
And the manual says, and you know from your own experience, that you shouldn't load every single chamber on one of these revolvers because it's at risk. Fair?
And that is referring to the hammer being at rest on a loaded chamber. Yes.
Now, I understand you keep saying that, Mr. Ziegler. Were you prepped on that point before you testified here today?
Objection, Your Honor. Argumentative.
I'm allowed to ask a witness what their preparation was on a topic. Were you prepped on that topic before today, Mr. Ziegler?
No, sir. I keep reiterating that because you appear to be insinuating that this firearm can fire with a hammer in every position, and you're using direct quotes from the owner's manual when those quotes refer to a specific hammer setting.
So you weren't, were you, well, I'm asking you a different question now, which is, were you prepped on the issue of whether or not this gun could fire without pulling the trigger before today?
We certainly had trial prep.
Mechanism that we're describing, which you obviously can describe more artfully than me, is not the same on every modern firearm. Not every modern firearm can go off like what we're describing, true?
That is correct.
And there's actually examples of firearms similar to this firearm, right? And you've said you've disassembled very similar single action revolvers before, that if the sear was defective, the gun could accidentally discharge, true?
That depends on many factors.
Sure. I'm just simply asking you, is it possible that if a sear is defective on one of these firearms, it could accidentally discharge? Is that possible?
It is possible, but there are also safety mechanisms within the firearm, to include this firearm, that would prevent that from happening.
And I'm assuming that there's a caveat on all of these answers, but I'm asking just simply, assuming all other caveats, is it possible that, for example, that if the main spring on this firearm was loose, or there's a loose screw, it could accidentally discharge?
I don't agree with the example you just used.
What about if the notches are worn?
That is a possibility.
And we talked about, or you talked, I guess, on direct about the trigger pull. And just to make sure it's clear, at least in my mind in the courts, the trigger and the hammer, they interlock so that if one is moving, it has an impact on the other. Is that fair to say?
That's correct. The hammer has notches and the trigger sits within those notches. So as the hammer is being cocked, the trigger is moving within those notches.
Okay. And you would agree that the trigger weight on this firearm was on the low end of the range of trigger pulls. Fair? Amongst all firearms, amongst all single action revolvers, whatever denominator you want to use.
As I testified previously, that I feel this range is in line with this type of firearm. Now, if you compare that to a double action firearm or some completely different firearm, then sure, it is lower than what other firearms are.
Well, let's go to that easier example of a double action revolver, which is what many police departments use. Is that fair?
I don't believe many people use revolvers anymore.
Well, is a double action revolver a firearm that would take 10 to 15 pounds of pull force?
Yes, I agree with those numbers.
And isn't it true that the FBI's own website indicates that the standard trigger pull on a single action revolver is 4 to 6 pounds?
I do not know that.
Okay. Well, while we're continuing this exam, we can pull up and see if it won't refresh your memory. But if it was 4 to 6 pounds, that would be double or triple the pull force required on the gun you examined in this case. True?
It would be approximately double, yes.
And the pull, the amount of trigger pull weight required, you don't know the genesis of that. Assume for the sake of this question that the trigger pull weight was lower on this weapon. You don't know how that occurred, right? You don't know whether that was the manufacturing or somebody altering it and customizing it, true?
Can you rephrase that question? I don't quite understand that.
Sure. While I'm doing that, if we can just show Defense Exhibit 2, just to refresh your recollection to the witness. Are you familiar with this?
I have not seen this before.
Okay. Well, maybe because we could, are you familiar with the National Institute of Justice, Advancing Justice Through Science Institute?
Yes.
Okay. And if you look down at trigger pull measurements and you look at the single action revolver, do you see that under typical trigger pulls, it indicates 4 to 6 pounds?
I do see that.
Okay. Does that, do you think that that is a fair number and characterization?
Generally speaking, for single action in general, I would say it's typically between about 2 and 5 pounds.
So you're saying that you disagree with this?
To me, there are many types of single action revolvers. So it is my testimony that this type of revolver I feel is in line with the 2 to 2.5 pound force that I measured.
Did you measure the distance that the trigger has to move?
I did not.
Okay. Do you know the distance that the trigger has to move in this firearm?
No, sir, I do not.
Now, when you do the accidental discharge testing, the goal of that test is to simulate the firearm in a way as if it was bumped or banged into something. Isn't that right?
That's correct.
And if you have the ability, the accidental discharge test should replicate the real world situation as closely as possible, right?
So the accidental discharge test, how we do it at my laboratory, it is lined out in the SOP. And then beyond that, if there is some type of extenuating circumstance that the examiner feels they also need to test, they could then go and do that. However, this is the way that I did it, the method that I use, that's what our SOP dictates.
Well, when you say dictates, it also provides the examiner some discretion as in regards to how that is believed to have occurred in the real world, doesn't it?
Again, this is at my laboratory following my SOP. That line, I believe, follows the accidental discharge testing. So it's written as in if there is any additional testing that the examiner feels that they should do.
Right. So, and you've testified previously that if I had a gun leaning against a door and I'm saying that the door opened and the firearm fell, I would try to replicate that situation. Haven't you said that?
That was in regards to, I was being asked about a drop test.
Well, if you knew that that's how a firearm had gone off, in your discretion, wouldn't you have tried to replicate that test?
That's a conversation that I would have with the case agent.
Okay, but you didn't do that in this case, did you?
I received none of that background information, so no, I did not.
But as you did this test, you had no reason to believe that the prop gun on the movie set had been hit with a hammer, did you? You didn't think that that was the real world, correct?
No, sir. I explained the test.
Right. And you didn't believe that the gun had been dropped and fired after being dropped, did you?
I had no background knowledge.
Right. And there was no reason why, and no reason provided to you by the Santa Fe Police Department why you couldn't do, for example, a push-off test prior to the destructive testing. Nobody gave you a reason why you couldn't do that. True?
That's true. That did not come up in conversation.
And again, just like on your emails to them, your email address, your phone number is there, and you were having communications throughout this case with both the Santa Fe Police Department, and the liaison, Special Agent Cortez, true?
Special Agent Cortez was my main point of contact. However, yes, there were some email chains where the detectives were also included on them.
And when you do conduct the test that ends up leading to the gun breaking, what you're trying to see is if the amount of shock or vibration that's being introduced to the firearm is enough energy on that particular firearm to cause it to fire without touching the trigger. Fair?
That's correct.
And you knew from your experience, the manual, the light trigger pull, you didn't think it was impossible that the test would come back showing that this gun was capable of an accidental discharge without a pull, right? If it was impossible for this to happen, you wouldn't have done a test that jeopardized the weapon, would you have?
I'm not quite sure how to answer that. It's not so much as whether I think it's possible or not. It's just, is there an investigative question, and do I have an examination that can assist in answering that question?
Right. But if on the one hand, right, there's no possible value to this test, and on the other hand, the test was going to lead to a likely damaging of the firearm, you wouldn't have conducted the test, would you have? You wouldn't have recommended the test.
That was not my decision.
And did you consider any other tests, like the push test, before embarking on the test that led to the destruction of the firearm?
Objection asked and answered.
I didn't ask that question before.
Yes, you did. Sustain.
Okay. There were 2 times during your testing that this firearm fired without pulling the trigger, as I understand it. Is that fair?
That's correct.
Okay. So why don't you just explain those 2 times to the court, the 2 times that it fired without you pressing the trigger in any way?
So the first time was when the hammer was at rest on a loaded chamber, and by striking the hammer with a mallet, that provide a sufficient amount of force for the firing pin to detonate that primer. So this is the same issue we keep talking about in the owner's manual. The hammer being at rest on a loaded chamber is inherently dangerous with this type of firearm. So that was an expected result. The second time was when the hammer was in the fully cocked position and I struck it with a mallet. The internal parts fractured, so that hammer fell and fired the cartridge.
After this testing, I think I understand your worksheet to indicate that you continued testing the firearm at the half-cock notch?
Right. The trigger sear, even though it was broken, it was still engaging at the half-cock notch.
You did it again.
So, as I described, I had to test all 6 planes, and I had only tested 5 of those when the breakage of the hammer occurred. So I still felt that if it was possible for me, if it was feasible for me to test that 6th plane, which was the bottom, that I should do that in the condition that I was able to.
And when the Santa Fe Police Department and the prosecutorial team gave you the original directive, they didn't tell you, hey, if something goes wrong as you're testing, if some damage occurs, come back to us, check in with us. They didn't give you any limitation like that. Fair?
I don't recall that occurring, no.
So when there was a little bit of damage done to the firearm, or some damage, if you don't like the phrase little, at that point, you did not do anything other than continue to strike the firearm again with a mallet. Fair?
The damage that you're referring to, those internal parts had already fractured at that point.
Well, do you think that the final mallet strike might have done further damage?
Not necessarily.
Well, I know not necessarily, Mr. Ziegler, but it's possible that it did, is it not?
Objection asked and answered.
I don't believe I asked that question either. Isn't it possible, Mr. Ziegler, that the following 6th hammer strike caused additional damage?
I should answer? Yes, that is possible.
In your when you were striking it with the hammer, you gave some testimony that you could have hit it not straight on, diagonally. Do you remember that testimony you gave on direct?
Yes, just me being a human being, there is the potential that there's some variation there.
But it's fair to say you were trying to hit it straight on in the various planes as indicated in the SOP. Fair?
I was following the SOP. It doesn't necessarily dictate it has to be at exactly 90 degrees for each of those blows. So I followed it to the best of my ability.
But you weren't intentionally striking it diagonally, were you?
Not necessarily, no.
In your amended report, you removed the phrase with a pull of the trigger, with a pull of trigger.
That's correct.
Can you just explain to me why you removed the phrase with a pull of trigger?
Right, so that statement is in regards to the testing I did with the hammer in the quarter and half cock notches. And as I previously spoke about, the design of this firearm allowed me to test the gun with the hammer in those two positions without doing the strikes. So I could test those two positions by actually pulling the trigger, allowing the hammer to fall, and seeing if it was even feasible for the hammer to fire the cartridge in that position. So I actually tested it by pulling the trigger, and in my report, I mistakenly wrote that I tested it without a pull of the trigger. So the end result was the same. It still did not fire, but I felt the description of the process was inaccurate.
And who brought that issue to your attention?
I actually found that issue when I was in preparation for a previous trial.
After you broke the gun, that's when you take it apart for the first time, fair?
Yes.
And there were several parts internally of the gun that were damaged and broken.
That's correct.
And you don't know if the gun had any internal damage before you did the test, correct?
I can't verify that. I can just tell you that it had no effect on the function of it when I received it.
And you don't know if the gun had been modified before you ran that test, correct?
That's true. I do not.
You also noticed that the full cock notch was flatter than the other two notches, fair?
Yes, I did.
It didn't have as much of a claw shape to it, correct?
That is correct.
And you have no way to compare the condition of the prop gun now to the condition before the test, do you?
That's correct. I cannot.
And even after performing the test, you don't know whether it's possible for the gun to have fired without the trigger being pulled, correct?
Can you repeat that?
Sure. You can't say, as you sit here, whether or not it was possible for that gun to have fired without the trigger being pulled.
Right. So I can only testify about my exams. So my results, how it performed in my laboratory.
And you know that outside experts can't examine this firearm in the condition you got it in, correct?
Right. It would be different than the condition that I originally received it.
And you also know, well, let me ask you this. As you looked at the state's Exhibit 5, the broken pieces of the gun, right, you don't even know for sure that you got every single fragment of the broken firearm as you transferred it on, do you?
That is possible. We're talking about very small pieces of metal, very thin pieces of metal. So yes, it's certainly possible they could have fallen out of the gun at the time. They could have fallen out in transport. Again, these are very tiny pieces, so you're correct. It is possible that I was not able to account for everything.
And even under the best of circumstances, you did this in the lab. You can't account when you're doing these tests for every variable that might occur in the real world on a movie set, right?
That's fair, I would say, yes.
How did you inform Detective Hancock of the breaking of the firearm?
I don't specifically recall that.
And from the moment of the destruction of the firearm in 2022, April of 2022, Were you ever asked to do any further tests in 2022, 2023, 2024?
In regards to the firearm,
Yes.
there was never nothing was ever submitted. There was never a formal request. No.
And were you ever asked during that period of time to meet with any other firearm expert in this case, or speak with any other firearm expert in this case?
No, sir.
Even up until today?
I did have a pretrial where another firearms expert was present. I didn't consult with them regarding my examinations.
You just happened to be sitting in the same room during the pretrial?
No, it was virtual.
You just happened to be sitting in the same virtual room during the pretrial?
I'm not sure I understand your question.
Well, you said you weren't consulting with them. What were you doing sitting in the same room with them?
It was preparation for trial, and I believe the prosecution team chose to have individuals there to, I guess, see if what I was saying made sense to other people who had experience with firearms.
And that was the first time they asked to do that in all of 2022, 2023, and 2024 was the first time they asked to do that was this week?
No, sir.
Was this week the first time that you were in a room discussing the facts of this case with another expert witness? Yes or no?
Oh, another expert witness? Yes, that was the only time.
Okay. And so I think I won't ask it again. I think it's clear. And
sorry, I thought you said another examiner. That's where my confusion was.
I apologize if it was my fault. That individual that you met with, who was that? I understand it was virtual. I understand you're not calling it a consultation, but while you and another expert witness on this case were in the same virtual room together, who was that other expert witness?
Right. This was a preparation, a pretrial, and it was Mr. Haig.
Who else was present during that?
Miss Johnson and Miss Morrissey.
Anybody else?
Also, a representative from my laboratory, OGC, Office of General Counsel.
I see. Ever in any of the thousands of guns that you've ever tested, have you ever had a pretrial meeting with another expert and the prosecutors and somebody from the FBI General Counsel's office all present in a meeting? Has that ever happened before?
To the best of my recollection, no.
And what did you all talk about?
It was essentially preparing for this testimony here.
Can you give me a little bit more information?
It's general trial prep, going over my results, how this process is going to unfold. This is the first time I've done a hearing like this.
Do you have any notes from that meeting?
I did not take notes.
Did you speak to anybody else after the meeting about the meeting?
Probably just some coworkers. That would be it.
Your supervisor?
I share a lab suite with my supervisor, so yes, he was aware that the meeting occurred.
And was this the meeting? And you know now from meeting with the state's expert, Lucian Haig, that he believes there to have been no purpose for this test, right? You know that, don't you?
I understand.
I'm sorry, objection. He's asking him to comment on what another witness believes. I think that's improper, and it's also calling for Mr. Ziegler to speculate.
I'm asking if that came, if you know that from having met with him. I'm not the one that put them together 3 days before his testimony for the first time in 3 years.
What was the question?
The question is just that it goes to his state of mind, and it goes to what happened at that meeting 3 days before his testimony and his preparation, that he has been informed that that other expert believes that there was no beneficial purpose to the test that he performed.
No beneficial purpose to the test that Mr. Ziegler performed?
Correct.
All right, I'll allow that question.
Yes, I'm aware that is his opinion.
And you're aware from that meeting that Mr. Haig had issued a report that indicated that he thought that this firearm had been modified in some way outside of the FBI lab. True?
I am aware he's authored a report. I do not know, I haven't read that report, so I don't know the content of that report.
But you understood in that preparatory meeting that that report was an issue that you all needed to discuss. Fair?
I'm aware that he saw marks that he was trying to figure out how to explain. Again, I don't know the content of his report. I don't know what his conclusion was.
Well, you were aware that you were being called in to try to give Mr. Haig more information to deal with the issue of this report. True?
That wasn't necessarily the purpose of that meeting. That is something that occurred as a byproduct of that meeting.
Well, but you didn't need to have that meeting before you testified at Hannah Gutierrez-Reed's trial, did you?
I did not have that meeting.
Right? No prosecutor told you before this trial, we really need to have this meeting with another expert. That's never happened before in your career, right? Nobody said that.
No, but it is customary to have a pretrial meeting with the prosecutor, which this is what that was.
Sure, but it's not only unprecedented, it's not only unusual, but it has never happened in your entire career that at such a pretrial meeting, another expert is present asking questions and bringing up issues about the report that they authored. True?
Objection, Your Honor. That question contains facts, not in evidence, and it assumes speculation. It's asking Mr. Ziegler to speculate on what this other expert believed or what he opined. He's already said he has not read that report.
Overruled.
At the transcript and you looked at the questions, I think it's a natural follow-up question.
Can you repeat your question, please?
I will do my best. I don't have a real-time transcript, so I will do my best. Okay. What I'm asking you is, I understand that it is common to have pretrial preparation with prosecutors. I believe you've already testified that never before in your career have you been brought in to have a pretrial interview where another expert is present asking questions about their report. True?
That's correct.
Okay. And you called it a byproduct of that meeting. One of the topics of importance at this meeting was the report that Mr. Haig issued, in which you understood generally he did not think it was your mallet hammering that caused the modification of the firearm. You knew that, and you discussed that at that meeting, sir. True?
Your question is partially incorrect.
Well, why don't you tell me what's correct, and then you can tell me what's incorrect.
So you posed that question as though I knew that's what the purpose of this meeting was. I did not know he was going to be a participant in this meeting until the meeting occurred. So no, I didn't know that was going to be a topic of conversation.
And once you were at the meeting, it became a topic of conversation, correct?
That is correct.
Okay. And this is the first time withdrawn. And you understood from this conversation that the questions being posed to you were trying to elicit information that helped explain Mr. Haig's report, which was, in sum and substance, that the FBI was not how the firearm got modified, but rather that the gun was modified by somebody other than the FBI. You understood that, right?
I can't testify to Mr. Haig's intent or what his goal was.
Okay, but can you understand? I'm asking what you understood, sir. You understood that part of what occurred at that meeting was trying to understand, right? At that meeting, did you demonstrate how you use the mallet?
He asked me a series of questions to gain an understanding of how I conducted that test.
Including a demonstration of how you use the mallet?
I don't believe I physically held my arm up into the air, but I explained it just as I did here today, that I would liken it to in a similar fashion to hitting a nail with a hammer, something to that effect.
And a nail with a hammer, you're trying to hit straight, right?
I suppose so.
And you know that his report, what he found so unusual and why he thought the gun was modified by something other than your test was because the lines were diagonal. True?
He did mention that.
Okay. And that is when the testimony, that is the first time that anyone posed to you in this entire case for 3 years, well, couldn't you have hit the firearm diagonally, right?
That is the first time I was asked that, yes.
I have no further questions for this witness at this time.
Redirect.
Briefly, Your Honor, thank you. Mr. Ziegler, did the Sheriff's Department initially request the accidental discharge test when they requested testing of this gun?
No, they did not.
Now, as the FBI lab, is it your practice to learn the facts of a case before you conduct any sort of scientific testing?
No, not necessarily. When evidence is submitted, it's typically submitted with a written request. We call that an EC, or an electronic communication. And sometimes that request has background information, sometimes it doesn't. It just depends on the person who is authoring that request. But it's not something I would go and seek out. And most times I would typically prefer to have less information. I'm just asked to examine the evidence, not necessarily take into account external information.
So it's your practice as a scientist to have less information because you want to focus on the evidence. Would that be accurate?
Yes, I believe that's true.
So if this particular gun was able to fire without pulling the trigger, would that have been something that you would have noticed during the exam before the accidental discharge test?
Sure. If it was doing that during my function evaluation, yes, I definitely would have noticed that.
Now, Mr. Spiro asked you questions about why you suggested the accidental discharge test. Were you concerned that this gun fired without a pull of the trigger, and is that why you suggested this test?
It's not something that I detected. It's that I had been made aware that statements were being made in national news that the trigger was not pulled. So I felt I had a duty to inform the case agent, this is a test, we have a capability to conduct this examination, explain the test, explain the caveats, and then leave it up to them to decide if they want to pursue that test or not.
Now, you were asked some questions about disassembling this gun. Why didn't you disassemble the gun before the accidental discharge test?
As I've stated before, there was nothing abnormal or out of the ordinary during my function evaluation and test firing. So if something was occurring, if the hammer was falling, or if otherwise, maybe the cylinder wasn't aligned, if something was occurring to where this gun was not functioning normally, then yes, I would have wanted to take that apart to try to figure out what was causing this. But because nothing like that happened, I had no reason to disassemble it.
Now, do you always, or is it protocol or SOP for the FBI for you to videotape your exams?
No.
And in this case, you were asked about the sequence of the testing. Was the accidental discharge test the last test you conducted?
On the firearm, yes.
Yes, on the firearm, that's what I'm referring to. Okay. Now, you were also asked about the use of the word complex. Was the exam on the firearm, just the firearm, a complex exam?
Not necessarily. I would say it's routine, and again, for each of these exams, I followed my standard operating procedures. So pertaining to just the firearms exam, as far as the function and those sorts of things, those are fairly routine. So no, I wouldn't necessarily consider that to be complex.
Now, you were asked some questions about the manual for this particular revolver. Does the manual say that the gun can fire without a pull of the trigger if the hammer is in the full cock position?
Not that I'm aware of.
Now, you were asked some questions about the trigger pull and whether or not the trigger pull measurements you obtained were in line with this type of single action revolver. Are they in line with this type of firearm?
Yes, in my opinion, they are.
Now, even if this gun, assuming, let's assume for a minute the defense position, even if this gun had been modified when you received it in the lab, would you have had problems or did you have any problems firing it?
I did not have any problems. So even if the hypothesis is true that, let's say hypothetically, this gun was modified in some fashion, it had no effect on its function in the condition that I received it.
Did it have any effect on the full cock hammer holding without a pull of the trigger?
Not in the condition I received it, no.
Now, you were asked some questions about this meeting where Mr. Haig was present. Did you explain to Mr. Haig how you conducted the accidental discharge test?
Yes.
Now, as an expert witness, is it unusual to discuss or talk to other experts?
As I've stated before, it's not something that I've done in the past, so I don't feel I can really answer if it's typical or not.
To your knowledge, other FBI examiners, have they discussed their results with other experts, even within the FBI?
Sure, definitely within the unit. Yeah, there might be things that come up that you may want someone's opinion on, something of that nature.
May I have a moment, Your Honor?
Yes.
I have nothing further. Thank you, Mr. Ziegler.
Thank you.
All right, this witness is excused. We're going to take a 10-minute bathroom break. We'll be back at 3:50. Okay, thank you.
Thank you.
Ms. Gurmandonk, can you hear me? It's my understanding that Mr. Haig is trying to join the meeting and is being denied. He's coming in by his email address. I don't think his name is on whatever the information is that you're receiving. Can you be sure to let him in? Can you see? I see your text. Can you see if that's him? Just ask if he's Luke Haig. Thank you. Appreciate you, Haven. Mr. Haig, can you hear me?
Now I can.
So we're on a bathroom break. So if you could just sit tight, when the judge gets back, we'll get started.
Okay, very good.
It's not on my billing statement from June what date? 16th? Yeah, yeah, I don't know. No, I do not, and it's not on my statement, which goes.
Mr. Haig, can you hear me? You're muted. There you had it. I heard you for a second.
Okay, you can hear me now.
Yes, I can hear you now. The only reason I was trying to get your attention is because someone is unmuted and we can hear a conversation happening in the background. So I just want whoever is unmuted and there's a conversation in the background to know that everyone can hear you. But apparently, Mr. Haig, you were muted, so it must not have been you.
Right. This has taken a long time. I began to think there was some disaster.
Mr. Haig, we're on a break. I don't think we should talk, okay?
All right.
All right, counsel, we're back. Next witness. Well, wait a second. Let's make sure we have the court. Oh, there you are. Okay. All right. Ms. Johnson.
Oh, no, I'm sorry, Your Honor, it's me.
Oh, okay.
I was just waiting for counsel to turn their videos on.
Yes.
Sometimes I can't see everyone. The state.
I don't see, are they on? I don't see them.
I think we're waiting for Mr. Nikas.
All right, thank you. Go ahead. Let me call him and I'll swear him in.
The state calls Lucian Haig.
All right, please raise your right hand. Do you swear affirm under penalty of law that the testimony you'll give in this case will be the truth, the whole truth, and nothing but the truth?
I do.
All right, thank you.
Mr. Haig, for the record, would you please go ahead and state your full name and spell your first and last name?
Lucian Conrad Haig, Lucien Haag.
And what is your occupation, sir?
I'm self-employed with my own forensic consulting firm, Forensic Science Services, in Carefree, Arizona.
What is it that you do?
My specialty has to do with firearms evidence, basic firearms identification.
Can you move up closer to the microphone, sir? I think you need to move up closer to the microphone.
All right. My work involves examining firearms and firearms evidence with a special emphasis on the reconstructive aspects of shootings.
Can you tell us what a criminalist is?
Yes, a criminalist covers the basic work of people in a crime laboratory. Physical scientist who's involved with the testing and analysis of physical evidence, of course, firearms, tool marks, drugs, narcotics, blood stains, trace evidence, and so on. And
Would you describe?
Actually, firearms examination is a subset out of criminalistics.
So would you describe yourself as a criminalist?
Yes, I would.
And how long have you been employed as a criminalist?
For about 57 years now.
And I think you mentioned that you have your own independent consulting firm. Is that correct?
That's true.
And for whom did you work before you started your own independent consulting firm?
I worked for the City of Phoenix in the Police Crime Laboratory, starting there in 1965 as an entry-level criminalist. I became the technical director of the laboratory, so I supervised all the various units, trained others in the various units of the crime laboratory when I elected to leave there in March of 1982. That's when my part-time consulting firm became my full-time employer.
And what were your specific duties there at the City of Phoenix Police Crime Laboratory?
Well, in the early years, through the 60s and 70s, I worked in the various areas of the laboratory: trace evidence, blood alcohol, comparative analysis, firearms unit. But my real interest and passion was the ballistics and firearms unit. So when I was a technical director, I was now training other people in all of these various units. But my main focus, again, had to do with not only basic firearms evidence, but I've said it once before, the reconstructive aspects, things like a distance determination, whether a bullet went through an intermediate target, areas that deal with how did the event occur or not.
Does your experience include firearms examination?
Yes, of course. That's the basic function in the firearms unit. I had specialized training in that subject after I left Cal Berkeley with my chemistry degree, a 2-year program in criminalistics at Cal State Long Beach, taught by the primary firearms examiner for the city of Los Angeles crime lab.
And do you have extensive experience in firearms forensic testing, or rather forensic testing of firearms?
Yes, as I said, I've been doing that for over half a century.
Now, it's my understanding that when you left the Phoenix Crime Lab in 1982, that's when your part-time consulting firm became full-time?
That's correct.
Do you continue to work full-time?
I'm trying to retire. I think I'm flunking retirement, but I've cut way back. I just have 5 or 6 cases, a lot of projects, but not casework. I think that's now limited down to 5 or 6 active cases.
Okay, great. Could you hang on just a second? Have you conducted research in the area of criminalistics?
Yes, I have.
Have you written any articles or given presentations on the subject of firearms evidence and examinations?
Yes, a large number of them over the last almost 50 years. I think they number almost 200 now. Presentations before peer-reviewed groups. Many of those have become publications, and I've ultimately written a textbook on shooting incident reconstruction, co-authored by my younger son, Michael Haig.
Have you conducted seminars on the subject of firearms evidence and examination on more than one occasion?
Yes, many times.
Have you ever taught college-level courses in your field?
Yes, while I was at the city of Phoenix, they allowed me to adjust my work schedule so I could teach a 2-semester course in criminalistics. I did that for about 11 years at 2 community colleges here in the state of Arizona. I was certified in criminalistics as a criminalistics instructor by the state of Arizona.
And did the criminalistics courses include firearms evidence and examinations?
Yes, they did.
Are you a member of any professional associations or societies?
Yes, a number of them, starting closest to home, the California Association of Criminalists. I'm a regular member of that organization and have been for many years. The American Academy of Forensic Sciences covers the United States and a few foreign countries. And of course, the most important one is the Association of Firearm and Tool Mark Examiners, often referred to as AFTE. That is the worldwide organization of people that, almost all of which, with few exceptions, I being one of them, work in government crime laboratories in the firearms unit in this country and as many as 40 other industrialized countries.
In addition to testing and examining firearms, are you also personally familiar with firearms?
Yes, I am. I've been a shooter since childhood. I always had an interest in firearms and how they work. I was a competitive shooter when I was in high school. My high school actually had a rifle team. I competed in shooting events when I moved to Arizona. So yes, I find them interesting, and they're also, of course, the subject of my profession.
Have you frequently been called to testify as an expert in court as a result of the various types of testing you've carried out on firearms and firearms-related evidence?
Many times.
Give us an estimate of how many times.
Well, I don't keep hard statistics, but certainly I'm sure over the last 50 years or so, it's over 1,000 occasions. A lot more when I was in the crime laboratory because, of course, those are criminal cases. So I could easily be in court once or twice a week for one kind of hearing or other or actual trial. It's much more infrequent now. It's more common that it's depositions because much of my work is civil. Has to do with firearm misadventures, accidents, so on.
Have you been called by both the prosecution and the defense?
Yes, I have.
And how did you become involved in this case?
My recollection was a little over a year ago, a phone call from you.
And did you agree to consult and perform some examinations and some testing in this case?
Yes, I did.
So let's start at the beginning. Tell us, if you can kind of walk us through the initial examination that you did, and any testing that you did, and the evidence. And specifically, I know that you took a lot of firearms into evidence. I want to speak with you today specifically regarding the firearm that you understand to have been the firearm that was in Mr. Baldwin's possession.
Yes, well, my work began with, as they all do, getting an understanding of what the issues were in the case. So I was reading a lot of documents, looking at interviews, both audio and transcribed interviews of a number of individuals, including Mr. Baldwin, a man named Seth Kenny, the armorer, other people who were present on the scene, looking at the sheriff's reports of what sort of evidence was impounded. And of course, we all know the physical evidence ultimately went to the FBI laboratory. So I needed to see, and ultimately was provided, the examiner's, not only his reports, but his worksheets and notes. So every investigation, at least my approach, is to learn everything I can about the issues in the case, what people collected, what they state they saw. Not that it's evidence, but it's a starting point to decide what kind of tests and in what order are such tests appropriate. Ultimately, in July of last year, just a couple of days, as I recall, before the 4th of July, I had sent a list of all the things I wanted to see. It was pretty extensive, of items that were impounded, and of course included the what I'll call the evidence Pieta revolver. It's easily distinguishable from all the other prop guns of the same design and caliber because it's got a nickel-plated hammer. The ammunition, now there's basically 3 types of ammunition in this case. They're blanks. These are cartridges that can't hold.
Mr. Haig, I'm going to stop you right there. Go ahead and skip the ammunition because I don't think that's relevant to this motion. So we'll save some time there. So I understand that you examined the ammunition. So specifically with regard to the Pieta, take us through what you did with that gun.
Yes, well, when my son and I received it in a pistol box, evidence type box, it was partially disassembled. There were some broken parts, a severely damaged hammer, a broken trigger, the tip of which is called a sear, and a thing, the company calls it a bolt. It's also known as a cylinder stop latch. So we photographed the gun as found, ultimately replaced the broken parts after they were thoroughly examined and photographed with comparable parts that were functionally, measurably equivalent. And by that I mean a hammer, a trigger with an operating sear, and a cylinder stop latch. As soon as we did that, the gun was functional.
So can you specifically explain to the court exactly what parts of the gun were damaged?
Yes. 3 parts. This is a very simple design. There's a hammer that has to be manually retracted with the thumb. So that's a volitional, purposeful act. Inside of the gun is a portion of the trigger that can't be seen until you disassemble it. And that's called the sear, S-E-A-R. It's the top of the trigger. And finally, the 3rd part that was broken is called a bolt or a cylinder stop latch. This is a small component that, as the cylinder in this revolver rotates into position as you cock the hammer, it locks the cylinder in alignment with the axis of the barrel. So those three parts were broken, and in the case of the trigger, truly broken, snapped, and the hammer, just the full cock step or notch. There are three notches on the hammer. The full cock notch was essentially obliterated.
I want to use a demonstrative aid just so that we can see exactly those parts and how those parts interact. This is not something I'm asking to have admitted into evidence. It's just a demonstrative aid for the court.
I think, no, Carrie, is it among the things that you sent over yesterday or last night or yesterday? Do I have it?
No, it's a demonstrative aid. I sent you exhibits.
Okay. I guess I don't know if I have an objection without seeing it.
Your Honor, it's a video that shows the working of a single action Army revolver, and it's an X-ray version, so it shows you all of the internal parts that you can't see from the outside. That's it.
Carrie, is it Grand Jury 31?
Yes.
Yeah, no objection. You did send it.
Oh, I did. Sorry. Thank you.
Okay, let's take a look.
Let me see if I can get it to present. Can you see that?
I can.
I'm going to jump up here. I'm going to get us to a certain spot that I think might be helpful. Mr. Haig, can you see my cursor?
I don't see your, oh yes, okay, I see it.
Down here on the trigger?
Oh, no, I think I'm looking at my cursor, yes. I don't see your cursor. Oh, now I do. Now I do, it's black. I was looking for a white cursor.
Okay, I apologize. And I'll try to keep it off the black mark. Is that the trigger of the gun there?
Yes.
So I know that you can't see it, but what's this thing that we see here? If you can see my cursor, what's this thing above the hammer that we can see?
Yes, I'm not sure. It looks like it's a part of the mechanism to operate the cylinder stop latch, which if you come up just a little further, there, that's the cylinder stop latch, and those little ears on it were broken.
Are you talking about these little ears right here?
Yes, there are actually two of them with an opening between them, but one of them was broken off on the evidence item.
So when you say that there's two of these little ears, let me stop real quick. Is this big piece of metal here that my cursor's on, is that the hammer?
Yes, it is.
And what's this here?
The firing pin.
So these ears here that you're referring to, does one go on one side of the hammer and one goes on the other side of the hammer?
Yes.
And what's this here?
It looks like a spring, a stop or a spring to limit the movement.
The movement of what?
The cylinder stop latch.
Okay, thank you. I'm going to jump ahead. Can you see that?
Yes, I can.
Can you tell us what we are looking at right here? Do you see my cursor?
Yes. This shows an internal view of the trigger and hammer at the full forward or rest position. The top of that trigger is the sear, and it is not engaged in any notch. It's just resting against the working surface of the hammer. So that hammer is fully forward. If we had a live cartridge in the gun, the firing pin would be resting against the primer of a live cartridge, an unsafe condition.
So when you say that's the position that we're in right now, is this our firing pin right here where my cursor is?
Yes, it is.
And so would that firing pin in this position be resting on a bullet, if there was a bullet in that chamber?
But more correctly, be resting on the primer of a cartridge. The bullet is up in the front end of the cartridge.
Understood. I apologize for my mistaken terminology. So this here, the sear, is that correct?
Yes.
And tell us a little bit about these notches that we can see here on the hammer.
Right. If the hammer were to be retracted just about a quarter of an inch, that sear tip on the trigger would snap into that notch that's right next to it in this view. That's the safety notch, sometimes called the quarter cock notch. Now the hammer and firing pin cannot reach the cartridge. If we go to the next notch, basically just opposite the hole in the pivot hole in the hammer, that's the half cock or loading notch. In that position, the hammer will be halfway back. The cylinder will now be free to rotate, so you can spin the cylinder, whereas before you could not because the stop latch we previously talked about is holding it in place. And finally, this one's hard to see because it's really just a step, but much further down at about the, about the 7 o'clock position, that's the full cock. I like to call it a step, but it's often called a notch. So imagine retracting that hammer, trigger just rotates backward. It's going to rest. The sear is going to rest on that step with the hammer fully cocked. So when the trigger is pulled, the hammer, driven by a spring that we can see over there in the grip, a flat spring, the hammer is driven forward and goes all the way down. And if there's a live round in the chamber, fires the gun.
Okay, so why don't I'm going to go ahead and play this, and let's just walk through it. Is that what you're talking about right there?
Yes, the person has now pulled the hammer back to the full cock position, and it will stay there in a properly operating gun until the trigger is pulled.
So when we're in this position right here, is that the quarter cock position? If those two were engaged, they're not totally engaged in this video?
Yes, they are not engaged, but if the trigger rotated so that the sear, the top part, is deep in that notch, you would be in the quarter cock or so-called safety position. That would be the loading position. And again, the sear would be deeply into that notch. It's truly a notch. And the cylinder would now be capable of being rotated by the hand of the user to rotate it around and either take fired cartridges out or put live cartridges in.
So in this position, that's where the cylinder spins.
I'm sorry, could you ask the question again?
When the hammer is in this position, you can move the cylinder.
Yes, you just take your fingers and rotate it clockwise.
And then I think you indicated that this is our full cock position here, and this is the position when the gun is ready to fire. Is that right?
That's right. And the stop latch is sort of ghosted in this image, has now popped up, and it's in one of those notches you can see on the cylinder, locking it in place so it's aligned with the axis of the barrel.
Okay. Thank you. Let me move to a couple of exhibits. Bear with me. I'm sorry, I'm not as proficient with presenting when I'm on Google Meets. I'm going to show you what's been marked as States Exhibit 35. Do you see this photograph, sir?
Yes, I
Do you
do.
see this? Okay. Can you explain to us what we're looking at here?
The one you had your cursor on just a moment ago, the one that's silver colored with really fine lines on it. No, the one to the right. That's,
Hang on, let me get right here.
nope, move it over. There you go.
Okay.
Yeah, that's the working surface of one of the triggers from one of these guns. That's the way they would look when they come from the manufacturer. Those are finishing marks, very fine grinding marks on the working surface. So you're looking right down on the top of the trigger. The one on the left that looks sort of golden.
Let me stop you right there. Are we looking at the top of the sear?
Yes.
Okay, thank you. And what's the one on the left?
That's the severely damaged working surface of the broken off sear from the evidence revolver.
Can you explain to us in real life, because when we're looking at these photos, can we get an idea of this part right here of the gun, the sear, either one of these parts, how big are they?
I would say about 1/8 of an inch from top to bottom as you view these. Think of it like you're looking down on the tip of a fairly small screwdriver, looking right down on the working surface of a screwdriver. Same idea.
And approximately how wide would this be?
Probably a couple hundredths of an inch, 0.02, 0.03.
Was this photograph taken using any special equipment that shows all of these details?
Yes, that's what's called a stereo zoom microscope, where we could put a camera onto the microscope, focus it, and take the pictures.
So you are actually using a microscope to look at these very fine marks. They are that small.
Yes. And lighting is, you have to bring in lighting from the side to highlight them.
Okay. Pardon me. Mr. Haig, I just want to let's cut to the chase and let's talk briefly about these markings on the very tip of that sear that you described to be about as big as the tip-top surface of a flathead screwdriver. Is that right?
And a small one at that.
Okay. Do those, in your opinion, would markings like that, those microscopic marks that you see on the tip of that very, very small piece of metal, would they affect the functionality of the gun at all?
Well, the ones from the manufacturer, of course, the answer is no. All the triggers that we looked at typically have those very fine, perfectly parallel stria. The evidence one, on the other hand, if it affected it at all, it stands to make what shooters call a creepy trigger. It would grate. But those marks aren't from a trigger job or from the manufacturer. It's damage.
Okay. So let's back up. In terms of all of the things that you've reviewed, did you review videos from the filming of the movie Rust as a part in order to form conclusions in this case?
That was a part of my work, and I think I've at this point viewed more than 20 videos of Mr. Baldwin handling the evidence firearm.
And did you also review all of the FBI report in this case?
Yes, I did.
And based on, let me ask you this, have you come across anything in the videos that you've seen or in the FBI report or any of the transcripts of the testimony that you've reviewed? Have you come across anything that would indicate that this gun malfunctioned?
No, I have not.
So I want to go kind of in chronological order, and I want to go through some of the videos that you've watched of Mr. Baldwin on the set of Rust. Bear with me here, because what happens to these exhibits is when they sit too long, I can no longer access them. Even though they are right in front of me, I can't get them to display. So. Mr. Haig, did you review a series of videos that from the filming of Rust that were recorded on October 16th of 2021?
I believe so. I didn't write the dates down, but if it's something you sent me, I looked at it extensively.
Well, along with those videos, were you provided the dates?
I believe so.
Okay.
Your Honor, I'm going to object to the evidence, the videos as not relevant to this inquiry about the condition of the gun.
Do you want my response?
Yes, please.
Well, the defense's entire position has been the gun wasn't functioning properly. There had to have been something wrong with it. That was the cross-examination of Mr. Ziegler. I am here to show you numerous videos of the gun functioning exactly the way it should. And we have an expert here who's looked at the videos, and he can tell you this is exactly how it's supposed to work.
All right. Were you not provided these, Ms. Clark?
She was.
We were
right.
provided videos, Your Honor. I'm not sure which one she's showing, and it seems like an awful lot of video footage for something that I think is tangentially relevant at best.
All right, overruled. Thank you.
Mr. Haig, can you see that video?
Yes, I can.
Does this look like a video that you've watched at my request?
Yes.
Little closer.
Hey, Mark.
Yeah, well, I'm gonna run in.
No, just.
Yeah?
Just.
When you drop your arm, that means he's 10 feet away. I can't see how close he is, but I want to be almost up by the time he gets here.
No, I'm gonna go into this.
Yeah.
Well, let me show you something. Hold on. Step back to your original mark. So 1,000, 1,000, 3, I'm getting up.
Right.
Then when he drops his arm, Helena get out, he drops his arm, that means Brady's close. I'm gonna start to really get up.
Okay.
Okay.
Here we go, let's try it.
And everyone
Rolling,
doesn't need to be right here, like in the path of the gun. Could you please move? Just want to be over him a little bit so I can see it. Is that a quarter
load?
It's a quarter, yeah.
Now, wait a second, if I'm gonna shoot right, you wanna go on the other side of the camera? I don't wanna shoot toward you. Okay, right here. Okay, I'm gonna shoot close to you. Here we go. Okay, here we go. Ready, and action. Go! That's good. Motherfucker.
Mr. Haig, in this video, can you see Mr. Baldwin firing his gun?
Yes, handling it earlier and then ultimately firing it multiple times.
Given your vast experience with firearms, and to be clear, you also have considerable experience with single action Army revolvers, is that right?
Yes, I do.
Is there anything about what you saw that causes you to feel like the gun was malfunctioning or not working properly?
No, not at all.
In everything that you've read about the case, the hundreds of pages of police reports and transcripts, have you ever seen anyone read anywhere where anyone said this gun wasn't functioning properly?
I think I need to hear the question again. I missed the first part of it. Sorry.
In the documents that you reviewed, police reports, transcripts of witness testimony, did you see anything where anyone claimed that the gun wasn't working properly?
No, I did not.
And that's Hannah Gutierrez's statements, right?
I'm sorry?
Did you review Hannah Gutierrez's statements?
Yes, I'm sorry. Her statement and interview.
Did you review Mr. Baldwin's statements?
Several of them are interviews as well.
Did you review any statements from Mr. Halls, the assistant director?
At some point I did, yes.
Any of those people ever say this gun had a problem or wasn't functioning properly?
No.
Let me see if it will let me switch easily. So I just showed you what was marked as State's Exhibit 8. I'm going to now show you State's Exhibit 9. Can you see that?
I can, yes.
While I understand that it looks at the beginning to be the exact same as the video we just watched, I'm going to play it, okay?
All right.
Take your only mark. And set, ready, and action. Grab the rifle.
Any problems you see there with the way that gun functioned?
No.
I'm going to show you State's Exhibit 10.
Your Honor, I'm just going to object again. It's cumulative. We've been at this for a long time, and these exhibits are all going to show the same thing unless I'm very much mistaken.
Well, but the problem, Judge, is that the entire claim that is the basis of this motion is that the gun was modified prior to it going to the FBI. Now, the only way that that works for the defendant's motion is if any modification, no matter how slight, affected the functionality of the gun. That's what the entire motion's about. So if the defendant wants to stipulate that at no time during the filming of the movie the gun ever malfunctioned, I don't have to show these videos.
Overruled.
Hey, Mark. So, Joe? Yeah. I'm not going to open the door until the first squib hits the door. Right. So, door, squib hits, open door, another squib while it's opening, and then I charge out. Ready? Set.
Stand by, let Joe get to the monitor.
All right, set, video, ready, and action.
Mr. Haig, did you get a better view in State's Exhibit 10 of Mr. Baldwin and his gun?
Yes, actually, each one of them has some value, but this one you can see the hammer being cocked in one of the discharge scenes, letting go of the hammer. It does not fall from the full cock, and then he fires it with a normal trigger pull.
Any functionality problems that you can tell?
No, there are none.
That gun works exactly as it should, is that right?
As intended and as designed by the manufacturer.
State's Exhibit 11.
Hey, Mark. I don't know, I'm opening around. Take Mark. You good? And set. Set. Ready. And action.
Mr. Haig, State's Exhibit 11. Any problems with the functionality of that gun?
No.
State's Exhibit 12.
Hey, Mark. Take Mark. Set. Set. Ready. And action. One more. I forgot the recoil stuff. No, right away. Let's reload. Here we go. So, Helena. Hi.
Mr. Haig, any malfunction you can see in State's Exhibit 12?
No.
Your Honor, we'd stipulate that these can be admissible for the hearing and that these videos will show proper functioning of the firearm in an effort to expedite this for purposes of this hearing.
How many more? Which ones? 13 through what?
This is, Judge, it's going to be 13 through 32.
All right, so the defense is stipulating that 13 through 32 show the functioning, what's the proper terminology? Functioning of the gun, but
It will not show any malfunction of the firearm in those exhibits that the state has submitted for purposes of this hearing, and that Mr. Haig will say that. We will stipulate that Mr. Haig will say that they do not show any malfunction of the firearm.
I don't think that's, Judge, I don't think that's good enough. They need to stipulate, not that he will say that there isn't a malfunction with the firearm, but they need to say that there is not, in fact, a malfunction of the firearm in any of these videos.
Okay, so Your Honor, our stipulation is that he will say that because this is an examination of Mr. Haig, and my understanding is what we're interested in is what he will testify to about these videos. But otherwise, if the state wants to play them all and the court wants to watch them all, we withdraw our.
I don't want to watch them all. I don't want to watch that many more exhibits. So we're not going to fight over this. Is it that he can testify that the gun was functional for 13 and 32?
Okay, he can testify that the gun was functional for 13 and 32. Mr. Haig, have you viewed many, many videos from the filming of the set of Rust?
At least 20.
Have you seen any that cause you any concern about the functionality of the gun?
No.
All right.
No. Okay, I'll move on, Judge.
Mhm.
Let me stop. Mr. Haig, if you recall, just as a point of clarification, two or more of the videos that you reviewed, were they actually recorded on October 21st?
I believe so. They're in the mock church.
And with those videos that were recorded on October 21st, no problem with the functionality of the gun, right?
None that I could see.
Now, sir, when you reviewed the FBI report in this case and you saw that there was accidental discharge testing that took place, did you have any concerns about that testing that we understand ultimately damaged the gun?
Yes, I would say I did.
Tell us about that.
Well, fortunately, it comes at the end of a long list of tests, but it looks like it arose because Mr. Ziegler's understanding was this was an accidental discharge. An accident, as I've defined it in my book, means there's something wrong with the gun, not the user. So he pressed on with their SOP, their protocol, their standard operating procedure, to evaluate an accidental discharge again, meaning there's something wrong with the gun. And that procedure involved some pretty aggressive, very aggressive final testing by delivering an impact to the cocked hammer with a rawhide mallet, multiple blows. And as we probably all know, that caused a failure of the sear and the hammer.
Do you agree, however, that testing was done pursuant to FBI procedures and protocols?
Yes, it was, if there's a suggestion or an indication of an accidental discharge.
And do you agree that experts may disagree in terms of what kind of testing they think is necessary to ascertain an opinion?
You can, or I have found differences in an approach to solving a question in laboratories, including my own.
Now, let me show you what has been marked as I think it's going to be State's Exhibit 37. Is there someone that's unmuted that has background noise? It's not me.
It's quiet here. I do have a ceiling fan.
It's probably me.
Oh, I'm sorry, Judge. Can you see that there? That says State's Exhibit 37.
Yes, I can.
And can you tell us what we're looking at here?
You are looking at a profile view of the severely damaged evidence hammer, where we can see the quarter cock notch, which is in good shape, dirty, but it works. The half cock notch, which is undamaged. But then we go to the pivot point, the hole. There should be a right angle step there, and it's completely obliterated.
Let me ask you, the quarter cock notch here that we're looking at, does that appear to be excessively worn or create any functionality issues with the gun, in your opinion?
No, two parts of your question. It's not going to get wear because you just have the sear resting in that notch. There's no movement there. It just sits down in that notch. And I've already forgotten the second part of your question. It's not damaged. It's just got some debris on it.
So nothing about this quarter cock notch, in your opinion, would cause any functionality difficulties with the gun?
No, did that when I examined it.
Okay. And this notch here, this is the half cock notch. Is that right?
Or loading notch. Two names for the same thing.
Any problems with that?
No. It's undamaged and it worked when I examined it.
And we'll get to that examination here shortly. So this, your concern, what's abnormal about this hammer in this photo is that the full cock notch is missing. Is that right?
Yes, it's just basically rounded off or broken off, sheared off.
Did you form an opinion about how that damage to the full cock notch occurred?
There's only one choice, and that's the impact testing that Mr. Ziegler applied to it at the end of his protocol.
So just to confirm, it is not your opinion that this damage to the full cock notch existed prior to Mr. Ziegler's accidental discharge testing. Is that correct?
That's correct. It did not exist prior to that testing.
I'm going to show you State's Exhibit 38 for comparison. What are we looking at here?
You're looking at a pristine hammer, one of the number of hammers that my son and I had. I think I bought two. We disassembled several out of our own guns. The only problem, it's not a problem with this picture, it's just flipped right left. So now the half cock notch is on the right and the load notch is in the middle, and the full cock notch is by that large hole that you see. And there you can see a complete, perfectly formed and finished full cock step or notch.
Okay. And what you're talking about is this right here.
Yes.
Okay, great. I'm going to show you State's Exhibit 40. Can you tell us what we're looking at here?
Yes, I assembled 3 hammers, undamaged hammers from this make and model of gun, and nearest you is the evidence hammer. So it's a total of 4, but there's the evidence hammer, and it's they're on a rotating pin. You can see what looks like a screw there, so I can line them easily. And if one is so inclined, you can come across and look at the various notches and see that they're all in agreement. They're indistinguishable as far as dimensions and shape and so on, until we get to that full cock step or notch on the evidence hammer, the one that looks silver and is nearest you in this view. Yes, right there. And if you then look at the notches in the 3 hammers next to it, there's no comparison. The evidence notch is effectively gone.
Did you do some additional testing of this gun in August of 2023?
Yes, I did, with the help of my son.
So let me ask you, before we talk specifically about that testing, prior to doing that testing, had you already formed an opinion that the full cock notch of the evidence hammer was damaged by FBI testing and was not damaged prior to testing by the FBI?
Yes.
How are you able to do that?
A number of ways. First of all, you've already asked me about all the videos that show the gun working properly. Then a real detailed examination of the FBI lab report showed multiple ways that this gun was working properly. Photographs of the hammer at full cock, trigger pull test, probably the most important test, because they give a numerical value for what sort of force must be applied to the trigger and a cocked hammer to fire the gun. And that Mr. Ziegler, successfully test fired the gun at least 12 times with live ammunition. So putting all those together, it's clearly working fine until he gets to that point. And by his own description, if the hammer and trigger failed during that test, that's why they repackaged it the way they did. They took it apart. The FBI laboratory, took it apart to see what had failed. They recovered those parts, the hammer you're looking at here, the broken trigger, and the stop latch, and put them in a separate little container inside the pistol box.
So, Mr. Haig, when you did your forensic testing of the gun prior to August, did you have to replace the parts in order to put the gun back together?
Absolutely.
So you replaced those 3 broken parts to put it back together?
That's correct, with equivalent parts that are dimensionally identical, indistinguishable from the broken parts, except for the damage, of course.
And where did you obtain those parts so that you would know that they were the same as came from the manufacturer?
My recollection is the hammer and trigger came out of my son's Pieta Colt 45. We had others to choose from, but that's my present recollection. They were all indistinguishable. I think we used his. The trigger might have been mine, one of the ones I purchased, but they were intercompared with a group of new or parts out of working guns to effectively return the evidence gun to normal condition.
Were they all Pieta parts?
Yes.
Thank you. Now, we've seen numerous videos of the gun working properly when it's in Mr. Baldwin's hands. In August of 2023, at my request, what kind of additional testing did you do?
We put the damaged hammer that you're looking at in this view in the evidence gun, but a new or undamaged trigger and a new undamaged stop latch. So this would isolate the performance of the damaged hammer.
What was the point to that testing?
It was to determine, despite that damage to the full cock step, would the hammer remain at the full cock position when you manually cock the hammer back? That was part 1. If it didn't, would the half cock notch capture the falling hammer, which is what it should do if you have either a slip off or a full cock notch that's so damaged that it won't hold the full cock position. So 2 parts.
And when you conducted that testing, did you make a video?
Yes, we did.
I'm going to show you, I think these are unfortunately mislabeled, but I believe these exhibits should be 33 and 34, and they are in the folder that was provided that's marked Exhibit 33 through 34, August 24th, 2023. I'm going to show you States Exhibit 33. Can you see that?
Yes, I can.
And what are we looking at?
Looking at the evidence revolver, we can tell it by that silver nickel-plated hammer, which differentiates it from all the other prop guns. Of course, the cylinder and cylinder pin have been removed in this particular picture or video.
So this is the original hammer missing. The full cock notch has been put back in the gun, and all the other parts are working fine. Is that right?
Yes, and all the pins, all the springs are the same. So the only thing that's different now is this damaged hammer.
Okay, but we've got a working trigger and we've got a working bolt. Oh, I'm sorry. We don't have the bolt in this video.
I'm not sure.
Okay, let's go ahead and play it.
This is August 24th, 2023, in the property room of the Santa Fe Sheriff's Office. And Mike, you're on to describe what we've done to the evidence gun.
So it's the item 1 revolver, the Pieta. Original parts include all the pins, screws, grip, the original hammer. It has the original hammer spring as well as the original flat spring that operates the trigger. The trigger is a replacement trigger, so the top of the sear is a functioning original piece. And as said, original hammer. It does have a replacement bolt as well. Otherwise, all parts are original.
Okay, and the hammer's in the fully forward position at this. Hammer falls, doesn't hold, but the half cock notch captures it. Let's do it again.
I'll take it all the way down. We can see the quarter cock notch also functions. Half cock functions. And then all the way to full.
And it fails to hold, but is captured at the half cock.
I'll apply some.
So, Mr. Haig, if that hammer had been damaged the way that it is now, would Mr. Baldwin have been able to shoot that gun the way that he did in the videos?
No.
Would Mr. Ziegler have been able to test fire the gun 12 times?
Not in the normal way. No, he would not.
And Your Honor, for time saving, we have State's Exhibit 34 is just kind of a different version of that video, so I don't have to show it as long as it's a part of the record. Unless anyone wants me to show it, I'm happy to. All right.
You don't need to show it for me. What is Ms. Clark saying? Anything?
No need to show it for me.
So we know that the damage to the hammer could not have existed prior to April, I think, of 2022 when the FBI did their accidental discharge testing. Is that correct?
I would agree with that, yes.
And you concluded that the markings on the very tip of that sear did not affect the functionality of the gun. Is that correct?
Right.
Now, in that regard, let me ask you, did you issue a supplemental report August 31st of 2022?
I believe so, yes. Third and final report.
What's that?
Third and final report in this work.
Thank you, sir. And in that report, did you give any kind of an opinion about whether or not those markings that we could see in the photos that we looked at earlier were caused by the accidental discharge testing?
No, at that time I was uncertain, and I gave an open-ended comment that I couldn't explain them given the lack of information I had at that time concerning the history of the gun and the nature of Mr. Ziegler's testing.
Well, specifically, Mr. Haig, did you say in your report that you thought that it was unlikely that those markings were the result of Mr. Ziegler's accidental discharge testing?
I did say that, or write that.
And let me ask you, At the time that you wrote that report, how much information did you have about the manner in which Mr. Ziegler conducted his accidental discharge testing? And specifically, I'm talking about the striking of the hammer with the mallet.
Only very, very limited information that he used a rawhide mallet. Beyond that, I knew nothing at that time.
So recently, did you make a request to speak to Mr. Ziegler?
Yes, I did.
Tell us about the circumstances of that.
Well, this was somewhat troubling because these marks that you've seen earlier, which exhibit it is, are on a diagonal. I hope you can see my hand here, rather than perfectly back to front, which I would have expected if the blow to the hammer that caused the trigger and sear to fail was delivered with a perfectly back to front blow. So I needed to get more details. I assumed, it was obviously wrong, that they had a special fixture, a rig, an apparatus to hold the gun and swing the blow so it came square on. In that interview just a few days ago, I learned that it's free swung, so we don't have any numerical impact values in terms of kinetic energy, and he conceded in a free hand swing there could have been a side component. In other words, instead of 0 back to front coming in at, let's say, 80 or 90, he was unable to clarify that, other than he conceded, yes, we could have a side blow. That could explain my puzzlement, really, about why they're diagonal. I would have expected them at the time to be perfectly back to front. So that clearly offered an explanation. The other is maybe logic or common sense are less and less common, but if the hammer got that badly damaged, something serious had to happen to the sear tip. And really the only choice is the impact testing, despite the fact that the marks, the really egregious marks on that sear, have an angular component.
So after speaking to Mr. Ziegler and getting more information about the manner in which he conducted his accidental discharge testing, did that cause you to change your opinion as to whether or not those markings at the very tip of the sear were caused by the FBI testing?
Yes.
So what's your opinion today?
It's really the only choice, just by
Okay.
simple logic and the history of the gun, and now more information about the impact testing.
Now, hypothetically, let's say that these strange markings at the very tip of the sear, let's say that they weren't caused by the FBI, and that they did exist during the filming of the movie. In your opinion, would they have affected the functionality of the gun at all?
They would not, and they did not.
And is it unusual in your line of work that you would meet and speak to other experts about your opinions?
No, not at all. I just have to do it through the attorneys involved.
Okay. And just to be clear, when you attended that meeting with Mr. Ziegler, that was something that you requested from us, correct?
If anyone wanted to get past why I was so puzzled by the diagonal marks, and clearly, yes, I needed to know more.
Just to follow up, kind of close the loop on a couple of other things. In the testing that you conducted with regard to the spent casing from the set of rust. So when I say the spent casing, I mean the spent casing that appears to be the casing from the fatal bullet. You did testing on that, correct?
Yes.
And based on can you explain the kind of testing that you did?
Yes. Well, first of all, I had Mr. Ziegler's what are called photo micrographs. He took excellent pictures of a comparison. So I could see that the evidence cartridge, before I ever put it under the microscope, had achieved normal operating pressures. In other words, When the gun goes off, the cartridge is slammed back against the breech face. I also test fired cartridges, same caliber, same brand, and did the same comparison. The only difference is I used a 3D scanning device. He used a normal microscope. They're both up to the task. And I too could easily match a test fired cartridge with that particular cartridge case, impounded as being the fatal cartridge.
Were you able to determine from firing pin depth impressions what position the hammer of the gun was in when the fatal bullet was fired?
Yes.
What position was the hammer in?
In my opinion, from my testing and all the test fired cartridges I had from the FBI laboratory, it's a normal hammer fall from a full cock position, as opposed to what might be called a slip off, where someone is trying to lower a hammer, or they've got it at the quarter cock and they miss it and it slips, the hammer falls. The firing pin impressions there, this is by actual testing, will be substantially, visually, measurably different. So it's a normal hammer fall from the full cock position, in my opinion.
Your Honor, in terms of time, do you want us to keep going?
I don't have any other spot for you. How much longer are we going to take?
I don't have that much longer with Mr. Haig. We should be able to wrap it up. I just wanted to check in with you because I think it's 5 o'clock.
It is, but as I said, I don't have any other spots for you. So thank you.
Okay, no problem. Mr. Haig, can you describe the process that one would engage in to remove the firing pin from a Pieta single action army and reinstall that firing pin? Is that easy? Is it complicated? What happens?
No, it's easy. You just need an appropriate punch. It's not going to mar the hole. If you look at the pictures of the hammer, you can see the firing pin, literally a little pivot pin about which it rotates. That's driven out. The firing pin falls out. And now you've got a gun you could take to a trade show and meet their requirements of not having a firing pin. To put it back, again, you align the firing pin with the hole in the hammer, reinsert that pin and just tap it till it's flush on both sides, usually with a brass driver, a gunsmith tool.
Okay. Let me just review my notes real quick. Sorry. And just to correct the record, I think I indicated that the testing that Mr. Haig did in August was in 2022. I just wanted to correct that. It was actually in 2023. I'll pass the witness.
Cross-exam.
Thank you, Your Honor. Good afternoon, Mr. Haig. I want to start back with the your review of the FBI's report and your conclusions regarding the FBI's exam. So you reviewed the FBI's report in July of last year. Is that correct?
Yes.
Okay. And over the course of your review of that and other materials, you determined that the testing the FBI did was completely unnecessary. Is that correct?
No, all the testing they did until we got to the point of the accidental discharge test. There, I felt that was unnecessary if the person, in this case, Mr. Ziegler, knew more about the issues.
Okay, so just to put a finer point on my question, you would agree that the testing that Mr. Ziegler did, the accidental discharge testing, was unnecessary in light of the circumstances of this case?
Yes, I would, and I do.
Okay, and you would not recommend that testing based on the circumstances of this case if you were in Mr. Ziegler's shoes?
I would not have if the firearm had come to my laboratory.
Okay. And your understanding is that Mr. Ziegler did not disassemble or document the internal components of the firearm before he conducted the destructive testing?
That's right, he did not.
Okay. But you and your son did disassemble and photograph parts of multiple firearms in the course of your testing in this case. Is that correct?
I think we disassembled 9 Pietas that were prop guns, and both my son and I have the brother to the evidence gun, same make, model, barrel length, so on. So we have
Okay.
11 examples.
Okay, and you do that because you want to document the condition of those firearms on receipt. Is that correct?
I'd say it was a little more than that, in the sense that here they are, let's have a look. I already know what they look like inside, but it would just be a question someone might raise. Did you ever examine the interior of any of those other guns? I want to be able to say, yes, we looked at them all.
And is that something that you would routinely do in the course of a firearms examination?
You're a little scratchy in the audio. I missed that one. Sorry.
Is that something that you would routinely do, disassembling the firearms and documenting them in your experience as a firearms examiner?
Boy, I'm sorry. I'm still missing it.
Is everyone else having a tough time?
I hear you. But it's
Your
really,
voice is just a little raspy, but why don't you turn the volume up? Maybe that's the problem.
And maybe speak a little slower.
Okay, I think I have it as high as it can go. Can you hear me now?
that's better.
Okay, so my question is, when you undertake to examine a firearm, do you commonly disassemble and document the internal components?
It's going to depend on what the issues are, what the context of the case is. If it's an alleged, and there's a difference, if it's an alleged accidental discharge, that's a gun problem. And yes, if it's an alleged unintentional discharge, the gun may not necessarily need to be disassembled.
Okay, and based on the circumstances of this case, you said you disassembled 9 Pietas as well as 2 additional firearms that you had in your possession?
Yes,
Okay, and how long does it take those guns apart?
that's pretty much a day's work.
For each gun?
About a day's work. My son did most of it. I watched. He's better at it than I am.
Okay. And would you consider it good practice to document those internal components?
I missed part of your question. Would I consider it?
Good practice to
Oh.
document those components?
Again, it's going to depend upon the issues. Certainly in a civil case where the gun manufacturer is a defendant and there's an allegation of a compromised gun, you bet. Everything's going to get photographed and measured.
Okay, and you did it in this case, so you presumably thought it would be a good thing to do in this case?
I think we did photograph all the various parts from the various guns.
You described, we've spoken before, you described to me previously a test called a push-off test. Push-off test?
Oh yes, push-up, sorry.
Okay. And would you agree that, and can you tell me what a push-off test is?
Yes, it's going to be easier to demonstrate. Here's the brother to the evidence gun. There's the full cock position. And you just put pressure with your thumb. Push maybe 2 or 3 pounds of force. And if that full cock notch is damaged, the hammer's going to fall and it's going to be captured, as we've seen in the video, at the half cock notch.
And is it fair to say that a push-off test is not destructive?
Clearly it is not.
Okay. And would that have been a more appropriate test given the circumstances of this case, in your opinion?
It would have been a useful test. And if the hammer held at that point, then we're back to your earlier question. I wouldn't see, if I knew more about the case and was in Mr. Ziegler's position, to go beyond that.
Okay, so just to make sure I'm clear, in your opinion, would it have been appropriate to do a push-off test in this case?
It's certainly appropriate in my laboratory. It's common. It's just part of my worksheet. If, again, there's an allegation of an accidental discharge, a hammer fall without a trigger pull.
Okay. And And is it your understanding Mr. Ziegler did not conduct that test?
That's my understanding.
Okay, and instead he conducted the destructive accidental discharge testing that we've talked about before?
Well, he conducted a test that ultimately became destructive. It wasn't necessarily intended to be.
Understood. You were speaking with Ms. Morrissey before about a test that you and your son performed where you replaced the broken hammer, or you put the broken hammer back into the gun, and you otherwise put in a replacement sear and bolt. Do you remember that?
Yes.
Okay. And I believe you said you did that to isolate the damage to the hammer. Is that correct?
Right, to see if that damaged hammer would even hold the full cock position.
Okay. And my understanding is you did not conduct a test to isolate the damaged trigger. Is that correct?
That's correct.
And would it even be possible to do a test like that at this point?
Well, it's always possible to put the broken trigger and a good hammer back in the gun. I saw no need to do that.
Is it your opinion that that test would be pointless given the current condition of the firearm?
Yes.
Okay. Ms. Morrissey showed you a series of videos earlier, and I understand that you've reviewed more than we reviewed here today. Do you recall that?
I do. And we only looked at a few today.
And have you said you reviewed about 20?
Yes, at least.
Do you know how many days Mr. Baldwin was on set?
No, not at this time. I may have at one time, but I don't today.
And you don't know how many days Mr. Baldwin's gun was fired on set, do you?
I do not.
You haven't seen all of the footage from Rust, have you?
I doubt it.
Okay, you've just seen what's been provided to you by the state, is that correct?
Yes.
And Ms. Morrissey mentioned some video from October 21st, but in the video from October 21st, Mr. Baldwin doesn't fire his gun, does he?
He does not.
I want to talk about this August 31st report. You referred to it as your third and final report. You sent that report to the state on August 31st, 2023, correct?
I believe so. Yes.
Okay. And I'm going to show you what was submitted in the exhibit packet as Exhibit H, but I believe we're just going to be calling it Defendants 3. That's the number we're up to. Mr. Haig, can you see my screen?
Yes, I can see it.
Okay. And my understanding is this is subject to our prior stipulation, but this was again submitted as Exhibit H in the packet to the court. Mr. Haig, do you remember sending this email?
No, I don't. I accept it as mine, of course, but I don't remember it.
Okay, can you tell me about the conditions or what prompted you to send the report on August 31st to the state?
Actually, it's the unhighlighted sentence that I think pretty well explains it. I try to anticipate cross-examination questions, whichever side I'm working for, anticipate what I might be asked. If a person with similar expertise looked at evidence, so I could envision, and apparently did, someone looking at the broken parts, seeing those really egregious damage marks on the sear tip, and wanting to know, what do you think about those? Where do they come from? Why don't we hear any reports about them?
And it looks like you say here, Mike and I agreed that something needed to be memorialized. So was there a conversation between you and Mike about submitting this report?
Yes, I would say so.
And remind me who Mike is, please.
I didn't hear that question.
Is Mike your son?
Yes, I have two. He's my younger son.
And did Mike work? And Mike worked closely with you on your expert reports in this case, correct?
Yes, he did.
And Mike is an expert in his own right, correct?
Yes, he is, clearly.
Okay. And so you and Mike had a conversation about memorializing the odd tool marks on the evidence trigger. Is that correct?
Again, we're both reading the same sentence. I don't remember it, but I still stand by it.
Okay. And so is it fair to say that you volunteered to provide this report to the state?
I'm not sure if I volunteered it or said, shall I prepare a report? I just, frankly, too many things have gone, I've done since then to remember that.
Okay. So other than this email, do you have any recollection of how the third report came about?
Not beyond, I think, what we've discussed both today and in an earlier interview this week.
Okay. This came up because you and Mike had observed odd tool marks on the evidence trigger, correct?
I missed that one again. Sorry, Sarah.
This came up because you and Mike observed odd tool marks, correct?
Oh, yes. We observed them long before that supplemental report was written when we first looked at the parts.
Okay. And I think that was around July 7th of 2023. Is that close?
Yes.
All right. And you authored 2 other reports in this case, correct?
Yes.
One on October 2nd, or August 2nd, that is fairly lengthy.
Yes.
And another one that is somewhat shorter on August 26th.
I believe you're correct. Yes. I don't have them in front of me. Those sound right. Those dates sound right.
And these odd tool marks didn't make it into either of those reports, correct?
That's right. Only the third one.
And you don't have any explanation for why those odd tool marks didn't make it in?
No, I didn't think they were that important. It's clearly damaged effects. But again, from this email, we decided to let's get pictures of them so someone else can see them and realize that we didn't just blow them off or not consider them.
Okay, and so you assumed that this would be provided to the defense, correct?
Of course.
Okay. And do you understand that it wasn't in fact provided to the defense until May of this year after your son's interview?
I became aware there was some sort of a breakdown in communication between your office and Ms. Morrissey.
Can you explain what you mean by a breakdown in communication between my office and Ms. Morrissey?
Really, I'm kind of out of the loop on that. I was assumed that the report went forthwith to the defense. Didn't hear otherwise until there was this issue about belated discovery.
Okay, and you didn't mention this report in your prior interview when you and I spoke in April, correct?
You're going to have to, sorry, it's very scratchy. Still, try it again.
Do you recall speaking to me in April?
I don't.
Okay. Do you recall doing an interview in this case?
I've been involved in several interviews. I do remember you visually, but again, okay. I've done a lot of things since April. I don't dispute we had an interview. I just don't remember much about it.
Okay, so you'd agree with me that if I tell you we had an interview on April 29th in this case?
No, I agree. I'm sure we did.
And in that interview, you didn't tell me about this third report, correct?
I don't even remember the interview.
Would you dispute that you did not tell me about this third report?
No, I would not. Don't have any way of doing that.
Okay, and you said you became aware of a breakdown. How did you become aware of that?
Just vaguely, as I sit here now, that there was a failure to disclose some kind of a snafu, and that was news to me. And this was sometime this spring.
And that was after you testified in Ms. Gutierrez's trial?
One more time?
After Ms. Gutierrez's trial?
I'm sorry, I still can't understand the question.
You learned about this breakdown in communication after you testified in Ms. Gutierrez's trial, the armorer.
Don't know. I really don't remember when it became an issue or of concern.
So you don't know when you learned about this issue with the third report?
Not as I sit here today.
You don't remember if it was in the last month?
I doubt if it was in the last month, but again, I've got lots of other things I'm doing that occupy my thoughts.
You mentioned that you asked for an interview with Mr. Ziegler in connection with this third report. Do you remember that?
I do.
When did you make that request?
I'm not sure.
Did you make that request last year when you sent a list of items to the state that you needed to inform your opinion?
I don't know. I don't remember.
Did you speak? You didn't speak to Mr. Ziegler before Ms. Gutierrez's trial, though, did you?
No, I did not. In fact, most recently is the only time I've ever talked to him.
And so you didn't clarify those questions you had about the third report until this week, did you?
I don't believe so. Again, I'm still confused of where this is going, so I'm not very helpful.
Do you recall you testified in Ms. Gutierrez's case that other than the FBI testing, you didn't see any other modification or damage?
That's my opinion. I don't recall whether testifying to it or not, but that would be my opinion regarding the evidence gun. But the one exception, it has a nickel-plated hammer. Doesn't change the function, but it certainly makes the gun stand out when you watch the videos.
And when you testified at Ms. Gutierrez's trial, you had not yet spoken to Mr. Ziegler, is that correct?
That's true.
Okay, and so at that point in time, those markings were still unexplained, to use the words from your report, correct?
Yes.
Okay. And you never asked to speak to Mr. Ziegler to clarify those markings before you testified at Ms. Gutierrez's trial?
That's right. I did not ask to talk to him before the trial of the armorer. Only more recently, when it became apparent this trial might go forward.
And do you recall telling me on April 29th of this year that the working surface of this sear looked as expected and normal?
I don't even remember the interview of the date you described. I remember seeing you, but beyond that, I don't remember anything from the interview.
If you told me in April that the working surface of the evidence sear looked expected and normal, would that be false?
Rebecca, I'm having trouble hearing the question.
I'm going to represent to you, and I can refresh you if you'd like, that on April 29th, you told me that the working surface of the sear looked as expected and normal.
I don't remember that, and I still haven't heard all of the question. I apologize, but the quality of the audio from you is really hard to hear.
Your Honor, I'm not having any difference in hearing the audio from Ms. Clark that I heard from Ms. Morrissey or anybody else today. And I'd ask to approach the bench if there's a way to approach remotely.
I hear you just fine, by the way.
Louder in person, but I'm doing my best.
I can try to speak lower. That's
I don't think we can approach the bench on this. Why don't you turn your volume up to the max, both of you?
Mine is up as far as it goes.
Yeah, now it's over-modulating. It's loud, but some over-modulating.
We're at the point, Your Honor, where my concern is, of course, that the right to cross-examine the witness is being impeded by this. And between the remote nature of this, the fact that we're at the end of the day, I'm just going to alert the court. The defense is not going to. I understand that the court's time is precious, and I mean that genuinely. But the issues here are just too serious, and it's just too hard. It's just going to be one of those rare times in my career where I think there's something going on that just I can't let lie. And so I'm not going to be. The defense is not going to be resting today. We're going to be seeking to put other evidence before the court, just to alert the court of that.
Well, what do you mean other evidence? Completely. This is an issue of we need to fix the hearing, but other evidence before the court. I mean, I think you've interrupted enough. He's answered questions. You can repeat the questions that he hasn't asked. I'm just curious as to whether this can be corrected. Is there any other place you can go to, Mr. Haig?
No, I'm in a small office joining my home. I can hear Mr. Spiro. That's the way to pronounce it.
Is there any other office that you can go to, Ms. Clark?
I can try to call in from my phone. I will say I have not had this problem with anyone other than Mr. Haig, but I can try to call in from my phone and do the audio that way. Would that be preferable?
Yes, see if it works first of all, and then we can regroup on the questions.
Your Honor, counsel, can you guys hear me now?
All right, it's most Mr. Haig. Is that better?
That was better. See if the question.
All right, so listen to the questions. Go back at any point in time in your cross-examination, Ms. Clark, that you feel that you were not getting sufficient cross-examination because he could not hear or because of whatever other reason. Take your time.
Thank you, Your Honor. Mr. Haig, can you hear me now?
I can hear you. It's a little better. So let's see how it goes.
Okay. I want to go back to when you noticed the damage to the evidence here. And I understand that that was early July, correct?
It would have been the official exams in July of last year.
Okay. And I believe I understood you to explain to Ms. Morrissey that there was egregious damage to the working surface of the sear and that that is what is reflected in your third report. Is that correct?
Yes.
Okay. Do you recall doing an interview with me in April of this year, April 2024?
As I told you, I don't recall it. I don't dispute that we had one, but I just don't recall it.
Okay. And if you and you told me at that interview that the working surface of this sear looked as expected and normal. Do you recall that?
No.
Would that be a true statement?
I believe so, yes.
That the working surface of this sear looked as expected and normal? That's true?
We're back to the same problem. I'm missing a word here and there. Sandy, do you mind if my wife stands here and see if she hears it? Can't do that, eh? Okay. Judge says no, Sandy, go away.
Hold
Your
on,
Honor,
folks.
I don't.
Hold on,
Sorry.
folks. Counsel, tell me if that is what you want to do.
As I've indicated, Your Honor, we're not going to be able, the defense is not going to rest today. So I would ask, and I understand, and I say this genuinely, the court schedule and fitting this in where we are in the lead up to trial, but the issues are just serious, and I'm not going to be able to rest today. So I would ask, even if we don't decide at this exact moment when there could be potentially another hour from the court, but given the hour, given the ability to cross-examine this witness, and given that there's going to be other documents and evidence that we have to put in because of what's going on here today, we're not going to be in a position to rest today.
Can I ask, does the defense have other witnesses that you intend to call?
So I have to meet with my colleagues after this and decide, given what I think is going on here, which is troubling, to put it lightly. So I don't know exactly how this is going to proceed. Having practiced in many, many states, it's very rare that I'm put in a position where reports are hidden, witnesses change their answers in this kind of manner. And I hope the court will take this seriously. We're certainly taking it seriously. And I just cannot be in a position where we don't have a moment to confer and the court looks at me an hour past the end of the day and says, can you just rest? I'm not going to do that. I'm going to ask for more time. And so I'm just being direct with the court on where we are.
Well, that's not really germane to my question. My question is, we showed up to do a hearing today. I understand Mr. Spiro's concerns, but if the court tears a hole in its calendar and resets us, is the defense then going to show up with witnesses that we haven't interviewed?
Let me do this. Your plan, Mr. Spiro, was that you were going to use these three witnesses. And now I don't understand how because he can't remember, you're going to be calling other witnesses. These are the three witnesses for this hearing. I am going to call this hearing again at 2:30 on Monday. And it's going to end at 5:30 no matter what. All right.
Understood.
Now, I will see you back on Google at 2:30 on Monday. Thank you.
Thank you, Your
And
Honor.
Ms. Morrissey, Mr. Haig you have got to hook him up with some way better IT.
Understood.
This cannot happen again, or I will begin to entertain confrontation issues.
Understood.
All right, thank you. We're in recess.
Thank you.
Your Honor.
Glanville beside court would now come to order.
Good afternoon, ladies and gentlemen. Please be seated. All right, Deputy Hudson, all of our jurors present? Okay, all right. Is Mr. Copeland back with us? Yes. Okay. Anything to take up before Mr. Copeland comes out? All right. Oh, yeah. What's my name? All right. We're back on the record in the matter of the state of Georgia versus Khalif Adams et al. In 22 SC 183572. Mr. Stillwell, Mr. Botts, and Mr. Shard, good afternoon. All right, Mr. Williams, Mr. Steele, Mr. Adams, and Mr. Pines, good afternoon. All right, Mr. Kendrick and Mr. Weinstein, good afternoon.
Yes,
all right, Mr. Huey and Mr. Matthews Sr., good afternoon. All right, and Mr. Nichols and Mr. Garner, good afternoon. And Mr. Ryan and Misty Williams, good afternoon. Okay, Ms. Haltwinger, sorry, I apologize. Good afternoon, madam. All right, and then for representatives from the state, Ms. Atkins, Ms. Love, and Ms. Hilton. All right, okay. Mr. Kokomo, good afternoon, sir. All right, Mr. Yusuf, good afternoon, sir. All right, I think I got all the important people, really important people. All right, okay. Where's Ms. Knight?
It's her special day.
Okay, all right. Okay. All right, let's summon our jurors then, okay? All right. Bring Mr. Copeland back in, please.
All rise for the jury.
All right, ladies and gentlemen, please be seated. All right, thank you, Officer Hudson. All right. Ladies and gentlemen, the jury, good afternoon. All right, sorry you had to compete with the vice president in traffic today, so all of you that may have had to come down here today. So without further delay, we're going to go ahead and continue with examination of our current witness. Mr. Copeland, you're still under oath, okay?
Good afternoon. All right. So yesterday,
left off talking about your interview that you did on February 20th, 2015. Going back to the incident in which you, your girlfriend at the time, and your child was being shot at, do you remember seeing any of the individuals who shot at you?
I never saw no one that shot at me at that time.
Do you recall in that interview a period of time where the detective left the room and you were speaking with your girlfriend and you told her that you knew who shot at you?
I never saw nobody. I never saw who shot at me. If I saw who shot at me, I would never told the police who shot at me.
Do you recall in this same February 20th, 2021 interview that when the detective left the room, you said to your girlfriend, "This shit not gonna work. Sit right here and be a damn snitch, so I'm gonna keep going." Do you recall telling your girlfriend that?
I don't recall.
Okay. And then she responded, so, you're right, it'll be effect on the listener.
I'll rule the objection, sir. Overrule, sir.
So what you're saying is, why you acting like you did? And she said, you should have just said, no, I thought you know all of them. And you said to her, I do know who it was. Do you recall telling her that?
I know that I knew the camera. I knew that I was being recorded, so I kind of knew what I was doing.
Okay. And then you said, I saw him. I did when he jumped out the car. I know exactly who I saw.
Nobody never got out of the car, so this clearly proved that I knew what I was doing.
Do you recall telling your girlfriend that?
I don't recall what I told her.
Okay. And this was when the detectives had left the room.
I don't recall if they left the room or if they stayed in.
Do you recall further in the interview when the detectives asked you whether or not any of the people who did this had ever been to your home, you instructed your girlfriend to tell the detectives who had recently been at the house?
I don't recall what I told them.
Do you recall the detective asking anybody you let come over to the house recently that normally ain't been by there? And then you told Deshaun, tell him who been there. Do you recall that?
If I brought anybody to my house, I'm 100% sure they know not to play with me.
Okay. Do you also remember when you and your girlfriend were in the room by yourself, you told your girlfriend it was Tay and them who did this to you?
I don't recall.
Was it Tay that shot at your vehicle?
I don't believe so.
Do you recall in that same interview being concerned about being labeled a snitch?
I don't care about what I'm being labeled as.
Let me ask you this. During this time when your home was when you were being shot at with your daughter and your then girlfriend, how many other family members' homes have been shot at that year?
Objection, causes speculation, and hearsay.
I'll sustain as to speculation. I will overrule as to hearsay from Mr. Steele.
To your knowledge, how many of your family members' homes have been shot up back in 2015 after Nut died?
Objection, relevance.
Overrule, sir.
I can't recall.
Do you know, okay, let me ask you this. Was your brother's home shot at?
No.
Okay. Was your girlfriend's mother's home shot at?
Yes.
Okay. Was your sister's home shot at?
Yes.
Was your grandmother's home shot at?
No.
Did you think you were being retaliated against?
Huh?
When all the shootings were happening at your family members' homes, did you think you were being retaliated against?
I didn't think.
Did you know?
Clearly.
Okay. Why were you being retaliated against?
Because people said I killed Nut.
And do you know who was doing the retaliation?
No.
Do you recall telling detective in the same February 20th interview that it was a whole gang after you?
Anytime the investigator talked to me, I do not recall what I have told them.
So you don't recall telling them that it was a whole gang after you?
I would told them whatever I think that I need to tell them to convince them to stop watching me.
Was there a whole gang after you?
I don't know.
Was the entire IF gang after you?
I seen a few of them, so I can't say that.
Which were the ones that you saw?
I don't know.
Earlier, I asked you about whether you were concerned about being labeled a snitch. Do you recall telling Detective Copeland?
Detective who?
Excuse me, Detective Copeland. Detective Curry.
Now I'm a detective.
Or was it? I made a mistake. Talking about Detective Mr. Copeland. I'm about to ask you a question. Do you recall telling the detective, I know if I tell you what's going on, they're going to be on records and all this here, and you're going to get him locked up, and he's going to get his discovery package. First thing they're going to do is send him to two places, to the street and to prison, and float it all around the city of Atlanta, and then all around prison. But my name's over that. I'm not going that way. No, I'm not going through none of that. Look, they shot at me, my girl, and my baby. Almost shot my face off as we were running. I'm not for sure, but I thought I heard one of the bullets hit the car seat or graze the car seat. Were you concerned about snitching in this interview?
I was concerned trying to get my story together, so I was trying to buy time.
Did you also tell in that same interview, I just know the trouble I'm putting myself in. Just know I don't want to have nothing. I don't want to have nothing, man. I can't go to no job. I can't do none of this shit. I know the street not going to be here forever. All things going on right now. Just waiting on you niggas to catch up and kill me. Again, not wanting to snitch on who did this to you, your child, and your baby.
My only motive was, anytime the police questioned me, was try to figure out how could I get myself out of it. Anytime they asked me any questions, I was trying to, if I couldn't come up with no answer right then and there, I was trying to buy time to think of something to say.
When you met with Mr. Curry, weren't you going there as a victim of an aggravated assault? When you went to go meet with the detective that's in that picture,
okay,
weren't you going to talk with him about being a victim of a crime?
No, I was shooting back. So I thought they were going to try to lock me up for shooting back.
But during the course of that interview, were you made aware that they weren't planning on arresting you because you were protecting yourself?
When they said they would take me downtown, I put my hand behind my back and told him, "You gonna lock me up? Come on, get it out the way now."
And did they ever lock you up?
Cause he wanted the gun. So he gave me 24 hours to get him the gun. When he let me go, I didn't come back with the gun. So they sent the SWAT team to my house to get me.
But when you went the first day, did they ever put handcuffs on you?
Cause they wanted the gun.
Did they ever put handcuffs on you?
You hadn't answered the question.
Did they ever put handcuffs on you?
One of the officers pulled him out and he told him we don't need that.
Okay, so they never put handcuffs on you?
Oral, sir.
Did they ever put handcuffs on you?
I don't think so.
Okay. And when you left the interview, did you leave that interview without any handcuffs on you?
Yeah, I left. I went back to the streets.
So again, when you went in this interview, you were not in trouble.
I was.
Basis. Overruled, sir.
Were you arrested at all on February 20th when you went to go speak to the police about being shot at? Were you ever arrested that day when you went down to tell the police about what happened to you, your child, and your girlfriend?
They locked me up the next day.
I asked you, were you arrested that day?
No, they locked me up the next day.
Were you arrested that day?
Objection, Your Honor. Arguing that it's an asked answer.
Overruled, sir.
Were you arrested that day?
No.
Did you want the police to go and find the people who actually killed Nut so that people would stop retaliating against you?
Yeah.
Do you recall being asked by the detective, you knew one of them. I know you knew one of them. Your face tells the story. Now, out of all the ones, I mean, you might know the other ones, but I know you know one of them because the face tells the story. Because the face tells the story of somebody being close that you trusted. And your response was, it ain't that. The truth is, I wouldn't say that person because I'm not 100% sure, but I know only one person.
What's the base of your objection, sir?
Foundation, predicate.
Okay. All right. Foundation and predicate. I'll sustain the objection. Go ahead and rephrase, madam.
Did you know at least one of the individuals that were shooting at you back in February of 2015?
On my daughter's life, when that car pulled up on me, all I saw was a gun come out the window. They said, I never seen no one face. They was questioning me. They constantly kept telling me, you gonna let dudes shoot at you and your kids and this and that. And I'm telling them, and they won't believe me that I'm telling them, I didn't see nobody's face. I didn't see nobody's face. And then after a while, I got tired of them asking me, so I don't recall if I just went ahead and said, yeah, I seen Tay. I don't know how it came out, but in my heart, and still to this day in my heart, I do not believe Tay had anything to do with me getting shot at.
Okay. Do you recall telling your girlfriend when it was just the two of you, I did when he jumped out the car? I know exactly who I saw.
I don't, at that point, it was so much pressure on me. Yeah, I'm a daughter crying, trying to take her to the hospital. Somebody pull up on me, shooting. I'm trying to figure out what made me have the gun to go to the hospital. It's all type of stuff going through my mind. I don't know. Too much going on. Yeah, I can't, because she keep asking me these questions and.
Mr. Copeland, just take a breath, okay? We do need to take down your testimony, so you do need to speak a little slower, all right? Okay?
All right.
All right.
Are you? Can we continue?
I don't got anything else to say.
About which part? Regarding the gun that you used to shoot back at these individuals, who were you going to give? Which police officer were you going to give the gun to?
Huh?
Which police officer were you going to give the gun to?
Neither.
Okay. Who did you tell them you were going to give the gun to?
Whichever one they were asking for it.
Do you recall them telling you needed to give the gun to Gaither?
I don't recall. I know they said they want that gun as part of the investigation. I knew it was a trick. I told him if he let me go, I go get it and bring it back. He went for it.
And why didn't you get the gun?
Huh?
Why didn't you go and give them the gun?
You know, it helped them lock me up.
At any point in time, did you ever get arrested for shooting back at those individuals?
Thank God.
Do you recall them asking you some more questions about Tay, and you providing them information about where Tay was from, what part of Atlanta he was from?
I don't recall.
Okay. Do you recall the detective asking you, we only know there's a guy by the name of Tay. Where's Tay from? What area he live in? And you told him that he was from Simpson Road area. You recall telling the detective that?
I guess I don't remember what I said to him.
Do you recall?
Because at that point he had put too much pressure on me, and you know what I mean. I'm just thinking because he told me. I remember him saying he want that gun. That's all I remember him kept saying. He want that gun.
And when you say putting pressure, what do you mean?
Same thing you doing to me now. You keep putting pressure on me.
Okay. Was he yelling at you at all during this interview?
I think he kept saying, I'm letting people shoot at me while I got my child, and my loyalty to the streets, my loyalty to my child.
Okay. So was he just trying to get you to tell him who did this to you, your child and your baby?
I stand the questions to form.
Did he ever threaten you to give a name?
Nah, but he kept asking me to make me say a name, and you like how you keep asking me a question. I'm gonna say something to answer you, so you can stop asking me the same question.
Were you concerned about how you were going to survive the attacks on you and your family?
Yes.
And again, were you concerned that because you had already spoken to the police about Nuts' homicide, that people were considering you a snitch, that people thought you were a snitch?
I don't get what you're saying. Can you say that again?
Were you concerned that people already thought that you were a snitch when you did this interview?
What interview?
With the detective after you were shot at? After you were shot at with your girlfriend and your daughter?
No, my only concern was... No.
Do you recall telling the detective in this same February 20th interview, I came and talked down here. Everybody look at me like I'm a snitch now. It's just like I can't get no money. You know, I was just getting money just by doing nothing. It's just like, hey man, I need to borrow this right here. Just hanging around, going to the mall. He paid for everything, but all of them now, they all come out here, they think I'm a snitch.
I always got my own money. When I need money, I know how to go get it.
Would Thug give you money at times?
I'm not a handout type of person.
Would Thug give you money at times?
I never asked Thug for no money.
Would Thug give you money at times?
I can't recall if he gave me money, but I never asked him for no money.
When you said he paid for everything, who were you referencing?
The big money, the ballers.
Okay. Were you concerned that Young Thug had washed his hands of you?
Huh?
Were you concerned because you had been speaking to police that Thug had washed his hands of you?
No, I didn't need Thug.
All right. Do you recall telling the detective in the same interview on February 20th, 2015, he asked you, so basically Young Thug washed his hands of you, and your response, yeah, because I came and talked to the detectives and them folks in the street saying I'm a snitch. I'm a snitch. I'm a snitch. Nobody don't want to hang around me. I called my partners. They don't want to hang around me. It's like, what the hell? What the hell all this come from? What the hell is going on? Do you recall telling the police that?
The police concerned about Thug, I was removing myself from him.
Do you recall at all talking to this detective about what happened that Monday night at Club Crucial with you and Kel, the fight between you and Kel?
I don't recall nothing specific that me and him talk about outside of the shooting with my child. And I barely remember some of this stuff. You talking about some years ago when I don't even know what I did 3-4 days ago. Like,
Do you recall telling your girlfriend, again, when the two of you were alone in the room, no matter which way it go, I'm going to lose anyway if I tell them that Tay did it? You recall having that conversation with your girlfriend?
Did you say it again?
Sure. Do you recall being alone in that same interview room with your girlfriend and you told her, no matter which way it go, I'm going to lose anyway if I tell them that Tay did it?
On my child life, once again, on Izari life, I never seen no one face that was in that car shoot at me. At any time, if they got out the car, to this point, I never knew who shot at me. So when that detective was asking me, I just had to come up with something. I got no reason to lie about it. I didn't see nobody who shot at me. So y'all going back into the interrogation when I'm telling you the truth. I don't know who shot at me. I have told them I didn't know. When they're going to keep asking me, make me know, okay, cool. I'm going to say, I'm done.
Do you recall being hesitant in the February 21st interview, and we're going to get to that interview with Detective Gaither, when she showed you a photographic lineup, and you actually eventually pointed Tay out of a photographic lineup?
Because I know Gaither. I mean, I know Gaither. I know that, I mean, she one of them people that she got it out for me, so I didn't care. I was just trying to get them out for me and trying to convince her. And trying to convince her is very hard to do. So I had to go through with it, even though in my heart, I knew that he didn't shoot at me, or he would have never shot at me. And to be more clear on it, before I went back to jail the last time, I was right around him. So I would never be with nobody that I believe shot at me while I had my child.
Why did you say Tay did it versus anyone else?
First thing came to my mind.
Why was Tay the first person that came to your mind versus anyone else?
Because in the midst of trying to convince the police so they could leave me alone, I just got shot at. Only thing was in my mind was, get back.
Okay, but you had to beef with Kel. Why not say it was Kel?
Because I had to convince them. I gotta make it seem. If I say Kel shot me, they gonna, how you know? How Kel know where you stay at? So I gotta come up with something to make them know. Okay, well, Tay been over here. You know what I mean? So okay, Tay. I don't know. Like,
but
listen, you keep asking me. I told you I don't know who shot at me.
Why would Gaither have it out for you?
That would be speculation, sir.
I sustain the objection.
Well, you said she had it out for you. What makes you think she had it out for you?
I'll let him answer that question. It's posed.
You said she had it out for you. What makes you think she had it out for you?
Because she was trying her best to get me. She was trying to catch me.
Didn't she advise you to leave town? But you're right, it's a contradiction.
Not a contradiction.
Hold on. That come from the interview. Where's that come from? Where's that statement come from?
His interview with her. during the course
You
of
need to reference that. I'll rule the objection.
in your February 21st interview with her, then she asked you to leave town, go somewhere else, Cobb County, Clayton County. Then she told you to lay low so that you wouldn't get killed?
No, she was saying it because she's saying it. My name was, she just said my name kept coming up a lot.
Right, so she did not want you to be harmed. So why would she have it out for you?
I sustain the objection. You can rephrase.
During the course of that interview, was she encouraging you to lay low? Do you recall her doing that?
I think she was, I thought she was faking. So I don't know.
Outside of the interviews, would you talk to Gaither? Would you call Gaither on the phone?
No. The only time I talked to Gaither is when she called, but it was never about nothing in the streets or nothing.
Right, so.
It was, hey, Miss Copeland, your name involved in the shooting. We want you downtown. This only time she called me, hey, Miss Copeland, they say you shot up this person's house. We need you downtown. I don't recall me and her having no conversations about nothing.
When you were locked up, would you have your girlfriend call Detective Gaither for you so you can speak with her?
You heard where I was, right? Where was I? In jail?
So if she had it out for you, why are you trying to call Detective Gaither?
Because I'm trying to, all she got to do is give me a name. I'm going to try to convince her so she can get me out of jail.
But if she has it out for you, why would you trust Detective Gaither?
I don't trust her. I'm trying to play on her.
I want to go back very briefly to the interview that you did, the first interview you did with Detective Gaither, after your car was shot at on the highway. Okay. During that interview, at the time when your car got shot at, did you know about Lucci's mother's home being shot at?
What you mean?
Were you aware that Lucci's mother's home was shot at?
Huh?
When you met with Detective Gaither,
right,
about what happened on the highway, during that time period, were you aware of Lucci's mother's home being shot at?
No.
Do you recall talking to Detective Gaither in that January 28th interview about Lucci's home being shot at?
I can't recall.
During that interview, do you remember telling Detective Gaither and Detective Dennis that Lucci's mama and dad got shot, so Nick called Big Boo's phone, and we was at Big Boo's house? Do you recall telling them that?
I don't recall.
Let me ask you this. Do you recall independently being with Big Boo and Lucci's manager calling his house, calling his phone, trying to give him $20,000 to find out whoever shot up Lucci's mama's house?
I sustain this form. You can rephrase.
Do you recall being at Big Boo's house and someone from Lucci's manager calling Big Boo back in 2015?
I don't recall.
Sure.
I go out.
Hold on. All right, let's bring Mr. Copeland back in, please. All right, so you can continue when ready.
Thank you. So I'll just ask you again. Back in 2015, do you recall being with Big Boo when Lucci's manager called him?
I don't recall.
Do you recall telling Detective Dennis and Gaither in the January 28th interview, Lucci's mama and dad got shot, so Nick called Big Boo's phone. We was at Big Boo's house. And the first thing that nigga said was, hey, Boo, Lucci's mom and dad got shot. Somebody shot up his mama and dad. Somebody's house got shot up. It's $20,000. It's $20,000, man. There's $20,000 on their head, or whatever they said. And you heard that conversation.
I don't recall.
Okay. And once you heard the conversation, that you took the phone from Big Boo and you told the person on the phone, I ain't did nothing. I didn't do that, bro. You know, don't scream my name. I didn't do that. And you kept telling that person that you did not shoot up his mother's house. Do you recall doing that?
I don't recall.
And did you shoot up Lucci's mama's house? You shake your head just so.
No.
Okay. Now, back in 2015, who were the people that you would spend the most time outside of your family? Who were the people that you would spend the most time with?
Huh?
Back in 2015, outside of your family, who were your friends that you spent the most time with?
My friends.
Who?
You want me to name every single person?
Yeah.
I'm not about to name every single person.
Okay. So who are the people that you would spend the most time with?
I can't recall.
Do you recall telling Detective Gaither that you only keep a couple people around you, and it's really just Little D and Shannon? Do you recall telling them that?
Probably so. I can't recall.
Okay. And then you also said sometimes Moonsoon, but he might come around, but not every day.
I don't recall.
And then you said, I really have my, then you also further went to say, I really wouldn't want nobody around me but Little D.
Your Honor. Form of the question is my same objection.
I'll sustain the question. You can rephrase.
Sure. Between Shannon and Little D, who's the person you would have most around you?
Huh?
Between Shannon and Little D, who would you spend more time with?
I don't know.
Do you recall telling Detective Dennis and Gaither that I wouldn't want nobody around but Little D?
I probably said it because I was trying to run the play on them.
Okay.
But I don't remember what I said to them.
Back in 2015.
Anytime they question me, like I said, you keep asking me about what I supposed to told them. Anytime they question me, I just said whatever came to my mind or whatever I could have thought of in a split second. So I don't know what I said to them.
Back in 2015, did you trust Little D?
Say that again?
Back in 2015, did you trust Little D?
No.
Do you recall telling Detective Gaither and Dennis, I really have my trust in him, speaking about Little D?
You said I really had my trust in him?
Yes.
No, man. Go ahead.
And that Little D ain't never going to turn his back on me.
I told you, I trying to tell them whatever they would have went for. Because yeah.
The gun that Little D from Cleveland bought from you from the pawn shop, what kind of gun was it?
I can't recall.
Do you recall it being, as you described, a chopper?
Probably so.
Can you tell the jury what you would describe as a chopper? What type of gun is a chopper?
I can't recall.
You don't know what type of gun a chopper is? Do you not know what type of gun a chopper is?
I don't know what I done told them.
I'm asking you separately. What kind of gun did Little D purchase for you?
A rifle?
Okay. Is a rifle a chopper?
I guess.
Okay. Have you ever had the occasion to give Nut back items that was stolen from him? Back in 2015, before he passed away.
Yeah.
Okay. First, who stole the items?
I didn't.
Do you recall telling me the other day that you did take the items?
Yeah. I said, I don't.
Did you tell me that?
You asked me, did I give it back to him? I gave it back to him.
Okay. My question is, do you know who stole it?
Huh?
Do you know who stole
I told him a friend of mine stole it.
it? Okay. Did you tell me something differently?
I probably did.
Do you remember what you told me?
What did I tell you?
Do you recall what you told me?
I just asked you.
So do you not recall what you told me?
I told you I gave it back to him.
Do you recall telling me that you actually stole those items, but you did give it back to him?
Do you have an objection?
Sir.
Basis.
Prosecutor is the lawyer becoming the witness.
Yeah.
Are you talking about the foundation for the question or the form of the question or what?
Is that the prosecutor testifying as personal knowledge?
Your Honor, I'm asking.
Cross-examination.
Your Honor, I'm asking a question, but I can clarify who all was in the room.
Yeah, why don't we do that? I'll sustain the question as to the current.
Do you recall me with me, investigator Long, and maybe investigator Lancico, and telling us in the room that it was you who stole it, but you did give the items back to him?
I can't recall.
When you gave the items back to him, do you remember where you were? Where did you meet him at?
In my neighborhood.
Okay. And was he with anyone when you met with him to give the items back?
I think so.
Do you remember who he was with?
Oh, I can't say who the people were that were with him.
Do you remember him being with Greedy, his brother?
Probably so. I don't know.
Do you remember just telling the detectives in that January interview he was with Greedy, his brother was there?
I guess. I don't know. I can't recall.
Do you remember what type of car Donovan had? Oh, excuse me, Nut had.
A truck.
Do you remember what kind of truck?
It was just a truck.
Do you remember telling the detectives back in that January interview it was a green Tahoe?
Probably did. I don't know.
Do you remember what the items were that you gave back to him?
Yeah, his driver license, phone, and his necklace.
Describe for the jury, if you remember, what the necklace looked like.
What you mean?
Do you remember what the necklace looked like? Do you remember what the chain looked like?
Yeah, it was a necklace.
Was it a peanut? Do you remember?
Oh, I think so. I think it was a nut. I don't.
If you don't remember, it's okay.
Yeah, I don't know.
All right. We just talked about who you would hang around with from Mechanicsville. Do you recall telling Detective Gaither and Dennis back in 2015 that you're not going to see you hang with anybody besides Shannon and Dee, who was from Mechanicsville?
Shannon ain't from Mechanicsville.
Do you remember?
I don't remember saying it.
Okay. And do you remember also telling the detectives that there's not going to be one time that you and Dee are not together?
I don't recall. But there's not going to be no time that me, Dee, and Shannon is not together. Not just me and Dee.
So the three of you will be together?
When me and Dee together, it's me, Dee, and Shannon.
Okay. Now, we've talked about briefly another interview that you did with Detective Gaither after you were arrested for probation once you, your child, and your child's mother was shot at. Do you remember that? All right. And do you remember meeting with Detective Gaither after you had gotten arrested?
No.
When you met with Detective Gaither once you were arrested, as you discussed, were you upset that they arrested you for failure to comply with community service? I know you're shaking your head. You have to say yes or no for the record. Right. And during the course of that interview, where you asked to tell Detective Gaither about what happened with you, Deshaun, and your daughter?
I don't recall.
Do you recall in that interview also talking to her about Nuts murder?
I can't recall.
And during this interview, do you recall telling her that on the day that Nut was killed, you initially were at home at Deshaun's house?
That's where I was, but I don't recall what I told her.
And that she got a phone call from Little D.
I don't know.
I'll sustain the objection.
We've already talked about where you were on the day that Nut passed away. Do you recall us talking about that over the course of the last few days?
I don't know.
Do you remember us talking about Nut's murder yesterday?
What you mean?
Do you remember me questioning you about where you were when Nut passed away yesterday?
You said you asked me that yesterday?
Yes, sir.
I guess.
Okay. If you don't remember, that's fine. Do you remember or no?
No, you didn't ask me yesterday.
Okay. Do you remember us talking about it since you've been on the stand, though?
Yeah, talking about what?
The day that Nut passed away.
Yeah, that's what it's about, right?
Okay. Cool. You're on permission to approach?
As long as you're showing that to the defense counsel, please.
I'm showing you what's going to mark it says get a 378 Yankee D1. Do you see yourself in that picture? Is that you?
I guess.
Does it look like you?
I guess.
Yes or no? Is that you?
If you say it's me, it's me.
I'm asking you, is it you?
Yeah, I guess. Yes, it's me.
And is that Detective Gaither?
It's like a man.
Do you recognize that to be Detective Gaither?
No, I can't tell I can't tell for real.
Was this? Your Honor, permission to. Condolences. You have permission to approach?
As long as you show that to the defense counsel.
Mr. Coco, I'm showing you a portion of 378 Yankee Delta on here. Does that look, do you see yourself in this video? Yes or no?
Yeah.
All right. Looking at this screen, are you able to tell who that is?
Yeah, that's her.
That's her?
Yeah.
Does it appear to be the same individual in the picture that I have in front of you?
It looked like the same picture.
You're right. This time the state would like to attend the state's exhibit 378 Yankee Delta 1.
Any objection to states 378 Yankee Delta 1? Hearing none, it's admitted and may be published as you see fit.
Thank you. Mr. Kearns, can you enable share? And if you could bring it down, Mr. Edmund. Melt down. And just scroll out. Thanks. Mr. Kova, are you able to see the dates and the time of that interview?
Yeah, right there.
What is the date and time of that interview?
February 21,
Okay. And what year is that?
2015.
Now, during this interview, do you remember anyone else being in the interview room with you? Do you recall if Detective Thorpe was in there with you?
I don't know.
Okay. And during that interview, do you recall talking to Detective Gaither again about what happened between you, Deshaun, and your baby?
I don't know. I don't remember.
Okay. And during that interview, did Detective Gaither also ask you who shot at you? Do you remember Detective Gaither asking you about that?
I don't remember.
Do you remember being concerned in that interview about being labeled a snitch as well?
I don't remember.
Do you recall Detective Gaither trying to encourage you to tell them who did it so she can help you so you don't have to be getting shot at in the streets?
But if I already told them Tay did, why would she be asking me that?
Because you recall this being the first interview with Gaither. You had not met Gaither prior to this interview.
I don't remember what me and Gaither talked about.
Okay.
Or what I said to her.
Do you remember telling her, if I tell you anything, guess what happens? That make it even worse. What makes it worse? Everybody, oh, now I'm a snitch. And remember her asking you how you would snitch when somebody was trying to kill you and your baby. How was that snitching?
Okay. If there was the truth, why would I wait till later or at any point and say anything to the police? It's self-explanatory.
What is self-explanatory?
The whole thing. You seen here tonight what I told to the investigator, and I'm so concerned about being labeled a snitch. So why would I tell them the truth to anything if they trying to say I'm concerned about being labeled a snitch? So if I'm gonna tell them something that sooner or later gonna get out in the streets, why would I be concerned about being labeled a snitch? It doesn't make sense.
Do you recall being reluctant to tell the detectives who it was?
No, I was trying to buy time to come up with something to tell them so they can get up off me or let me out of jail.
Okay. The interview that you had on February 20th, what time was your interview on February 20th, 2015? What time did that
This paper?
Yeah, what time did that say?
What about?
What time is it on here?
1:41
What, AM or PM?
a.m.
And then what time did you meet with Detective Gaither?
Well, look like I got on a Rice Street outfit, so I didn't meet with her. And it say 3:53.
On February 21st?
Yeah,
Is that PM?
p.m.
So did you meet with Detective Gaither the next day after you met with the first investigator?
Yeah.
All right.
That's what they say.
So if you just wanted to make something up, didn't you have time to make up a new name if it wasn't Tay?
See, with Gaten, it's harder to convince her. I got to, whatever I tell her, I got to stick with it.
Wouldn't you want to tell Gaither the truth if you were trying to get out of jail? If you were trying to get out of jail, wouldn't you tell her the truth?
But if she asks me about something that I don't know and I'm trying to get out of jail, I gotta act like I know.
Did you ever try just telling the truth to get out of jail?
Have I? Probably. I don't know what I don't told her, so I can't remember what I told her, so I don't.
How bad did you want to get out of jail?
I want to get out of jail.
So wouldn't you want to tell the truth to get out of jail versus lying?
Objection asked and answered.
I'll rule the objection.
Wouldn't you want to tell the truth to get out of jail?
But if they ask me who shot at me, and I didn't see nobody shoot at me, and they constantly thinking that I seen somebody shoot at me, and I keep telling them I didn't see nobody shoot at me, they don't want to believe me, so what I got to do then? And if I feel like this is the only reason I'm going to jail, I got to stick to what I don't tell her.
So why tell your girlfriend that when no police are in the room?
I don't know.
Why tell your girlfriend that?
I don't know. I don't recall me sitting there just telling her that. I don't even understand how his name even came about from the start. I just know once I heard Tay, that's why I just stuck with Tay. I don't know if I brought it up. Which I doubt I brought it up because I didn't have no reason to bring your name up.
How would the police know who Tay was?
I don't know.
How would the police know if Tay was even in your neighborhood at the time?
I don't know.
So why would the police bring up Tay?
Then I said, I don't know.
I sustain the objection.
Do you recall providing Detective Gaither a picture of Tay before ever even getting into the interview room?
No.
Do you recall during the interview when you told her it was Tay, You told her, I gave you a picture of him.
I don't recall.
And do you recall her pulling up the picture and showing you the picture in the interview on her phone?
I recall her showing me a picture of him.
And do you recall not really wanting to point him out on there?
Because I knew at that point what she was doing. They was forcing me to say it was him who shot me. Because I like I keep telling you now, and to this day, I still feel as in they did that. Like I never seen him shoot at me. Even when they called me, tried to get me to come to trial on it, I told them I'm not coming to trial because I never saw who shot at us. And they said, well, Mr. Cope, all right, y'all can call me. I didn't see who shot at me.
Were you concerned about being labeled a snitch because of what was happening to your cousin?
My only concern was not being able to protect my family.
Do you recall telling Detective Gaither that you were concerned because your cousin was being tortured because he was labeled a snitch?
My only concern was being in jail and not able to protect my family.
Okay. Do you recall telling Detective Gaither, in referencing your cousin, well, he's getting tortured. Everywhere he goes, he's a fucking rat. Don't nobody want him around. This and that, this and that. And then he turned right around, and I'm in the same damn shoes he's in. But I won't. I don't know if he did whatever he had going on, but you didn't want to be labeled a snitch.
This is the police talking to me, and they're not trying to hear what I'm saying. They're trying to force me to say that somebody shot at me that I did not see shoot at me. I'm trying everything in my power to not lie on this man. I'm not afraid to protect nobody that shot at me and my child.
Okay. Did you ever give Gaither the gun that you used in the to shoot back at those individuals who shot at you and your child mother?
Nope.
Why not?
Cause you're gonna use it against me.
Who did you get the gun from?
What you mean? Who I got it from?
Who did you get the gun?
I stand the objection.
Do you recall being shown a photographic lineup with Tay inside of the photographic lineup?
Say that again.
In this interview, do you recall being shown a photographic lineup?
I think so.
Okay. And do you recall not wanting to sign the photographic lineup?
Right. I do remember.
Okay. Why didn't you want to sign the photographic lineup?
Because in my heart and from facts, I didn't see who shot at me, and they constantly kept trying to say, they kept pushing me to say, to make me think that I saw somebody I know I didn't see.
Okay. All right, I want to kind of switch gears. Do you know someone by the name of Trivia?
Who?
Trivia.
Who is it?
Do you know someone by the name of Trivia? Do you know who Moontunk's girlfriend was back in 2015?
No, I don't remember who his girlfriend is.
Okay. Do you know someone by the name of Aunt Trivia?